witnesses today, under House Rule 4, Section 13, House committees are subject to the same rules of decorum that govern House proceedings. Under those rules, the chair is responsible for preserving order and decorum during committee meetings, and the chair may ask the sergeant-at-arms to assist in preserving order and decorum. Outbursts or vocal displays of support or opposition from visitors in the audience are prohibited, and the chair may order the sergeant-at-arms to clear the audience if there is disturbance that disrupts the committee's meetings. Signs, placards, or other objects of similar nature are prohibited. Food and drink are prohibited in the hearing room, and members of the committee and witnesses must confine their remarks to the matter being considered by the committee. To our guests in the audience that are trying to find a place to sit, we do have 2 overflow rooms located in room E1.026, which is directly across the hallway from us, and E2.026, which is directly downstairs from us. Before we begin today's hearing, I want to take a moment to reflect on the flooding tragedy that has been occurring in Central Texas. So far, 131 lives have been taken. Of those, at least 36 precious children are gone. Our hearts break for the families of the victims, and our prayers are with you. Rest assured, the Texas legislature will pour every ounce of our effort into finding ways to prevent and mitigate this loss of life from happening again in the special session that starts next week. I want to thank Governor Abbott, Speaker Burrows, and Lieutenant Governor Patrick for taking quick action and showing unified leadership towards accomplishing this shared goal. Now, I'd like to ask you to join me in a moment of silence as we pray for the families and loved ones of those whose lives were lost, and for the many Texans who lost so much over the last couple of weeks. Thank you. I want to thank everyone for taking the time to participate in today's hearing on high-capacity groundwater wells in Anderson, Henderson, and Houston counties. Whether you're a member of the legislature, an invited witness, or a concerned member of the public, your presence demonstrates the seriousness of the subject we are about to discuss and the statewide implications it has. I've called the roll of the members of the Texas House Natural Resources Committee, but I'm joined on the dais by many members who are not on this committee. If you're a state representative but not on this committee, please raise your hand. If you're a senator, please raise your hand. I want to especially thank my counterpart in the Senate, Senator Charles Perry of Lubbock, who chairs the Senate Committee on Water, Agriculture, and Rural Affairs. Mr. Chairman, thank you for joining us today. It is abnormal to have a hearing with this many members attending who don't sit on the committee, and it's even more rare to have members of both chambers attending a hearing of a committee that isn't in a joint committee. I think that should demonstrate the level of interest this topic has garnered and the general concern of the state of Texas. Water is finite. Water is precious. Without it, we cease to exist. Everyone here recognizes that there are certain areas of our state with more groundwater than others. We all represent different parts of Texas, and the needs of our districts vary greatly. But there are certain commonalities that allow us to join together regardless of those differences and regardless of party. One of those commonalities is fairness. When something is objectively unfair or unjust, body rally to the aid of those who are being disenfranchised. Today's hearing is about 2 separate but realistically same entities applying for water well drilling permits in 2 different locations in Henderson County and Anderson and Houston counties, with the stated intent to collectively produce and export over 54,000 acre-feet of groundwater per year. Texas has recognized the rule of capture since 1904, with the only remedy being for neighboring landowners being to drill a counterwell. However, in 2025, when land is owned by large corporations with unlimited funds, it leaves everyone else at a severe disadvantage to exercise this counter remedy. When the rule of capture was adopted over 120 years ago, they didn't have three-phase electricity powering 400 horsepower motors running 24 hours a day, 7 days a week. They had windmills. I believe it's time to modernize the rule of capture while still protecting groundwater as a precious property right. But let me be clear, no one is arguing that a landowner should not be able to use his or her property from the sky above to the depths below. But when that use damages your neighbor, that is where limitations should come in. Landowners put up fences to protect their rights, whether you're a large ranch or a homeowner on a lot in the city. Statutory fences to protect property rights are what's needed. My hope is that through this hearing today, we'll begin to understand the disparity that exists and identify the legislative solutions that are needed to ensure that individuals, communities, and regions aren't put at risk for the benefit of one corporation to profit from this most precious natural resource. Texas is a state of great innovation, and as you will hear in today's testimony, exporting and transporting groundwater is not the only solution to provide the water needs of water-poor areas in the state. With that, members, I'd like to open it up to anyone else who would like to make any opening comments before we proceed to testimony. The chair recognizes Representative Ashby.
Thank you, Mr. Chairman. Is this on? Yeah. Thank you, Mr. Chairman. And I was proud to stand with you here a few weeks ago in Jacksonville when you announced that you were going to be calling this hearing. And I appreciate my colleagues for being here to listen to this serious issue. And I jotted down a few notes this morning because I tend to chase a rabbit down a trail sometimes, and I wanted to stay on task in terms of just making a few opening comments and really to give you a little bit of breadth as to what we're talking about here today. But like you, Mr. Chairman, I'm sitting here today not just as a committee member and a legislator, but as a lifelong resident of East Texas, someone who has been blessed to raise my family on the land that has supported so many generations of Texans before. And like so many of our neighbors and fellow Texans across the state, I also understand that water isn't just a resource, it's a way of life. It sustains our farms, our economy, our families, and importantly, our future. Today, we're going to discuss one of the most alarming and aggressive groundwater production proposals in Texas history. Two entities, Redtown Ranch and Pine Bliss, both are controlled by an out-of-region private investment firm, have filed permit applications to drill 43 wells across Anderson and Henderson counties, which Chairman Harris represents. Their stated goal is to extract nearly 49,000 acre-feet of groundwater every year from the Carrizo, Wilcox, and the Queen City aquifers. That's more than 15 billion gallons a year, and importantly, members, nearly 98% of the modeled sustainable groundwater production in these areas. This project isn't for the benefit of East Texans. It's not for our cities, it's not for our schools, our industries, or our landowners. Let me be clear. This project sets a dangerous precedent. The impact on water availability in Anderson and Henderson counties would be severe, with Henderson County projected to face a 5,000 acre-foot annual shortfall if these projects are allowed to move forward. It threatens the long-term viability of our important agriculture and manufacturing industries and really the basic needs, water needs, of hundreds of thousands of Texans that are blessed to call this region home. What's more, the permit applications are riddled with vague statements, missing technical analysis, and ambiguous references to, quote, beneficial use. There's no credible modeling on aquifer drawdown, no specifics on export destinations, and no plan to mitigate the damage to surrounding wells or impacted landowners. In my opinion, that is blatantly unacceptable. Additionally, the groundwater supply in Houston County, which I represent, is in danger. Redtown Ranch has made their plans to install 15 high-capacity wells in Houston County, and since no groundwater conservation district exists in Houston County, Redtown Ranch can begin to capture egregious amounts of groundwater in the not-too-distant future without any regulation. This committee has long stood for the principle that local control and responsible groundwater stewardship go hand in hand. I respectfully urge my colleagues to take a hard look at the implications of this proposed project, not just for East Texas, but for every region across this state. If this permit is allowed to proceed, in my view, it will set a dangerous precedent and jeopardize the future prosperity of the East Texas region. Mr. Chairman, thank you for allowing me the opportunity to make a few opening comments, and I look forward to the testimony before us today.
Thank you, Representative Ashby. Members, anyone else who would like to make any opening comments? All right, if not, we'll proceed. You do? I would. All right. The chair recognizes Representative Bell of Montgomery.
Thank you, Mr. Chairman. I'll be brief and simply echo that water is the only commodity that we have that we can't live without. Whether we're talking about economics or not, that aside, literally cannot live without water. And while I understand the need of the respective regions and the need to have a plan as a state because of the impact not having a plan would have to each and every one of us, it is essential that as we undertake this endeavor, we recognize the certainty that we've got to maintain the water in the region necessary for the people in the region to be viable and for their economy to be viable. And we cannot compromise one region for the sake of another. And I'll just leave it at that, Mr. Chairman. Thank you.
Thank you, Representative Bell. The chair calls Kim Nygren, Adam Foster, Jessica Pena, and John Dupnick. Which one? I called 4 and 5 showed up, so who is the extra?
Todd Gallagher with TCEQ. I'm here with Ms. Nygren to assist, but I can.
With Ms. Nygren. Okay, I was going to call you after I get done with the Water Development Board and this panel right here, if that's okay, unless y'all have joint testimony.
I don't have specific testimony. Ms. Nygren does. I was just here to assist her with questions.
Okay, great. Then why don't you let the gentleman behind you sit, and if you're needed for questions, I'll pull you back up if that's okay. Thank you. All right, thank you guys for being here today. If you would, state your name, who you represent for the record, and then we will begin with Texas Association of Groundwater Districts, then Ms. Sledge. I'm sorry, I didn't call Ms. Sledge yet. Then the Texas Water Development Board, and so on. So please proceed.
This is on. Okay. Chairman Harris, members of the committee, thank you for the opportunity to come and talk today a little bit about groundwater conservation districts. My name is Adam Foster. I'm the Executive Director of Texas Alliance of Groundwater Districts, otherwise known as TAG. TAG is a membership organization representing 91 of the 98 groundwater districts around the state. We also have about 45 associate members that are made up of groundwater professionals, lawyers, hydrogeologists, and other people in the field. Our mission is to promote and support sound management of groundwater based on local conditions and good science. There are currently 98 groundwater conservation districts in Texas, and I've included in a handout a map of the 98. The first, High Plains, was established in the 1950s in response to drought, and the most recent was Southwestern Travis County GCD, which was approved by the voters in 2019. Together, GCDs now cover 175 of Texas's 254 counties and overlie approximately 85% of the major and minor aquifers. You'll notice in this map, I've One of the handouts shows the creations of the districts throughout the years and some important legislation. And you'll see after SB 1 and SB 2 in the late 1990s and early 2000s, you saw a large number of GCDs created in response to those. Also want to note, again, that any areas in the white, there is no groundwater management in those areas, and the rural capture applies. GCDs can be created in 3 ways: by legislation, by the TCEQ, through a priority groundwater management area process, where the TCEQ will identify an area that needs essentially groundwater management, and then they'll make a recommendation for the creation of a GCD. And then lastly, by landowner petition. All 3 generally need confirmation or approval by local voters in a confirmation election. GCDs are specifically designed to allow for local control of the state's groundwater resources. They are political subdivisions of the state, granted with specific authority to manage and protect groundwater. State law makes clear they are the state's preferred method of groundwater management to protect private property rights and balance the conservation and development of groundwater to meet the needs of the state. Districts are funded locally, typically through property taxes or groundwater protection fees, and governed by locally elected or county-appointed boards. I've also included some information in one of the handouts on the breakdown of funding, governance, and composition. This means the people using and relying on the groundwater are also the ones directly supporting its management. Districts vary widely in size, staffing, and resources. Some serve large multi-county areas and manage multiple aquifers. Others may consist of just one county with a single board member. There's even a couple of county or districts that only have part-time employees. But regardless of their size, all GCDs share the same statutory mission: to conserve, preserve, protect, recharge, and prevent waste of groundwater while considering the groundwater needs of the state and its citizens. So what do districts actually do? They collect water level data, water quality data, and use data. They conduct research on the aquifers they manage, and they do this to better understand the local conditions to help them make informed management decisions. And we applaud Rep. Harris for his work in this past session on allowing districts some funding for their groundwater science and research needs. They also participate in the regional joint planning process, which I'm sure you'll hear more about today. They develop and implement detailed management plans, and note that the districts are required to use the best available data in their management plans, and those must be approved by the Texas Water Development Board as a level of oversight. And then they adopt and enforce rules to achieve those plans. Texas is divided into 16 groundwater management areas, or GMAs. Every 5 years, the GCDs in each GMA work together to adopt desired future conditions for the aquifers they share. These DFCs are long-term quantitative goals that describe what conditions the aquifer should be in 50 years from now. Typically, you see DFCs a certain footage of drawdown, but they can also be tied to spring flow. Several districts in the Hill Country area have their DFC tied to spring flow from certain springs, or overall aquifer storage. The Texas Water Development Board then uses these DFCs and the groundwater models to calculate the modeled available groundwater, or MAG. The MAG is the amount of groundwater that can be pumped each year on average over the next 50 years while still achieving the DFC. It functions like a long-term water budget. From there, GCDs implement those goals locally through management plans and enforceable rules, which may include well registration and construction standards, spacing requirements to prevent interference between wells, reporting requirements for groundwater use, and permitting systems and groundwater allocation. And then finally, annual production limits. The MAG is also used in the regional water planning process to determine future water supplies. It's also important to note that GCDs are required by statute to exempt certain types of wells from permitting. These exemptions include domestic and livestock wells, temporary wells used in oil and gas drilling, and certain wells related to mining if they meet specific criteria. Groundwater districts play an incredibly important role in safeguarding Texas's future. Their work oftentimes requires balancing competing interests, those of protecting property rights and managing groundwater for the long-term benefit of all Texans. These are not easy decisions, but GCDs are uniquely positioned to make them because they are the deep understanding of local aquifer conditions and their accountability to the communities that they serve. Lastly, I do want to mention a resource that may be of use to members of this committee and the public that's listening in. TAG has developed and maintained a GCD index on our website, and on that site you can get information about any district in the state. This includes contact information, enabling legislation, copies of their management plans if you're interested on how they're managing their local resources, funding mechanisms, and some additional information. It's publicly accessible and updated quite frequently. So thank you again for allowing me to come speak, and I'm happy to answer any questions about GCDs or elaborate on anything that I brought up today.
Thank you. Members, any questions? Representative Berry.
Thank you for your for coming out today. I appreciate that. I guess my question revolves around you talked about MAG and you talked about future conditions. Do we have anything that would lead us in the direction of recharge rate on aquifers? Any data associated with that?
Yes, there are many districts collect that type of research or that data. The Texas Water Development Board also has conducted studies on recharge. There are at least one district that I know of that has an active managed aquifer recharge project. And so they do have the ability to do that. And I think with some additional funding mechanisms that came available during this past session, we may see additional districts try to take on those type of projects or assist in those type of projects.
So what kind of methodology is used when trying to determine future desired future conditions if the recharge of that aquifer is not contemplated?
Well, that's one of the things that they take into consideration when coming up with the DFC is recharge rates.
Okay, thank you.
Representative Zwiener.
Thank you so much, Chairman. Thank you for being here today. So y'all play an important regulatory role in terms of water permits, correct?
Correct.
Could you walk me through what a groundwater district's process would look like if they received word that someone was considering doing an export well in their territory?
Yeah, I mean, they would have to have a meeting, right? A meeting of the board, and then they would be able to, or anybody from the public or an affected person would be able to contest that permit application. And then depending on what the board decides, they can handle the contested case in the district, or they can, I guess, farm it out or contract out with the State Office of Administrative Hearing.
What type of resources does a groundwater district have to expend to consider one of these permits and potentially go through a contested case?
I mean, it's quite a lot of money to pay for hydrogeologists to look at the impacts from the proposed project, so.
And then in addition, legal fees too, if they do in a
Correct.
contested case?
Yeah, and if it goes to SOA, then my understanding it's the applicant's responsibility to pay for the contested case hearing.
But it's still the groundwater district expending a lot of resources.
Oh, absolutely, yes.
Now, what if someone's trying to put a well where there isn't a groundwater district covering that area? Is there anybody over y'all that would have regulatory authority over them?
Nope.
Okay, so absolutely nobody
Rule
has.
of capture applies in the white areas.
Okay, thank you.
Members, any other questions? All right, let's proceed to, I may come back to you, Mr. Foster, after this panel. Let's proceed to the Texas Water Development Board, in whatever order y'all choose.
Chairman Harris, thank you for the opportunity to address the committee and members of the committee, the expanded committee. We're here to provide some additional information and context, hopefully inform the discussion. And Chairman, at your discretion, I might be able to expand on Representative Berry's question, or I can save that to the end, or?
Sure, please feel free.
Yes, sir. So Representative Berry, with respect to the recharge considerations, per statute, our agency provides information to groundwater conservation districts to help them develop their groundwater management plans. It includes outputs of the groundwater availability models, including inflows and outflows from the aquifers, discharge to surface water, and also recharge estimates. So that information is provided to the districts and incorporated into their management plans.
Representative Berry.
To your knowledge, do you know whether or not the GCDs contemplate recharge rates when trying to export water from the GCD? Or is that up to the GCD to determine what they feel is going to be hazardous or hurtful to the aquifer?
Going off my memory of statute relative to the export specifically, but most of the focus of a consideration for a permit is the effect on the aquifer and the production of the aquifer. Districts do have the ability to require a permit for export and to charge fees for export, but it's my understanding that most of the impact is based on the production and the impacts to the aquifer from the pumping and not so much the actual export of the groundwater. But I might defer to some of the other experts and the attorneys in the districts in the room to elaborate on that.
Well, I would, in my particular case, I'm referring to export as the production of that water or the taking of that water from the actual aquifer and, you know, doing whatever the property owner decides they're going to do with it. But that's what I'm considering an export. If the export is going outside of the groundwater conservation district, in our area, there's a fee charge for that. I don't know if every GCD actually charges a fee for that or not, what the conditions are around whether or not the fee is charged or whatnot, what the criteria is for that. I'm happy to, you know.
Yeah, I might defer to Adam to speak to the specifics, but I think it's variable across districts. Different districts have different sort of fee structures and fee amounts depending that they might be able to charge for export. I think it is variable, though. I do think the statute provides certain guidance on how that fee could be structured. Sometimes it's specified in their enabling legislation, but there's variable versions of how that fee is structured. And I might defer to Adam.
And how often is that fee changed, or is it up to the GCD as well?
Statute says that it can only increase by, I believe, 3% every year. That was a bill that passed in the 88th session. So they have a cap on how much that they can charge for
Understood,
export
yeah.
fees, and then it can increase by, I believe, 3%.
Yeah, gotcha. Okay. So that's kind of where my concern lies is, you know, if we're gonna take out of the aquifer more than it can recharge over time, you know, and from my layman's perspective of that, it's damaging to the aquifer long term, right? If you're taking out more than you're recharging. So that's going to be kind of the center of my attention when it comes to questions associated with things going on today and in future meetings. So just so you know, thank you.
And I can offer my testimony.
Sure.
Perhaps that'll provide a little bit of information to describe how these decisions are made.
Please proceed.
Okay, thank you. So I wanted to provide a little bit of background and context in terms of groundwater management in Texas. And Adam covered some of the basics, so I don't want to repeat myself. You have some handouts in front of you with some of the information that I intend to present. So I'll try to modify it slightly so that it complements what Adam has already provided rather than repeating any of that information. But in terms of groundwater management in Texas, it all starts with groundwater conservation districts, and Adam described those fairly well in enough detail. I think the takeaway here is that it is defined in statute that groundwater districts are the preferred method of groundwater management in Texas. 36.0015 is where that is stated. There are 100 that have been created to date, and I think you have a map of what those districts look like or where they're located, and I won't repeat some of the other things that Adam's already provided for you. I will add on that Texas has also established a framework to provide for planning among districts within shared aquifers or overshared aquifers, and that was done by creation of what's called groundwater management areas. Back in 1995, our agency was tasked with creating the framework that was most suitable for regional groundwater management. So there is a map in your handouts that describes how that was done. We configured 16 individual groundwater management areas, and you can see on that map that they are generally aligned with the major aquifer boundaries within Texas. If you've got the map in front of you, you can see that the red aquifer system there represents the Creasy-Wilcox system. That's the system of interest for the hearing today. We segmented that aquifer system into 3 GMAs, 13, 12, and 11, and the area of interest here will be GMA 11. So the next handout I've got for you is a map of that same configuration, the groundwater management area framework, the planning areas with the districts overlaid within that framework. Really, the purpose of this framework of establishing these groundwater management areas is provide an area in which districts can collectively decide on the future policy decisions and collectively decide on how they manage the aquifers that they share, that they overlie. And again, the area of interest here is going to be GMA 11. So on the next slide, we're going to zoom in on GMA 11, and this shows you the boundaries of that planning area. Again, this is largely aligned to with the Carrizo-Wilcox Aquifer system. There are 4 groundwater conservation districts in that area: Neches, Trinity Valleys, GCD, Russ County, Piney Woods, and Panola County GCDs. And as was mentioned, Houston County has no groundwater conservation district. The next slide is a zoom in to the district that is the subject of this hearing. This, of course, is Neches and Trinity Valleys GCD, and they are made up of Henderson, Anderson, and Cherokee counties, as you know. So the next slide, I want to focus a little bit on the aquifers, and I won't go into deep detail on the physics of these aquifers or the availability of these aquifers, but to point out that there are some major and minor aquifer systems within this planning area. Again, it was configured to align with the Carrizo-Wilcox system. That is the major aquifer system. There are also 2 important minor aquifer systems, the Queen City Aquifer and the Sparta Aquifer. The Queen City is also the target production zone for some of these wells in this project area. So the next slide I've got for you is a map of the entire aquifer system that are the target areas for these projects, including the Carrizo-Wilcox. It's a large system going all the way from the southern border up to the Louisiana border. It's a very important major water supply within this region. It's made of thick packages of sand and gravel and sediments, and so porous media that is suitable for holding lots of water and yielding lots of water. The solid colors on the map there show you what's called the outcrop area. That just means that's where those rocks, that's where the units of that aquifer are exposed at the surface, and that's also where that aquifer can receive recharge. The hatched area shows you the down dips or the subcrop part. And then the other map I've got there is of the Queen City Aquifer. Similar situation, the solid colors show you the recharge area. It is not as thick as the Carrizo-Wilcox Aquifer system, so therefore it does not yield as much water, but also a very important supply for this part of the region. The next slide I've got for you is what we call a hydrostratigraphic column. It's just a fancy word for showing you diagrammatically how the aquifers are stacked from deepest and oldest to youngest and most shallow. I've highlighted the Carrizo sands and the 3 divisions of the Carrizo, or the upper Wilcox, middle Wilcox, and the lower Wilcox. These are thick formations. This kind of puts it in context. This formation can be as deep as 3,000 feet in some sections, but on average it's about 600 to 700 feet in thickness. Whereas the Queen City is going to be a little shallower in depth and also a little thinner in thickness. And then finally, this is the last slide on the aquifers. This is showing you what it looks like in cross-section. So if you think of these units as a layer cake, and you were to take a knife and make a big slice out of that cake and kind of look at it in cross-section, this is what it might look like. And you can see the aquifers of interest here, including the Queen City and the Wilcox. On the left side, in the northern part of this area, this is where they're most shallow and they're actually exposed at the surface. And again, where they are exposed at the surface, that's where they can receive recharge from precipitation, stream flow, and fill back up, basically. Then you can also see how these dip to the south and get deeper and become confined and under pressure with some distance to the south. So now I want to quickly switch gears and talk about a few of the terms that Adam threw out there that are important to understand in the context of talking about groundwater management and planning. I'll try not to repeat what has already been said, but I'll try to emphasize some points of interest that I think will help you in your discussions. Now, we've got a lot of acronyms, so I've already talked about a couple of them. We talked about districts and GMAs. I want to focus on the desired future condition. You're going to hear a lot about that term today, and it's a very important term to understand because it drives a lot of how we determine groundwater availability and ultimately planning in Texas. I'll also talk about modeled available groundwater. Adam mentioned that. And another important term, total estimated recoverable storage. And I'll try to put those terms into context, again, to inform your discussion today. So we'll start with the storage numbers. As a product of our model, we can provide an estimate of the total amount of water within an aquifer system. And what this total estimated storage number represents is the total amount of water that can be removed by pumping that completely drains the aquifer in a computer model. This can be true in the computer world. It is not necessarily true in the physical world. And the way I like to explain this is if you take a sponge that's saturated and you squeeze all the water you can out of it, the sponge is still damp. There's still water in the sponge. That is true of an aquifer system as well. So just some context for what these total storage numbers mean. They're not necessarily removable in the physical world. We also provide a very important estimate of what's called total estimated recoverable storage. And so we simply provide a range of that total storage number, which is 25 to 75% of that total volume, representing that you can't get it all out, but this is a range of what might be recoverable. There's an important caveat to that number as well, is that total recoverable storage number does not contemplate the impacts of pumping on things like subsidence or water quality degradation or impacts to surface water resources or to springs or the economic feasibility of pumping that water. So just some important context when you're seeing these very large storage volume numbers. So I've got in your slide the numbers that were reported for total storage, total estimated storage for the 3 aquifer systems in the 3 counties, and they range from 390 million acre feet to 66 million acre feet over those 3 counties. Again, very large numbers. Again, important to remember that context. So now I want to quickly talk about how groundwater availability is determined in Texas, and it's all based on establishing the desired future condition, and Adam mentioned that. But this is established by groundwater conservation districts in the joint groundwater planning process. And again, Adam did a very good job of describing that. The only points I would like to add is some context around what a desired future condition is. It's defined in statute as a desired quantified condition of groundwater resources at a specified time or times in the future. Think a 50-year planning period. Also think of it as the expression of a physical condition of the aquifer that you would like to preserve over time, 50 years or so. Could be a maximum amount of drawdown over 50 years. Could be a minimum amount of spring flow that you want to preserve. Could be minimizing subsidence on the Gulf Coast, for example. These are all examples of desired future conditions. The statute also lays out 9 specific factors that districts have to consider when they make this decision. I won't go through them all. They're in your materials, but they range from uses, state water plan, hydrologic conditions, environmental impacts, socioeconomic things. There are a lot of different factors that go into that decision that then to start to apply some judgment decisions, some value decisions that pull it away from that big storage number and actually represent some of these other factors. Ultimately, the test, though, is that this condition, the statement, must provide a balance of the highest practical level of production and conservation and preservation of the aquifer. That's a statutory test. That's the ultimate test for the districts when they make this decision. I've got some other figures in here. I won't repeat everything that Adam had said, but basically, joint groundwater planning, the way I describe it, it's a marriage of policy and science. That desired future condition is very much a policy decision. The science comes when we apply that condition to our groundwater availability models, and we can derive from that exercise an amount of pumping on an average annual basis that will preserve that desired future condition. So just think of it conceptually as that, and those are the important terms here. The DFC, the models, and also modeled available groundwater, that's that groundwater availability number. I'll just quickly mention that the modeled available groundwater, the output of that number has 2 very important functions in terms of planning and GCD management. On one aspect, it defines the groundwater or the water budget for regional water planning areas. Modeled available groundwater is the amount of water that planners have to plan strategies in the regional water plans, and that rolls up to the state water plan. The other important role of the MAG numbers is that it provides important information to the districts they incorporate into their management plans and to the rules. It also is a factor in a permitting decision. It is not a cap. Districts are not limited to issuing permits within that amount, but they do have to consider modeled available groundwater in their permitting decisions. So I've gone too long, I apologize. I'll just wrap up with the information that was relevant to you for GMA 11. This is the product of the 2021 round of joint planning. Desired future conditions established for this area for the 3 counties represent average drawdown between the period of 2013 and 2080, and they range from drawdowns or water level declines of 86 feet to 155 feet in the Creasy-Wilcox, and these are for the 3 counties, including Houston County. And the numbers for the Queen City are there that range from 12 feet to 44 feet. Again, this is drawdown by the end of that period, 2080, is the desired future condition. The modeled available groundwater that we've calculated that corresponds with those desired future conditions are on that last slide there, and they range from 2,355 acre feet to 27,024 acre feet for the Creasy-Wilcox for those 3 counties, and then for the Queen City, 2,295 acre feet up to 16,591 acre feet, again for the Queen City for those 3 aquifers. So, that's all the information I have for you. Hopefully this is helpful. I'd be happy to take any questions.
Members, any questions? Representative Alders.
Mr. Chairman, Mr. Dubnik, thank you for the overview on this, and I'm coming at this from a layman's perspective, but your overview is helpful. When talking about available groundwater and then the various usages and the science, kind of planning ahead for how much is available, to what degree are you able to know and kind of put into the math and the equation groundwater that's staying within the GCD versus the scenario we've got here potentially, which is exporting it from the GCD? I mean, does that go into the planning?
It really is a consideration of the production of it, removing the groundwater from the aquifer. And others might be able to speak more to this. The attorneys in the room might be able to speak more to this, but I'm not sure how export or transport is factored into the desired future condition decision. The statute does lay out 9 factors. It does include uses. It does include environmental impacts, socioeconomic impacts, private property rights, all of those things. But most of those things really hinge on the impacts of the production, the pumping of the water out of the ground, rather than what happens to the water once it's been produced and whether it gets exported or not.
I appreciate that answer. Kind of along the lines of Representative Berry's questions earlier, one of my concerns is what happens when you export out of the basin, out of the aquifer that we're talking about here in East Texas. Obviously, we're in the region of East Texas, of the state that has water, and so we want to be very cautious about water leaving our part of the state. I mean, do we have even an accurate number currently of the number of agreements that are in place? Does the Texas Water Development Board have a record of all the export agreements that exist across the state? Do we know the amount of volume? Do we have anything we can refer to as far as historical precedent that would give us some guidance on what happens to an aquifer when this high of volume is contemplated?
I would say in general, we do not have all of those records. If we do have any information related to an export project, it will be related to a project that has applied for financial assistance from our board, or may be contemplated by the planning groups and maybe in the state water plan. There may be arrangements outside of that process that we are not aware of.
So where do we go to look and get this information? Is that to the individual GCDs? Is it the regional planning groups? Where do we go?
If the project's contemplated by the Regional Water Planning Group, that would be one source. If the project is coming out of a groundwater conservation district, they would have to have the permits. So that would be the source as well. The individual district would probably be the best source if they require permits from that area.
Okay. And then last question here, just following up, I referred to the website that you mentioned earlier, the Alliance of Groundwater Districts, and just pulled up the one that's relevant here. The note that we've got, or that shows is number of active groundwater export permits is 1. Do we know what the volume is that's currently being exported?
So that information is not publicly available on the GCD index, so we have the number of export permits per county. We've asked them to supply us with that information, but then to get the actual volumes, you'd have to contact the district itself
Okay,
for that information.
good, thank you.
Chair recognizes Senator Perry.
Thank you, Mr. Chairman, and really it's just for making sure members that are kind of hearing some of this stuff for the first time, and you've done an excellent job of laying out the process. Specifically, two questions. On the, I think it was the 2022 GMA for 11, their MAG information and things. When you list the total acre feet of production by year 20 through 80, is that the recoverable amount that it can produce without causing, to meet the DLC, or is that the storage amount? I want to make sure members are clear. That's the recoverable amount, correct?
That's, if you're referring to modeled available groundwater. the Magnum-
251,000 acre feet is what that GMA is showing throughout. And it's broken down into district and non-district production. And so I just want to make sure that is the actual I assume it's the recovery, but the aquifer may have more storage, but. So-
The information I have, the MAG numbers I have are for the 3 counties.
No, not for the 3. This is just the overall GMA.
Okay.
And I can do the quick math for it, but it's just a general principle. That's recoverable in the GMA report that's done, or is it not?
If it's referenced as, there's a specific term for total estimated recoverable storage. If
Okay.
that's how it's described, then that's the larger storage number. If it's referencing the modeled available groundwater number, that's going to be the amount of pumping on an annual average basis that corresponds to the desired future condition.
Okay, so the 251 is the estimated amount of recoverable, not recoverable, production.
And I'm
associated with the
sorry,
DLC.
Senator, I don't have those numbers in front of me,
Okay.
but
All right. It was done, I think, by you guys, but anyway. Secondly, when I see the same report and it's got no district, meaning there's no water district over it, where do y'all get your data since there's not actually a district over the top submitting the data? Where does that data come from for the non-district information that goes into that?
the joint regional planning process does require the districts contemplate the desired future conditions for even those areas outside of the districts. And our models have the information that provide the actual aquifer parameters. So regardless of whether it's in a district or outside the district, the model covers the complete domain of the aquifer system.
Is that the well, is there wells out there in the non-districts providing that information?
We do include pumping distribution within the model, even with it, if it's outside the district, and we pull together the best information we have available to us. And the districts, if they have some of that information available, we certainly rely on them to provide what they can, and then we try to get what we can from other sources for the areas outside the
So
district.
at some level, it's kind of a best guess. You have actually more detailed information from a district, but a non-district county, it's best guess. It's limited availability, and you extrapolate there from what you got.
The information is generally more limited outside of the district.
And could that accommodate for some of the wide ranges within these distributions of what is recoverable up to what's, I mean, you named once 390 million acre feet, but yet the low end and that's significantly different. Is that part of the difference possibly is you're kind of working with best guess? So under this particular page, 134,000 acre feet per year over 251 is potentially not monitored. You really don't know. You know some, but you don't know a lot. Fair statement?
Yeah, the state of Texas, the Texas Water Development Board, we do have monitor wells in place all across the entire state, even outside of districts. So we do our best to fill the gap.
Sure.
But the information certainly typically more readily available, more dense within a groundwater conservation
Right,
district.
thanks, sir.
Representative Ashby.
Mr. Chairman, I want to drill down just a little bit deeper on Chairman Perry's question there about storage versus the modeled available groundwater numbers that we have in front of us by county. And just so I'm clear, and I think Chairman Perry was trying to get to this as well, but the modeled available groundwater is a joint process with the locals, the GCD, providing their DFCs, their desired future conditions to the Water Development Board, and then y'all work together collaboratively to come up with the modeled available groundwater, correct?
It is a collaboration. I would describe it a little differently. The districts, per statute, they have factors they have to consider in determining that physical condition of the aquifer they intend to preserve. Typically drawdown. That's typically, water level declines is typically what they tend to manage for. They work with their stakeholders and with their consultants and work through all the factors to come to that decision. So a lot of the decisions on how the criteria, which criteria to put more weight on, which are more important, which to prioritize, that happens among the districts within the DFC decision process. And then once that is decided, they submit that full package to us, and we just go through the technical exercise of running the models to calculate how much pumping corresponds with that condition, with that desired future condition.
That makes sense. So, but ultimately, the modeling here is based on the local GCD's desired future conditions.
That's right. That is
what they're
correct.
trying to achieve.
Correct.
Okay. And I think that is, you know, the concern that so many folks have with this particular permit is that when you look at the very numbers that Water Development Board is presenting, in the case of Anderson County, the permit application that's pending before the local GCD for Anderson County exceeds what is their modeled available groundwater. And so I highlight that because I think that is really tip of the spear major concern. And you just can go down the list, next county, Henderson County, it leaves very little available groundwater when you take into account the permit that's been proposed. So I think that's the story here today, is that when you just look at the numbers that are provided both locally by the GCD in terms of adhering to their desired future conditions, which of course they're required to do by statute, and you look at the modeled available groundwater that y'all work with and help provide that technical expertise to the locals, this particular permit exceeds that. Now, there's another question later on about, well, you know, what can be done about that? But I think in terms of just looking at the science and the data on the issue at hand here of this hearing, I think the point is well made that there is not enough groundwater, according to the Water Development Board, to not only meet the expectations of the permit application, at least for one of the three counties, but it would leave no available groundwater for people that actually live there. And so I highlight that as obviously a major concern. The other question I have is, you mentioned subsidence. How does that factor into this process?
Subsidence is a specific factor that has to be considered when they're weighing their options for what a desired future condition could be or should be. Subsidence risk is variable across the state. We've got a tool that helps districts assess what the overall risk of subsidence is in their specific area. I'd have to go back and look at what the risk is for this area. It's a really common risk that's well known in the Gulf Coast, for example, and they manage to mitigate for subsidence there. But it's a factor that goes into the decision if that's a potential risk in that particular area for that aquifer.
But it's also true, is it not, that if you look at just the history just south of where we're talking about in these counties, and you look in the Houston area specifically, Galveston, back in the early 1900s through about 1970, they primarily relied on groundwater, and then of course shifted to more of a surface water model in the 70s. But you know, I think according to your own data that we saw subsidence in those counties of up to 9 feet. And this particular area, ladies and gentlemen, that we're talking about runs right along the Trinity River. And I see my friend Kevin Ward over there. He knows this all too well because I call him about it. But we already experience more than our fair share of flood events along the Trinity River. And so the thought of further subsidence in these particular counties could be catastrophic for the individuals that live up and down this particular river basin, as well as potentially the Natchez. So anyway, I just wanted to highlight that, but thank you for your testimony.
Representative Hefner.
y'all may be talking about something that's my question. These permits and these GCDs that y'all are talking about are south of my district, but, you know, I had a call from one of my cities that was concerned. So if you start pumping these amounts of water from this aquifer, and if it's, say it's 60, 70, 80 miles south of me, what is that going to do on the drawdown, like in my area? So I have a city that has 5 wells that are in this aquifer. I mean, is there a potential of the water level dropping below the depth of their wells? And I don't know the fancy terms for all this, but it just seems like, you know, people don't understand how that water is under the earth. Is it just a lake down there? Is it working its way through sand and gravel? And so if they pump it down south, is that going to have an effect further up north to our wells that are down in the same aquifer?
That question can certainly be modeled, and it's going to be highly variable. It's going to be dependent on the aquifer conditions. It's going to be dependent on the aquifer properties. It's going to be dependent on the volume of production. It's going to be dependent on the duration of that pumping. But typically, when you produce from an aquifer, it will draw down at the vicinity of the well, creates what's called a cone of depression, and then that, if the duration and the pumping of the aquifer is maintained over time and it's not replenished by the aquifer, that cone of depression will expand and the drawdown will expand. It behaves differently if it's confined under pressure versus unconfined, and that can get into the weeds a little bit, but that question can be modeled, and it's going to be variable depending on the conditions.
So it's pretty complicated then.
Yes.
Wow,
Yes,
okay.
sir.
Well, and of course, obviously, their concerns are, you know, we have these 5 wells, they're good-sized wells that provide their city water, and if some of them could be lowered at great expense, some of them might not be able to be lowered and have to drill new wells if that were to happen. So, but thank you for that information.
Representative Bell.
Thank you, Mr. Chairman. So, just looking at the information you've handed out and listening to the dialogue, one of the things that jumps out at me is we see a map that's one-dimensional that shows what an aquifer looks like in a cross-section. But what is the lag time in updating that information between what we see in this paper? I mean, a lot of what we see as a legislature may be 2 years old. What is the real-time update for the flatline modeling that's going into these projections?
The models are living tools, and they're designed to be updated as more data becomes available, and we can continue to improve them. The versions of the modeling software get improved over time. The resolution gets improved over time. We try to update them on about a 5-year basis if we've got the funds and the resources and the staff time and the ability and the data, really. It depends on having new data and new information. And this can come through pumping projects that provide aquifer testing data so we can refine our aquifer parameters, for example. It can come with more refined distributions of actual production, actual pumping across the region. We can update that in the model. We can update the physical parameters of each cell in the model as we mentioned, information becomes available. But to your point, Representative, it is an iterative process. These are dynamic tools, and they are designed to improve over time as more information becomes available.
So, but if I hear you right, the information may be as old as 5 years old before it's acted on. What is that? What is your opinion, as you sit here in front of us right now, the data that you've handed out to us that is used to generate what the conditions are we're looking at today? Is that data 1 year old, 2 year old, 3 year old, 4 year old, 5 year old data?
I believe this model is, I'd have to check back on this. Confirm. Oh, yes, sir.
It's from 2024.
Okay.
I'm sorry, from 2014, not 2024.
Okay.
2014.
And that was where I was going with that. So we don't have a 3D model that has as much dynamic nature as what I'm sure the state of Texas would like to have, needs to have, in order to be able to assess the impacts not only on the cities that Representative Hefner talked about and everybody else is concerned about, not only the drawdown effects that Chairman Ashby talked about, not only the concerns with all of the local wells and residential and ag wells that are around these areas. As we sit today, we're talking about what effectively would be demographical information. It's not, it is forecasted, not statistically accurate based on where we are today. It has a lag time in it. And I just want us to understand that as we sit here, because what we're looking at right now may not be what's actually there. And I would suggest to you that the probability is our condition is not as, it may be now with all the flooding, recent flooding, because the recharge may have pushed our aquifers, should be pushing our aquifers along with the tragedy and devastation that can go along with, and has gone along with recent flood events. But if we looked at the model, and if we looked at the aquifers in real time right now, we don't have an ability to across the state look at, I guess that's my ultimate question. We don't have an ability to look at the aquifers across real time and say, what's the snapshot of today? Or even what's the snapshot of last December?
We don't have the modeling capacity to run predictions in real time. We do have real-time groundwater monitoring wells in place that are collecting data just on the level of groundwater in the subsurface. So the data is collected in the real time, but the modeling exercise does take some time. So that is not available in real time, at least for the tools that we develop. And Chairman Harris, I'm a well-conditioned state bureaucrat, and I don't make a habit of correcting the chairman, but I'm told that
Please do.
our models bit was updated in 2021.
It was, okay, all
Yes.
right. The 2024, actually, I was citing the GAM, the groundwater availability model that's cited in, on one of the websites that's been published is from 2014, from my understanding. I thought that's what you were going off of.
So,
Thank you for correcting me on that.
anyway, I just think as we go forward, we need to also figure out how to make that model far more dynamic so that if we ask for a screenshot, if this body or any, or a local regional body asks for a snapshot of where is my aquifer today to answer a permitting question, it should not be 5-year-old data or worse that's being used to generate that. And we put some, as a legislature, we put money into Water Development Board to develop those resources and those tools. And it sounds like to me that as we said here today, one of the things we need to invest in is making this more dynamic, more real-time. Real-time, maybe a year, I don't know. Real-time, maybe 2 years, but real-time can't be 5, and us know that we can use it to forecast where we are today. Thank you.
And Representative Bell, just by way of clarification, we update the models on that time scale, but we can make model runs. We can run scenarios through the models. You know, they're available for as a tool to do that at any time. So we can run those scenarios in real time or as they're requested. But the updates to the models take a few years to actually get done.
And we could go in a circle. So we got to be looking at a small snapshot, or we just leave it all updated. So we're looking at a screenshot, or we're looking at the whole aquifer. And I'm not. I appreciate the hard work you guys do, and I'm not trying to. I'm just saying that that as a state, we're at a point. We have a finite resource. We know we have a finite resource. We've got to have it to live on. We know it's a private property right. We know it's a need for the state, across the state, and it's time for us to figure out what that looks like and to know what that looks like in a relatively real-time snapshot. So anyway, thank you. Thank you, Mr. Chairman.
All right, members, before we go on to the rest of the questions, we're in a different hearing room than most of us are used to. So if you do want to ask a question, hit your mic button, and that will show us on this iPad over here that y'all want to ask a question. Your mic won't go live until you're recognized on the iPad. So that's how that will keep things in order. So we're going to go Representative Romero, Dr. Buckley, then Mr. Money. So if anybody else wants to ask questions, please hit your microphone. Chair recognizes Representative Romero.
Thank you, Chairman. So I think that there's, just based upon the questions, there's clearly concern from different parts of the state, shown by the presence of members from all over the state. So I think that what people are looking for is some sort of peace of mind. And I'm sure that when you do your modeling, that's what you try to provide is peace of mind. I think it's safe, or I think it's unsafe, and I should raise a flag here, deep concern, and these are the reasons why. It sounds like that's what you try to do through your modeling. Is that correct?
We're really responsive to what the districts have identified as their management priorities through that setting of the desired future condition. The work on how to prioritize all those conditions, all those factors that are defined in statute, that really happens at the district level within these groundwater management areas. Once that they've made their decision and they've considered all the factors, what their future demands are, what the impacts might be, then they produce that condition to us, and we then go through that technical exercise of helping them understand how much pumping could be afforded while maintaining that condition over time.
And so you went right to the point of the desired local conditions, and you talked about these different aquifers having different depths, some being thousands of feet, some being hundreds of feet. If one of these districts says that their desired local conditions are of an elevation that's a substantial amount of water, but yet at the same time, the entire state is thirsty for water, is there a mechanism where you can say to that local district, well, I know this is your desired district, but you have a lot more water there than you actually need, and other parts of the state need it? Is there a discussion that goes in play, or is that just, that's what the local district wants, so therefore that's the way we're going to leave it and not let it go below that number?
Yeah, that discussion happens among all of the districts that were within that area. So it's not just at a single district scale. And GMA 11 has 4. Some of the larger groundwater management areas have even more districts. But they have to come to consensus among the districts. And typically, the districts fairly well represent geographically, the various areas within a GMA. But those districts have to come to consensus on what their management goal is, and they have to vote on them, and they have to adopt ultimately what that condition is. So within that process, it's built for compromise, it's built for consideration of all the factors, but ultimately the decision of all the districts is what becomes the desired future condition.
And those districts are generally local in region. So let's just kind of go right to where it is. North Texas needs water. It's drier than East Texas. This might be a tool in the future for, let's say, if Senator Perry's pipeline grid were to occur, we might need water from East Texas and move it around different ways, right? So at what point is the discussion, if there ever is it just local because of your desired conditions, or does it go statewide? And I'm being real specific about excess of water. I don't want to cause concern, or no one should want to cause concern for any part of the state, because I don't live there. And there should be precedent for the locals. But I'm asking, when there is an abundance of water in some of those that are really deep, does it still just go back to those local areas, or does the Texas Water Development Board or whomever have the right to say, as a state, you're still okay, this is still safe, based upon your modeling? Can you give them that peace of mind?
There's another component of this where that kind of gets factored in that I will offer up, and that's within the regional water planning process. The regional water planning groups go through that exercise of projecting demand, looking at existing supplies, identifying where the shortages are, and then identifying what strategies they need. The significance of this process, the groundwater planning process, is that modeled available groundwater number determines the amount of water that's available to those regional water planning groups. So if the regional water planning groups have a sponsor that have the need for a big project that's going to go somewhere else, for example, it has to fit within the amount of water that's available per that groundwater planning process. That's where it starts. The groundwater availability is determined by that desired future condition, by that modeled available groundwater number, and then that becomes what the regional plan groups can work with. If they decide it's a big number and it's a lot of water and a high volume, and the regional planning groups identify a project where that scenario comes into play.
I'll allow
Representative Money? Oh, I'm sorry, Dr. Buckley.
Okay, all right. Thank you, Mr. Chairman. Is there any requirement when a permit is issued at this scale or any scale that the information and the data that a groundwater district has have a certain, be as current as possible? Because we talked about, Representative Bell talked about that, some of the data was new, some of it is I know groundwater districts can do this nearly real time. I mean, they can have pretty current data. The one that I represent in my area can do that. But is there a requirement that before a permit is issued, that the information be as current as possible?
Yes, when they consider that, one of the statutes says they have to use the best available data.
What does that mean?
I mean, most districts do have monitoring programs. In fact, probably all districts have monitoring programs where they have maybe not daily water level measurements, but they should have at least weekly or monthly water level measurements, so they can take that into consideration when issuing a permit or factoring that into considering a permit.
What about the Water Development Board? Do y'all continuously monitor like as real time as you can?
We have a recorder well network that is measuring real-time water levels, and it's available through our website. We also have staff that physically collect water levels on a seasonal basis. We cover the entire state. Typically takes 4 or 5 years to have our folks fan out and collect these data, but those are one-time measurements. The real-time networks, where you can see the trends, best see the trends, but we do collect those data and provide them.
Okay, and so a groundwater district could rely on the Water Development Board for maybe some gaps in data?
We partner with the districts. Most of the districts have their own networks, and then we also manage some wells that we collect data on, but it's usually a partnership between the districts and the board.
Okay, and again, though, if we have a aquifer or a permit that happens to be going in, so what happens if a permit is applied? Well, I guess there is no permit. What if you want to drill a big export well in an area that doesn't have a groundwater district?
Rule of capture.
Okay. Without any consideration of what that export would do to, that aquifer has no idea where the groundwater district boundaries are, right? I mean, I'm very familiar with that in Central Texas. And so you could actually have an export well under rule of capture that if there was, if the data there, I mean, you wouldn't drill that well probably unless you could get the quantities that you wanted, but that could impact someone in another district, and that district really have no say in the matter. Is that correct under current law?
That's my understanding of the rule of capture, correct.
Okay. All right. Thank you very much.
Senator Perry.
I got to go back and qualify what was said just a minute ago. It is relevant and timely, and it's important for the November election coming up. This project and projects like that are not eligible under Senate Bill 7 or HJR 7. Clearly, Senate Bill 7 and HJR 7 had the intent to force development of the next layer of water supply that is brackish. Specifically by statute, 3,000 parts and over qualifies for funding to force development of the next layer of water supply for Texas, and that's the harder water to develop, not fresh water. So that is a, quote, almost defense at some level. I don't want, because this whole hearing's about, is the science good enough to move water? Well, I took the approach in the legislature and Chairman Harris that we're not going to go after low-hanging fruit of freshwater supply. We're going to force it to brackish and other options. And that is what is eligible under Senate Bill 7 for funding. So this project would not qualify for that because it is way under the parts per million. It's not brackish. I say that so that we don't leave this hearing and have it go public, that in November, the very people you guys represent are not going to come out against Senate Bill 7 and HJR. Actually, it's to their favor because it forces the state to go to the next level to keep from depleting existing freshwater aquifers. So I felt compelled, Mr. Chairman, I'm sorry, but I couldn't leave that on the table because I don't want it to public, because that's already a kind of a narrative that the state is now subsidizing movement of fresh water, and that's contrary to what the bills do.
That's right. You and I and Senator Nichols and this entire committee worked very hard to make sure that that was in fact the case, that the funding in HJR 7 and SB 7 does not go towards fresh groundwater. Representative Money.
Oh, okay, I've got a funding question actually then. Is this particular project eligible for any type of funding with the Water Development Board?
I'll defer to my colleague.
All right.
Thank you. For the record, Jessica Pena at the Texas Water Development Board. The entity would have to be an eligible entity to be eligible for some of our other funding programs. Like the Senator mentioned, it would not be eligible under the new Water Supply for Texas Fund. But it could be potentially. If it is an eligible political subdivision, meaning there's a public sponsor, it couldn't be a private entity.
Okay, so the Water Development Board, in addition to the science that we're talking about, and I have a scientific question as well, also provides funding by way of low-interest loans, grants, things like that. And, I mean, has billions of dollars to do so. So in order for this project to be eligible for any of that kind of funding, it would have to be sponsored by a local groundwater conservation district, city, county?
Yeah, correct.
Yeah, somebody like that.
Mhm.
Okay. And to your knowledge, has there been any application related to this this particular project for that type of funding?
No, not to my knowledge.
Okay. My second question is, does the Texas Water Development Board do any kind of oversight of the engineering studies that are done by these projects? Who like they've provided hydrology studies. I think I'm saying this right. I may not be, but the private entity says, hey, here's what we think is going to happen with our project. They submit that as part of their application. Who oversees that and makes sure that their data is accurate, their analysis is accurate?
So when an application comes to the board, part of the review of the application, the technical review, is some engineering oversight. So we're looking to make sure that from an engineering perspective, they're meeting the design standards that are set by TCEQ, that they're meeting our programmatic standards and requirements. Anything that's written into the statute regarding these types of projects, those are the things that we're looking at. So we're reviewing engineering feasibility reports, environmental documents, and things like that.
And are you reviewing those to ensure, I mean, is someone reviewing the science to make sure that what they're claiming it will do to the aquifer is consistent with what the state believes will be done, the Water Conservation District?
So part of the review also includes a planning review. So we're looking to make sure that the project is consistent with what's in the state water plan.
I think you lost your mic.
Oh, sorry about that. So part of the review also includes a planning review. So our planning staff is looking at the projects to make sure that they're consistent with the regional and state water plans.
Okay, have you seen, and this for anybody, have you seen the report? And I know everybody's not going to be up here at the same time, but the applicant has some written comments that we're going to look at later today. But it says, I want to make sure this is accurate as far as you understand it. It says, we have not applied for any production or transport permits at this time. They're saying it's purely for exploratory drilling. Is that correct?
I'm not aware of.
I can't speak to the project application as either. I suspect there'll be other witnesses that can address that.
Yeah, Representative Mike,
Okay.
the Groundwater Conservation District itself would probably be the best to ask that.
I just don't want to lose witnesses that might know. So,
You don't.
okay.
No harm in asking.
Once they leave, it's hard to get them back. So, thank you. That's all I've got.
All right, any other members for Mr. Dupnick? We are almost at an hour and a half into the hearing, and we've only made it halfway through our first panel. So let's proceed with the remaining two witnesses for this panel. Hold off questions until the end of the panel, and then once we call up the next panel and those thereafter, if y'all don't mind, let's hold off questions until the end of each panel, just to try to keep it moving a little bit faster. But I genuinely appreciate the engagement of the members. Don't hold off from asking questions. I do appreciate that. Ms. Pena.
Yes, sir. Chairman Harris, members of the committee, for the record again, my name is Jessica Pena. I'm Deputy Executive Administrator of Water Supply and Infrastructure at the Water Development Board. So once entities identify these projects, one of the next tasks that they face, of course, is how to fund those projects. The board does have financial assistance programs that may be available to political subdivisions for projects that meet specified criteria. For example, if the project is included in the state water plan as a recommended water management strategy project, excuse me, with capital cost, it could be eligible for the State Water Implementation Fund for Texas, which offers low-interest obligations to fund projects that produce additional water supply during drought conditions. Another program would be the Texas Water Development Fund, which offers comparable market interest rates for eligible projects, including water supply projects. The 88th Legislature passed Senate Bill 28 and Senate Joint Resolution 75 creating the Texas Water Fund. That bill directed that the board may only use the fund to transfer money to certain funds and accounts administered by the agency. Included among the eligible funds was the New Water Supply for Texas Fund. The bill required that the board finance projects through the fund that would lead to the creation of 7 million acre-feet of new supplies by December 31st, 2033. The board adopted rules for this program at its April 2025 meeting. Projects eligible for the New Water Supply for Texas Fund include marine and brackish desalination water projects, produced water treatment projects, and aquifer storage and recovery projects, or ASR. In this past legislative session, the passage of Senate Bill 7 included additional eligibilities to the fund. The bill added water and wastewater reuse projects, the acquisition of water or water rights that originate outside of Texas, reservoir projects that have acquired the necessary land and permits, and the bill also further defined the eligibility of projects that provide for the transportation or integration of groundwater, essentially noting that the fund can only be used to transport or integrate groundwater if it is part of a new water supply eligible project such as ASR or brackish desal, but not fresh groundwater exports alone. The board has been funding projects that create new water supply, and that is most notable in the State Water Implementation Fund for Texas program. Since 2015, the board has funded 8 projects that could meet the eligibility requirement for the new water supply for Texas. Those projects received commitments for more than $3.1 billion with an estimated new water supply of 274,995 acre-feet per year when completed. Those projects include reuse, brackish groundwater treatment, ASR, 2 seawater desalination projects, and 3 reservoir projects. We are also currently reviewing applications for 5 additional requests for funding from the SWIFT program. 3 are proposing to create an estimated 27,790 acre-feet per year of new water supply, and 2 are projects previously committed that are requesting funds for the next phases of their projects. We anticipate presenting these projects for consideration by the board later this month. That concludes my presentation, and I'll take any questions.
Thank you, Ms. Nygren.
Thanks. Good afternoon, Chairman Harris, committee members, senators, and representatives. For the record, I'm Kim Nygren, Deputy Director for the Texas Commission on Environmental Quality's Water Availability Division, and I'm going to provide an overview of TCEQ's limited role in GCD oversight. The TCEQ's oversight role for GCDs includes investigation and actions in specific circumstances. Those specific circumstances are outlined in Chapter 36 of the Water Code, and they include taking a look when a GCD fails to adopt, readopt, or submit a management plan to the Texas Water Development Board by required deadlines. When the board denies a management plan and the GCD does not resolve the deficiencies identified in that denial by required deadlines. When the state auditor's office audits a GCD and finds them not operational, or when a petition for inquiry of a GCD is filed with the TCEQ. Under Chapter 36, an affected person can request an inquiry into a GCD for specific reasons outlined in the statute. If TCEQ finds there is sufficient evidence, the TCEQ can appoint a review panel to investigate. The review panel submits a report to the TCEQ with compliance recommendations, and the TCEQ can take action in response to that. TCEQ's actions have consisted of compliance agreements or orders directing specific compliance actions within established timeframes. The TCEQ is vested with additional authority up to and including GCD dissolution, although that type of authority will typically not be the appropriate tool when you're seeing some of the GCD compliance issues that we take action on. And that concludes my testimony. I'm available for any questions that you have.
Members, any questions? All right, so just for clarification, and this may be for Water Development Board, but Water Development Board would only review the applicant's science if the applicant applies to the Water Development Board for funding, correct?
That's correct.
Okay. And in this case, have you or have you not?
We have not.
Okay. So only the GCD will be able to review the applicant's science using y'all have got way more resources than the local GCD, right? But only the GCD were the ones who are able to review the science.
Until an application is presented.
Until when?
An application is presented.
Okay.
Sorry, steal the mic from you, Jessica. I just wanted to add that we've got a program called Groundwater Technical Assistance, and they're there to support groundwater districts, namely through the planning process, but we also try to be a source of data and information for the districts as well.
Okay. Mr. Dupnick, whenever you began your testimony, I think we missed you stating your name and who you represent for the record, so would you mind doing that real quick just to make sure we get that in?
My apologies, Chairman. John Dupnick, Deputy Executive Administrator, Water Science and Conservation with the Texas Water Development Board.
Thank you. Members, any other questions? All right, thank you all very much for being here. Chair calls Shauna Sledge and Todd Gallego. And the chair will ask witnesses from here on out to try to confine your remarks to 5 minutes each. Obviously, we've got a lot of questions from the members of the panel, so I'm sure we can cover everything that you want to between both of those.
That was the biggest hurdle
That
in
was, yeah.
putting together
Yeah, it's hard to do a
testimony. 5
Groundwater
minutes.
101
I know.
testimony in 5
It's
minutes.
a lot
isn't it?
going on.
Ms. Sledge, please state your name and who you represent for the record, and then proceed with your testimony.
Good afternoon, Mr. Chairman, senators, and members of the committee. My name is Shauna Sledge, and I'm a water lawyer and attorney with Sledge Law Group here in Austin, Texas. I've been invited today to speak on the topic of groundwater law. I would like to start my testimony by discussing the 3 fundamental tenets of groundwater law, which are the rule of capture, ownership, and regulation. And I will explain how these 3 legal concepts work together. I'll then discuss how groundwater conservation districts regulate the production of groundwater through permitting as well as groundwater exports. I have distributed a copy of a published article I wrote for the Water Report on this subject for those of you who may want to take a deeper dive. I was short a few copies, so I'll make sure to get that to Robert to send out to the rest of y'all. So as you know, there are 2 bodies of law that apply to groundwater: common law, which is established by the courts, and then statutes enacted by the legislature. Prior to the existence of any statutory governance over groundwater in Texas, the Texas Supreme Court adopted the English common law rule of capture as the law for groundwater in 1904. Essentially, as you guys know, the rule of capture provides that absent malice or willful waste, landowners have the right to take all the water they can capture under their land and do with it as they please, and they will not be held liable by their neighbors. Today, this right under the rule of capture is limited both by common law and through conservation statutes and regulations. So looking at the regulatory component, following the droughts in 1910 and 1917, the citizens of Texas adopted the Conservation Amendment to the Texas Constitution, which granted and imposed on the Texas legislature the authority and duty to preserve the state's natural resources, which includes groundwater, and gave the Texas legislature the authority to create special districts to assist the legislature in carrying out its duties. In response, beginning in 1949, the legislature declared groundwater conservation districts, local groundwater districts, as the preferred method of groundwater management and regulation in Texas. The majority of GCDs, however, were not created till after 1997, following the passage of Senate Bill 1. Senate Bill 1 was a huge bill that basically revamped all of Chapter 36, which is the primary statutory authority governing GCDs, requiring GCDs to develop management plans and do a lot of the things that were already discussed in the previous panel, and really for the first time ever get more serious about regulating groundwater resources. There were about 100 years where we had little to no law on groundwater ownership. So the legislature stepped up in 2011 and attempted to define groundwater ownership, stating that it was real property owned by the surface estate, or it can also be its own independent estate if severed. The Texas Supreme Court then in 2012, on the heels of that legislation, held for the first time in the landmark case, the Edward Aquifer Authority versus Day, that groundwater, like oil and gas, is owned in place beneath the ground. This means that a landowner has a vested ownership interest in the groundwater in place under the ground, and because they have a vested ownership interest to that groundwater, even before it's produced, they can therefore bring a regulatory takings claim against a groundwater conservation district if a regulation goes too far as to preventing that landowner from accessing that groundwater. The court in Day further explained that the only qualification to this rule of ownership in place is that it must be considered in connection with the rule of capture and is subject to regulation by groundwater districts. So, even though you own the property you own the groundwater beneath your property, the rule of capture still applies, and therefore your neighbor can still suck that groundwater out and you don't have any recourse against that neighbor. Rule of capture still applies, okay? Even where there's groundwater districts and even though we have ownership in place. So, ownership in place is also subject to regulation. The court in Day went very far to explain that even though the Supreme Court is applying ownership principles that are applicable to oil and gas now to groundwater, such as ownership in place, regulation of groundwater is necessarily and substantially different than oil and gas. And the paper I handed out goes into great detail about that. But if a regulation by a groundwater district goes too far, it may be recognized by the court as a taking, and the landowner may be entitled to compensation by the groundwater district. But a big takeaway from this that I want everyone to really think about is that you truly cannot have a recognized private property right in groundwater that is protected without regulation. Because absent regulation, such as in these areas where there's no groundwater district, the only remedy for drainage under the rule of capture is basically self-help, drilling your own well. So you're basically competing, whoever has the bigger well is going to get that water. That's not good for protecting private property rights. Sorry, I gotta get a drink of water. That's not good for protecting private property rights. And it's definitely not good to promote the long-term aquifer viability. So therefore, because groundwater is a commonly owned resource, meaning multiple people own it over one aquifer, regulation by GCDs is intended to give landowners the opportunity to produce their fair share of the resource, as well as maintain the long-term viability of the resource where feasible. And we'll get to that in a second too. So how do districts do that? How are they doing that? How are they protecting private property rights, affording an opportunity for folks to produce their fair share while also maintaining the long-term viability of the aquifer? Well, as we heard before, we have the DFCs. That's number one. Set your DFC. What do you want the aquifer to look like in 50 years? You tell the Water Development Board. They run the models. They hand you the MAG, Modeled Available Groundwater District. Each district gets their MAG. This is the amount of groundwater you have on average over the 50-year planning horizon that you can produce per year. It's basically your annual groundwater budget. We've had so many fights over whether this MAG is a hard cap on annual production. I would argue to say it's not a hard cap. There may be years you bust it, and there's maybe years you're under it. But in the long 50-year planning horizon, that's your groundwater budget. That's what districts have to work with in terms of how much water is available to issue permits and allocate groundwater amongst the various owners that co-own the resource. Next step, management plan. Districts adopt management plans, their objectives, their goals. This is similar to what state agencies do to achieve those DFCs. Then, third thing, in implementing their management plans, GCDs must adopt and enforce rules, including how they're going to allocate groundwater, such as through permitting. And these permits that are issued to the districts and allocate groundwater amongst the various co-owners of the common resource must ultimately be done in a manner that allows the groundwater districts to achieve the desired future conditions for that aquifer. So that's how this all works together. And we have heard a lot of discussion and questions on TERS, total estimated storage recoverable. And I'm sure we'll hear more about it. But that factor is only considered when GCDs consider factors in developing their DFC. It's not considered when we're issuing permits. We're only looking at modeled available groundwater, the much smaller number when we're issuing permits. Storage is only considered in DFC development. It's one of the factors. And frankly, in my experience in representing several districts, it's not a helpful factor because in most parts of the state, if you produce just 1% of storage, you've completely rendered that aquifer unconfined. It's no longer a confined aquifer, which means it's not as viable as it otherwise would be because you're losing that pressure in the aquifer. So to accomplish the DFC achievement, groundwater districts must limit total annual pumping through their allocation rules and permitting systems on average to the modeled available groundwater set by the Water Development Board, which is often referred to as the groundwater district's annual budget. Chapter 36 provides various tools and factors a groundwater district may consider in development of its rules to regulate the production of groundwater and limit production from wells, including well spacing, production limits, surface acreage ownership, beneficial use, historic and existing use, and service area needs for water suppliers. Now, you have to understand that because of the variability in local conditions and uses of groundwater, there's no one-size-fits-all approach to groundwater management and regulation. So, Chapter 36 does provide basic, very actually detailed statutory requirements for applicable to the procedures districts must implement in terms of looking at permits such as administrative completeness, notice hearing requirements, how they process these applications for permits. But when it comes to how they're going to allocate groundwater between co-owners of the common groundwater resource, districts vary. And that's necessary because even when you look, we have multiple different types of aquifers in Texas that respond to pumping differently. Karst limestone, totally different than a sand aquifer. Then even within the same aquifer, looking at the Trinity aquifer, in the outcrop where it's much closer to the surface, we only have folks making 5 gallon per minute wells. In contrast, just 4 counties to the east, along the I-35 corridor, you have multi-million-dollar wells that are 1,000 feet deep, 1,000, 2,000 gallon per minute. And nobody's on their own well, you just have big water suppliers. So even within the same aquifer, you have so much variance. Then you're gonna look at different uses. For example, in the Gulf Coast aquifer, we have, in the Montgomery County, we have tons of growth, and we have a lot of folks on big water supply wells, municipal use, industrial use. But then in Wharton County, you have landowners with huge tracts of lands doing rice farming. So there are different factors to look at in determining how a district's going to allocate the groundwater that's available to the various landowners. However, as more pressure is put on groundwater resources, districts have struggled with how to allocate and permit groundwater production in areas of limited groundwater availability, where demand frequently exceeds the available supplies that can be produced if a DFC is to be achieved as mandated by statute. So what this means is that basically in most districts in the state, we're getting to this point where we're basically fully allocated in terms of what's our annual groundwater budget and what are we gonna do next. If we want to meaningfully manage in a way that achieves that DFC, we're gonna have to start telling people you can't produce as much, or we're gonna have to curtail existing users. And the biggest issue there, and districts are scared, because they're scared of takings claims. And districts are not, I won't say all, but a majority of districts cannot adequately defend itself against takings claims because they don't have the funds. So we're talking today about we need groundwater districts to do all this science. We want them to focus on that. We want them to focus on the ability to say, hey, we got this big groundwater production permit coming down the pipe. Let's do require some really intense site-specific testing. Let's do some serious modeling. Let's develop our own model. But instead, districts are having to be prepared to go down these horrible litigation that can last up to 10 years, not only for a contested permit before the district or SOA, but then a takings claim in actual court. And so we're seeing some of that play out in court in recent years. So while it would not be prudent for the legislature to remove any of the regulatory tools in Chapter 36 toolbox at this point, because GCDs or groundwater districts regulatory systems and the permits already issued under them rely on those tools that I mentioned, the permitting limits, surface acreage, beneficial use, all those tools, districts use those, and they rely on them, and folks that have permits from the district have investment-backed expectations in those permitting systems adopted by the district, utilizing those tools. But the legislature could certainly supplement the toolbox with additional tools. One area ripe for consideration and of relevance to this committee today is Section 36122, which applies to groundwater district's authority to regulate and transfer groundwater out of the district's boundaries. Under this provision currently, groundwater districts arguably cannot prohibit groundwater exports or discriminate or restrict export permits more than in-district permits. The only clear exception is that districts can impose a fee for groundwater groundwater exports, but this fee is statute in the statute as we previously discussed. The rest of the section in Chapter 36 is difficult to read, and some of the provisions are hard to reconcile thanks to a hodgepodge of legislative amendments in Senate Bill 2 and 2001. In Senate Bill 1 in 1997, the legislature came up with a regulatory scheme for groundwater exports that was originally similar to what they did with interbasin transfers for surface water. And you can still see some of this language in the existing Section 36122. And that language requires a balancing test looking at the origin of where the groundwater is coming from to the area that's receiving the groundwater, looking at its impacts to the aquifer, to users, looking at groundwater availability. That language is there. However, this language was ultimately rendered useless in the statute by amendments in Senate Bill 2 in 2001 when the legislature overhauled this section and left it difficult to understand. So even though that language is there, there's actually other subsections that say, oh, just kidding, you can't consider that language because you got to treat everybody the same. So as a water lawyer that represents groundwater districts, we counsel our districts that they need to regulate everyone the same at the pump, regardless of location of use inside or outside this district, save and except the export fee. Is it time for the legislature to revisit Section 36122, the export provision? Maybe. In many areas, groundwater export projects challenge the long-term viability of our aquifers. Why is long-term viability of the aquifer important? Because aquifers provide free infrastructure. As the legislature is well aware from its water supply analysis, the cost of raw water is directly proportional to how far you have to transport it and the cost of storage. If your land is over an aquifer, then you have groundwater transported to it and stored under it by the aquifer for free. And if the state allows aquifers to get overpumped to move groundwater to high growth areas, or even just a large volume groundwater permit within the district, to such a degree that local landowners have to come up with an alternative water supply for their properties, there simply isn't enough money in the state budget to support having to plumb, move, and store water from all over the state for all those properties that were previously provided water by the aquifers for free. It would be totally cost prohibitive to both the state and to landowners. Ultimately, under current law and the tools the legislature has provided groundwater districts, there is little a groundwater district can do to regulate groundwater export projects and address their consequences to other landowners unless the groundwater district is also actively managing and restricting production on all of its district users as well. So treating everybody the same. So while a lot of our discussion today is about a local issue, local permits that are coming up, local export proposals, this is an issue that is plaguing the whole state. As I mentioned previously, districts are up against their MAG. They're going to have to start telling people no or not as much.
Ms. Sledge, will you say that one more time, that last sentence?
Yes, sir. This is an issue being seen across the state, not just export, but we're seeing huge projects come online. And these districts do not have permitting and regulatory systems to accommodate such large projects. For instance, in West Texas, these districts that I represent are allocating groundwater acre foot per acre owned because that's what it costs to make a crop. And everybody is on ag water out there. You're gonna see, we're seeing a proposal for a huge hydrogen plant out in West Texas. And they have done the work. They've bought up the water rights. They've leased the groundwater rights. And so technically they should be able to come in and produce that water. But that was never, the idea that you would have such large volume users come online was never a forethought of the district back when that 1 acre foot per acre was established. That 1 acre foot per acre is not a guarantee for everybody in the district. It's relying on the fact that some folks aren't gonna produce that groundwater. It's actually gonna stay under the ground. So we have to recognize the importance of that and that we're gonna have to get to the point where we can't treat everyone the exact same and not all groundwater is created equal under somebody's property. And I'm happy to answer any questions.
Thank you. Mr. Gallagher, I understand you're here primarily as a resource witness. You don't have prepared testimony, is that correct?
That's correct, sir.
Would you mind stating your name for the record, who you represent?
Yes, Todd Gallagher with the TCEQ's Office of Legal Services.
Thank you. Members, we'll go to questions next for this panel. Chair recognizes Representative Gertis.
Hey, Shauna, thanks for being here. You talked about improving the modeling and science, and the GCDs across the state vary with the resources that they have. And in particular, GCDs that don't have the resources or collect an absorbent amount of export fees, how do they go about improving their modeling and science when they don't have the resources that is needed to consider an application such as this?
I mean, they're kind of caught flat-footed, honestly. I mean, they are required to participate in the joint planning process with the other districts that overlie the aquifer and set those DFCs, and then the models are run by the Water Development Board, and they're given their, annual water budget, the MAG. But in terms of handing over a bunch of information that's really helpful, or districts that are well-funded are paying for to have the Water Development Board or their own hydrogeologists conduct multiple GAM runs, running the model under multiple pumping scenarios. What's going to happen if pumping increases over here? What if we limit it over here?
So have a science-based
some districts can do that.
Opinion or data line, right?
Yes, sir. That backs, that makes it a more meaningful process in developing those DFCs and knowing what those future impacts are going to be, because they can anticipate we're going to see growth in this area. So let's run a pumping scenario where, there's more groundwater pumped here, or what if we create these management zones? How would that affect pumping in the long term? So being able to do multiple model runs is really helpful for groundwater districts, but they have to pay for them out of pocket. So districts that don't have those funds, they're kind of left at the mercy of the other groundwater districts in the GMA and the groundwater management area in the joint planning process. And they do get to vote on the DFCs that are handed to them, but they may be outnumbered and they may not have, the best data that they need in order to develop rules that are really meaningful. And I think the best case scenario is if we could, especially with these big volume permit applications, we could do more modeling and testing on the front end, and maybe require perhaps the permit applicant to pay for it all rather than the district. That's something to consider from a statutory perspective.
And when you're talking about the MAGs, I'm just looking at the one for one of the GCDs I represent in Lost Pines. there's almost, in the MAG over the 50-year period, an additional 4,200 acre feet. How is excess water found in that MAG process in that 50-year window when that number increases for a GCD?
Oh, that's a great question. So what's actually happening, it's not that excess water is being found, it's that they're saying, oh, we can actually live with worse conditions, and so that gives them the ability to get a bigger bag. So if you're saying, okay, for the first, the joint planning process is in a 5-year cycle. First cycle, let's just say, okay, my district can live with 10 feet of drawdown, right? And you're handed the MAG, X amount of groundwater is your budget. And then over time, obviously we're seeing more and more pressure on these groundwater resources, and pumping is needing to, districts are scared to say no to folks because they don't want takings claims or not as much. They're afraid to cut people back. And so they're gonna say, oh, okay, next planning cycle, let's run the model and we can live with 20-foot drawdown. Mm-hmm. So that's how they get a bigger MAG, and they're just kicking the can down the road.
So it's not exactly science-based.
It's science-based in the sense that you're modeling it, and the fact of the matter is these are subjective objectives. I mean, a DFC is what can we live with? But I think, and these will be good questions for Wade Oliver, who's next, what we really need to be looking at is, and districts do look at that. This is, okay, with this much pumping, how many wells are we gonna see go dry? Because over time, it's really just making it more expensive to produce the groundwater. You're having to lower your well, you're having to lift the water, there's not as much pressure. So it's not that the water is totally gone, it's just that it's not cost effective to produce.
Right. Okay, thank you.
You're welcome.
Let's go Representative Money.
Oh, shit.
Never mind? Okay. Representative Ashby.
Thank you, Mr. Chairman. Shauna, I think we all deserve honorary water law degrees after that.
It wasn't 5 minutes.
And I'm not an attorney, so I was digesting as fast as a banker can. So I really, I guess I have two questions that because I want to keep it brief. But one of the, I think, problem areas you highlighted for a lot of GCDs across the state is the inability, because of lack of resources, to defend themselves in a contested hearing, a lawsuit, etc. And so I guess, and I could go with this in several directions, but I guess my question is, if can a GCD accept legal expense contributions from somebody that wants to help in the cause?
That is a great question. I've never, ever thought about that.
Well, I just, again, if you don't know, that's fine. I don't want to.
I don't know.
I don't want you to give us the wrong answer.
Yeah.
But I just think about, with obviously the case here before us today, I know there are some interested parties that do not support this permit that would probably be happy to participate and support in the legal case should that arise against it. And I just didn't know if there was any statute or any regulation that would prevent them from helping if it comes down to that.
If that is the case, I would encourage those folks to participate as parties to the permit application, contest it themselves, because they can have their own legal counsel and present their own legal arguments, assuming they have standing against the permit application. And it would be really helpful for the district, because they can have their own hydrogeologists and assess impacts to their individual well based on this proposed operation. So I think that those folks play a really important role in these permits, and especially these large volume permit applications.
Okay, thank you. And then I guess the last question I have is, and you didn't speak to this in terms of current law, but if you are an adjacent landowner to one of these big commercial well projects, anywhere in the state, not just here in East Texas, but anywhere, or in close proximity, and there's a cone of depression that's created, what legal rights and remedies do landowners have that might see their groundwater being depleted from underneath their own property?
So you wouldn't necessarily, you would have really limited rights between the landowners going after your neighbor because, again, of the rule of capture. There are exceptions to that, like subsidence, waste, malice, stuff like that. But if they're draining you legitimately under the district's rules, there's not a lot of recourse. You could, of course, go against the district for, state and there's a cause of action under Chapter 36, but there's not much recourse against the individual
So there's
landowner.
not in case law or much case law in this particular
There's
instance.
unfortunately very limited case law when it comes to groundwater. We're just seeing it more in recent years.
Yeah. Mr. Chairman, just an observation, and I know a couple folks have highlighted this, but it seems like most of my life we've talked about surface water and the legal issues surrounding moving surface water. We obviously have had a number of laws created over the last few decades that pertain to that, but I look at my colleague, Representative Gertis, who certainly has been very vocal about a project in his district, and I'm aware of others, as we all are on the committee. This is increasingly going to be an issue, and I just think that while we may be today talking about a specific one, this is something that we're going to see more and more of across the state, and again, I appreciate you having the hearing.
Agreed. Thank you very much, Mr. Ashby. Senator Perry.
Thank you. Sean, it's good to see you. Appreciate it. I do agree we could all have an honorary water degree. You mentioned several things, and I know there's not going to be a solution today, but you raised some really important subject matters that especially probably between now and the next session we've got to entertain. But a couple of things. First of all, we have one aquifer and we have multiple districts over that aquifer. And I know your position and probably people that represent water districts would take a different, because they have with me over the last years, but it is absolutely, and the question earlier was, if my city pulls to the south of these permit requests, is it going to impact my city? Well, depends on the aquifer, right? But when you have multiple GCDs with multiple rules operating over the same aquifer, it is nearly impossible to answer that question because you need the whole aquifer and not just by district working that number. And we don't have that process today. Is that a fair statement?
I think that's a fair statement. I think, as you of course know, the fix to that is the joint planning process and the coordination among.
But you spoke to that, and you clearly stated the little guy gets overvoted.
Well, it's just that
or a guy gets overvoted.
I've seen districts where, yes, that's the case. Like in, Pecos County, there's a lot of production, and plateau districts in that same GMA, and they aren't producing as much.
Right.
And so there's
Well,
obviously
it came up at the session right at the end there. There was a bill proposed where it's going to require kind of
Sure.
joint processing, and it goes back to the four nations. Some are on shelf, some are on cone. The guys that wants to pump the most because they've got the biggest need, if there's more than that in the cone, then the guy on the shelf's going to have the challenge, right? So that's one issue that I think this legislative session needs to deal with. Secondly, during session, there was a statement that was finally made public by someone that knows this stuff very well, and they said it just as honest as they could, that there is no expectation or should not be an expectation for water districts to protect the shelf, the individual well owners on the shelf. That was made clearly, and I've never heard it publicly. Everybody knows it. Everybody don't want to talk about it. So to that point, we have the other issue there, right? Because I'm in the wrong spot, my wells are going to go dry.
Yeah.
We've seen it come up. We've seen it through Vista Ridge. We've seen it through other things. It's going to continue to be a storyline. That's another issue the next session. You mentioned 122, and I watched the eyebrows of the water attorneys go up. State law is pretty clear. You don't make retroactive changes. But I hope this committee, with chairman's help and people that are actively engaged in y'all's groups, that we find a way to find a balance. To the point that Representative Ashby made, the surface waters have had some of these similar fights, you mentioned it. And somewhere in here, we're going to have to find a balance on the export side because truly it is the law that you treat everybody equal, but you said it best, not all groundwater is equal within the same system. There's more value to some than others, but It is a task that is yeoman's, and it will be overwhelming, but it will need lots of research. But somewhere in this export, because it is the sign of time to come, and most of the water permits granted in this state on its current path will be dictated by court order and not in the best interest of the people. And so we need to move forward on these initiatives. So this itself is the platform for starting the conversation. How do we address export in a manner that is at least as fair as possible? And I think we have precedent out there to look to, but we will demand lots of input from very, very smart people. But I caution fees in conversation, because no matter how much fee I'm getting, if I'm on a depleting resource, it doesn't matter how much money I have. And ultimately, the solution to this is more supply, and we made grounds to do that. But we have about 3 different tasks going forward, and this has been very telling at this point, that we need to pursue, and the fights that are going to come from it are worth the battle. Because if we don't get this right, then we're going to continue to see people lose at the expense of the others. And I don't know what the balance is, but there's got to be some formula in here we can figure it out.
Thank you, Senator Perry. Representative Bell.
Thank you, Mr. Chairman. So along the lines of what Senator Perry was just talking about, we see people who lose their wells on the shelf, and there's no private property right reserved by those individuals. And in the same breath, we hear, and in Montgomery County, you mentioned Montgomery County, that's way too complicated to jump off into today. It would take another week or two to finish
Totally
that
agree.
conversation by itself. But the challenge to reduce pumping within existing jurisdictions, while also recognizing the increase in population, the increase in manufacture, other challenges, pressures on it, that seems to be an inverted equation. You know, to do more with less, and I think if that is going to be the course and direction that we're contemplating, and maybe this is a statement, not a question, but we're going to have to figure out how conservation fits in these conversations as well, and where's that fund? Do you have any thoughts on, because I know, for example, you know, in Montgomery County, there are a number of cities who've been told you've got to curtail your production at the same time that there are subdivisions opening, other manufacturing facilities opening, other challenges coming in. What does the legal community see as the solution to those, or do you?
Well, I think there's really only, I don't know if you'll like this answer, but there's really only one groundwater district, and it's a unique special district, and it's not a Chapter 36 district, that I think has done it well and in a defensible way, and that's the subsidence districts, specifically the Harris-Galveston subsidence district. And so what they do is they have the statutory authority to impose a disincentive fee. And what they do there is they say, you know, they decided, they created these management zones, and they are regulatory zones. And they say, if you're in this zone, because there's so much subsidence occurring here, we need to cut you back. You have your demand, we're gonna cut you back to 10%. And for the other 90%, you have to go find an alternative water supply. But you actually can produce more than that 10%. You can produce 100% of your total water demand as long as you pay a disincentive fee. So it's not that they're saying you can't pump your water. They're just saying it's a disincentive. It's just, if you want to produce more than the 10% of your demand, you're going to have to pay a fee for it. So it kind of forces folks to bring online alternative supplies, because I think what we're all coming to recognize is that groundwater is not the silver bullet when it comes to the future for water, future growth for water in Texas.
No, I think if you look at groundwater, again, up until a couple of weeks ago, most of the big reservoirs, certainly those west of 35, were very near unusable for water purposes,
Yeah.
because of the low amount of water that was in those. The other thing that you said that kind of strikes me as interesting, a disincentive fee doesn't touch the fact that you have a finite quantity. So saying you can charge more to be able to exceed whatever the conditions are, that works for a moment in time, but doesn't seem to be a solution at all. Because whether we use groundwater, surface water, brackish water, desalinization, all of those equations, you know, there is certainly a finite calculation and a cost associated with that. But
Absolutely.
so, but I was just curious as your take on that. The other thing, I was reading your water report, and I just want to mention that in the Severn Cell aspect, Coyote Ranch, Lake Ranch versus City of Lubbock, the comment is made in that the court suggests that the doctrine addressing relationship between a mineral estate owner and a surface estate owner to recover minerals has worked well. Well, as a property owner in East Texas who's constantly trying to keep folks from just destroying the surface of a working ranch to put in, and so far.
You
thank
disagree
goodness,
with that statement?
I disagree with that statement wholeheartedly, and I think
understand.
it's important as we look at and consider the water and the private property right that exists in the water to the degree that it exists, that current law trying to apply mineral rights to it certainly, at least in this particular seat that I sat in, will not be a satisfactory statement because it leaves the surface to be destroyed for the production of the subsurface, and it's just not an equitable statement, and that's true whether we're talking about minerals or in the future talking about water. But thank you for your testimony. Thank you, Mr. Chairman.
Thank you.
Representative Zwiener.
Thank you. Thank you so much, Chairman, and thank you for being here today, Ms. Sledge. I wanted to follow a couple of threads you started. The first one was you mentioned lawsuit challenges for groundwater districts. I think you mentioned in particular that groundwater districts are afraid to say no even when their planning and their rules should allow them to say no because they're afraid of takings claims. Can you expand on that a little bit?
Sure. I mean, it really just comes down to some of these districts don't have much funding, and takings claims cost a lot of money. And, you know, even if a landowner doesn't have a viable taking claim, they can still file the claim, and the district has to defend itself. And so I know this is a controversial topic, but as we've seen in recent sessions, we've had bills to change the section of Chapter 36 to loser pays. Right now, it's the district can recover if it prevails in a lawsuit, that it does not initiate. And so it's important, in my opinion, to preserve that language to allow districts to recover their attorney's fees, because even if you don't have a viable takings claim, you can still get taken to court. And I think districts are worried about that. And we've seen districts prevail in takings claims in recent years and have these cases thrown out, but it doesn't prevent them from getting filed.
Well, I wanted to ask more about it because one of my districts is currently in the middle of a takings claim and is, I think, 5 digits, close to 6 digits into legal fees that they hope they'll recover. I mean, so we see these fairly commonly across the state. It's not just my check of the woods, it's everywhere.
Common. No, It's not that common. And I think there was like this huge concern that we're just going to see this huge influx of takings claims, and we really haven't. Your district does have one, unfortunately, but they do exist. They are out there, but you know, districts. We've learned from the 2 large takings claim cases, Day and the Bragg case, that there's a fact-sensitive analysis in whether a takings has occurred. And a big component of that analysis are landowners' investment-backed expectations tied to the production of their groundwater. And if a district regulates them to restrict their recovery of those reasonable investment-backed expectations, they could be liable for taking and have to compensate the landowner. And so districts are understanding they need to protect folks that have made those investments already. So people that have, you know, planted a whole pecan orchard, they have a better takings claim against a new guy that's coming to the district and has no wells in the ground yet, because they haven't made that big investment yet.
But any level of takings claim brought is going to be a substantial amount of time
Absolutely.
taken by the district. And so you see districts take sort of lawsuit avoidant behavior frequently, even when they think they
Yes.
would prevail?
Yes, I think there's districts that, you know, are, as I mentioned, their feet are kind of being held to the fire. Like, are y'all gonna start cutting people back because you're busting your mag? And the answer, unfortunately, is sometimes, oh no, we're just gonna adopt a new DFC that gives us a bigger mag. And so we're just kicking the can down the road because they want to avoid those takings claims. They want to avoid litigation and having to tell people no.
So we have situations where districts have done everything we've asked them to. They've done the science, they've come up with a mag, and then they are afraid to enforce it because of legal dynamics.
Yes.
Okay, thank you. The second thing I wanted to ask was more about rule of capture in general. Do most states have the rule of capture?
No.
What
Not
type,
anymore.
Yeah. What type of regimes do we see in other states?
Other states treat groundwater as we do surface water, where you get a permit from the state or a district, and it's a usufructuary right, meaning you just have the right to use that water. It's not owned in place, but there's other legal doctrines that apply, like reasonable ownership, you know, but not a flat-out ownership in place. But yeah, rule of capture is, other states think we're absolutely insane for still having that doctrine apply. But that's, of course, something the courts have applied. And then the courts have then said that it's up to the legislature to establish how to regulate and basically amend the rule of capture through regulation.
Okay. So I know a lot of states have this rule of reasonable use, where maybe there is some private property right in the water, but there's sort of the rule that we all hear about. You know, I can swing my fist till it hits someone else's face.
Sure.
I can draw down my water until it affects somebody else's water. Are we able to approach that through regulation in Texas, or are we still struggling to even, you know, protect neighbors under this current rule of capture regime?
I think that the rule of capture is, because it was established by the Texas Supreme Court, the legislature, of course, can modify that. But yeah, it's basically something that's been established by the court and would need to be overturned.
Okay. All right, thank you.
Representative Alders.
Thank you, Mr. Chairman. Shauna, thank you for your expert testimony here. And you brought up a lot of good points, but one of the interesting points that you brought up is that it's not only an export problem, but I mean, there are issues within these GCDs, within their footprint, with volume of water being utilized by corporations and groups. So, you know, that's a separate conversation, I guess, for another day. But this particular one, I mean, the reason why we're here is we've got an export issue.
Mm-hmm.
So I guess my question is do you know, like, through the history of analyzing the data, collecting the data, and you know, the GCDs, receiving applications, have we ever gotten applications across the state that have looked like this and have proposed this volume of water?
There's only been a couple. We've seen, of course, the Vista Ridge project, and I've seen other projects attempt to come online, but what happens is you get the legislature involved. You know, you might go in and amend the district's enabling legislation and give them some additional powers and negotiate a deal there with some special conditions, but in large part, we haven't seen that many of these, but I do anticipate more coming online.
And how does the Vista compare to this? What the proposed numbers?
I'm not sure what the numbers are and how they compare, but something that's interesting that's occurring there is that, you know, or in other export projects, districts are utilizing mitigation, basically. So they're getting export fees from these projects, and they're using them to assist landowners that are being affected to perhaps like lower their well mitigation programs. It's kind of a new concept. And I think that's great, but at the same time, I think that it's not changing the long-term effects that it's having on the aquifer. So if we're looking for long-term viability, it's still like helping a landowner lower as well and make up for those costs for pulling that water up. You know, the aquifer is still losing water pressure, and so.
Yeah, so just to be clear, I mean, your professional opinion, take the Vista Ridge project, for example, you'd say that is a negative impact on the local folks there in that GCD.
I don't want to speak for the GCD or the landowners out there.
Just from your perspective, looking at it objectively.
I'm sure there are folks that are unhappy about it, yes, that are out there.
Thanks.
Ms. Sledge, do you think GCDs could avoid future takings lawsuits by being very clear up front that a high cap export permit might be curtailed if it was shown to harm local existing uses that existed before the permit was issued?
Well, I have actually participated in representing groundwater districts that have tried to do that, and there were other issues at play there, but a lot of times what happens is, you know, we might give like a 10-year heads up, and you really got to get everybody to buy in, right? And we had that, right? But then maybe at the 11th hour, folks are like, oh wait, no, we actually don't want to do this, you know? So you can't control what folks are gonna do, and somebody has obviously the right to sue a groundwater district if they don't believe they're acting fairly. And so I do think the key in curtailment, though, I think it can be done. And I do think that that is actually something that you need to do, is give a heads up, get community buy-in. And it can be done. It just has to be done in a very specific way. And I think from a legislative perspective, there could be more robust legislation to support districts' ability to do that. Even though it does provide in statute that districts can curtail users, we could do more in that department.
Gotcha, thank you. Members, any other? Representative Gerdes.
Going back to the Vista Ridge, I'll speak for him. You know, that project loses 21 billion gallons of water a year, and 16 billion gallons of that come underneath my constituents' feet in Burleson County. That's why we worked this session on some niche water legislation to try to get cross-boundary communication, transparency, and interlocal agreements to maintain well operability. So yes, I'm passionate about protecting the folks and our resources in district that I represent. But going back to the GCDs, so there are no legal requirements for GCDs to consider future local demand when approving any permit, especially export permits. Is that true?
Well, there is, the court and Day specifically said that groundwater districts should be looking at future use, but it's not specifically said in the way that you just said it so clearly in statute. The court said it pretty clearly, but what the current statute says is really gives more protection to preserving historic and existing use. But of course, groundwater districts have to recognize that groundwater is owned in place. So folks have the right to access that water. How much is, I guess, the question. You know,
Right.
Again, not all land is created equal.
But they're required to manage toward the DFC, but not required to reserve water for future local growth. But the state water plan developed by the TWDB projects how much water local communities will need, especially in growing rural areas, which I represent. So shouldn't the GCD confirm that the projected local needs are fully met before allowing like a large-scale groundwater export permit to leave the region?
Sorry, I just want to clarify real quick something I failed to mention. Future needs is discussed as a component of the DFC process, joint planning. So in setting those goals, they do look at existing and future needs for groundwater use. But in terms of a permit application, I mean, Chapter 36 kind of says, you know, this is what you include in a permit application, and this is what, you know, and then 36113 provides a list of what a district can consider before granting or denying a permit. So if you have somebody come in and say, look, I have this many acres, your rules say you get 1 acre per acre foot owned, I've leased up, I own all these acres, I want this big daddy, you know, groundwater export permit, I've done the work, you know, a district has only those things listed in statute, and really, I think the only thing they could hang their hat on is impacts or unreasonable impacts, unreasonable effects on existing groundwater supplies or surface water supplies, which would include potential future use. You know, so there's not, beefing up that 36113 section would also be helpful in what districts can consider when bringing, when new permit applications come online, whether it's in district use or out of district use, because there's not a lot a district can hang its hat on. You know, let's say if that landowner meets all the other regulatory requirements.
Great, thank you.
Thank you, members. Any other questions? All right, thank you all very much for being here today. We'll proceed to our next panel, and that's on hydrogeology. The chair calls Ron Crowell, Mark Callicutt, and Wade Oliver. Thank you, gentlemen, for being here. Let's start with Mr. Crowell. If you would state your name, who you represent, and proceed with your testimony.
My name is Ron Kroll. I live
Pull that microphone towards you.
Ron, am I there yet?
There you go.
Ron Kroll. I live in Denton County. I represent myself. Thank you for letting me address this. I've been a professional engineer, pardon me, in the state of Texas since 1981. I'm currently semi-retired and inactive. In 1970s, I was a civil engineer in the Houston area. As part of my work doing master planning and engineering design, I became familiar with the significant dropping water tables and subsiding land in Galveston and Harris counties. It was due to the excessive water pumping, and they needed to convert from groundwater to surface water. I was in Anderson County last month and became aware of the applications for the multiple high-volume water wells. And with my experience in Greater Houston, I just wanted to share my observations and the research I've done. It's obvious, apparent from the discussions we've already had, that high-volume, long-term water well use is intuitively obvious to have impacts and consequences. Rather than guess and speculate as the consequences, we actually have historical experiences of over 100 years in Galveston and Harris County, and it's a great case study. And we can look at the effects when groundwater is withdrawn from aquifers at a rate greater than the recharge. Excessive water well production in North Galveston and eastern Harris County, southeast Harris County from 1900s to 1970 resulted in lowering aquifer levels by about 300 feet. On the exhibit you see, there's a couple of wells from a USGS paper in 1981 that shows the drops in those wells. The next exhibit comes from the Harris-Galveston Subsidence District, which was created in 1975. It had multiple missions, but one of its main missions was to convert supply from mainly well water to surface water. If you look at that exhibit, the area around Pasadena had 9 feet of subsidence. Baytown about 8, Galveston 6 feet from the early 1900s to the mid-1970s. Thus, the legislature created the Harris-Galveston Subsidence District. The Subsidence District defines land subsidence as the decrease in land surface elevation resulting from aquifer compaction due to prolonged excessive groundwater withdrawals. There's 2 exhibits which I thought were wonderful. The top exhibit, if you look in the lower left hand, and you can see how the soils were not well compacted. On the right hand, upper right hand side there, it shows after water levels dropped, the water that was within all those small areas compacted. The next exhibit down shows the same thing, but an interesting note in the upper right-hand corner of the upper exhibit, there are permanent decreases in land surface where even when the water wells come back, are still going to stay down. And when well production is reduced, it does reduce, or you can get rebounds in the water table. The Subsidence District was wildly successful. I was involved in it in the 1970s. In one of their primary areas, they reduced the groundwater withdrawal from 140 million gallons a day in 1975 to now about 8 million gallons. And the water level, in the subsidence, which was progressive all the way until the mid-70s, is virtually zero now. So they've been wildly successful. The aquifers have rebounded, and again, you and U.S. Geological Survey information have rebounded as much as 200 feet now. So they've been terrific. I wanted to have a quick look and see what the impact might be on shallow domestic and irrigation wells in East Texas. To get an idea of that, I found a Texas Water Commission report from 1988 that looked at a well about 7 miles northwest of Palestine. Looking through the data there, 87% of the wells were less than 100 feet deep. So if a large volume in East Texas results in a significant 100-foot drop, and if that's representative of those counties, a huge number of people are going to be affected. They'll have to find other alternative sources of water or incur the cost of drilling deeper wells. The conclusion obviously is, I'll lift out something. The other reason that the Subsidence District was created was the damage was not just lowering water surface, but because of the subsidence, they were damaging sanitary sewer lines, storm sewer lines, increased flooding, roadways were damaged, and other infrastructure was damaged. So we have a case study here now that shows actual 100 years of data, what happens when high volume, long-term water well withdrawals have happened and the effects. Lastly, much of my research was helped by Harris Galveston Subsidence District personnel, in particular Amy Gruder, a professional geologist and director of research and water conservation, along with the director, Michael Turco, have been very, very helpful. They're celebrating their 50th year, and they should be applauded and acknowledged. I believe they're in your district, or your district is next to them. Your district actually may be part of them. They would love to hear from you. Thank you very much. I know this was a short presentation.
No, that was great. Thank you, Mr. Crowell.
It doesn't take much.
Short and to the point. I like it. Let's go, Mr. Callicutt, if you would state your name, who you represent, and proceed with your testimony.
Chairman Harris and members of the committee, thank you for allowing me to come testify today. For the record, my name is Mark Callicutt. I own Callicutt Drilling. We are a local water well company based out of Cherokee County. We've been in business for 65 years. My grandfather started drilling water wells in 1960, followed by my father in 1970, and then myself. We are still currently active. We serve Cherokee County and the surrounding counties, including Anderson, Henderson, Houston, Van Zant, Angelina, Nacogdoches, Panola, Rusk, many of the ones that are around us. Smith County as well. You know, some of the counties that are in the groundwater conservation districts and some of the counties that are not in groundwater conservation districts. I have a degree in science. I've spent many hours in labs. I've taken many statistics classes. And the main thing I learned from both is that results can be manipulated to create the desired outcome that you want it to in most cases. And that's exactly what CEM's hydrogeologic scientists and engineers are doing. They're manipulating data, and they're trying to show you data to make you believe there's more water in the Carrizo-Wilcox Aquifer than what there really is. Data, studies, analysis on paper are one thing, but what really matters is real-world data seen by someone in the industry every day. I'm in the industry every day. I'm a small company. If I drill a well, I drill it myself. If I put a pump in a well, I put a pump in a well myself. I see static water levels drop every day. I see what's going on with these wells. Up until about 5 years ago, we'd seen a slow, steady decline in water levels in East Texas wells. If you asked me 5 years ago how much static water levels have dropped in water wells, I'd tell you about 30 feet on average. But today, that's different. In the past 5 years, we've seen a steep drop in water levels with some wells going completely dry and having to be drilled deeper. We've never seen this before. This is new territory for us. One example is on the west side of Lake Palestine, there's Lake Tranquility water wells, or Cape Tranquility. They're owned by Undine. They're just past the 1 mile radius from the Pine Bliss project that Mr. Bass wants to do over there. These wells are going dry already. The first well was drilled in 1970 to 435 feet. It had a static water level of 95 feet, and its current static water level as of last summer was 271 feet. That's a 176-foot drop since that well was drilled, and will only pump 25 gallons per minute now. The other well that's over there was drilled in 1978 to 440 feet, had a static water level of 120 feet when it was drilled. Its current static water level since last summer was 234 feet. It's a 114-foot drop. Had to install a dole flow valve, which restricts the pumpage of that well, so it could only make 12 gallons a minute to keep it from pumping off, so it could supply its customers. The customers in that area have been on water restrictions for 2 years, while they're waiting on the company to do engineering and get a new well drilled. Just west of Jacksonville, I have 2 customers over there. One had a 450-foot well, one had a 500-foot well. They both went dry. We had to drill deeper. One we had to drill to 737 feet, one we had to drill to 1,031 feet. And outside of Troop in Smith County, Wright City Water Supply drilled a new well in 2023. That was a large, high-capacity well, very similar to what's being proposed in Henderson County. There is no groundwater district there to limit how much water they can pump out of that well, and they're pumping as much as they can for their public water system. I have customers that are in about a 1.5 mile radius that I've had to drop their pumps 80 feet, and I can't drop their pumps anymore. They're going to run out of water soon. or they're gonna have to drill deeper. Their wells will not be any good. I have 2 other customers near a Southern Utilities public supply well just south of Tyler, kind of southeast of Tyler. Another high-capacity well that's supplying a large neighborhood over there. Both of their wells, another 80-foot drop, and they can't go any deeper. Soon they're gonna have to re-drill new wells and go deeper. There's a small oil field between ARP and Troop. It's an oil and gas field. Southwestern Energy started it up in the early 2000s. My dad drilled all the rig supply wells for them for their frack water and their drilling water that they needed. And in the last few years, I've been doing pumps for them when they're doing workovers and completions. And every one of those wells is dropped. And then they won't produce as much water as they used to. They used to produce over 100 gallons a minute, and some of them have dropped to half of that. And these are just a few of the real-world examples I see every day. CEM says that these are test wells. The design of these wells are not test wells. These are full-blown production wells. If I was going to go drill a public well for a municipality, and they would ask me to drill a test well first, it would be a 4.5-inch well. And then they would do their logs in that 4.5-inch well. They would test it, they would pump test it, and they would extrapolate that data to see what it's going to do to the aquifer and how much that, a certain design of a well could produce. Then later on, after all that was engineered and approved, they would drill a big well like being proposed in these drilling permits. The test wells have already been drilled and the aquifer testing has been done. They're referred to in the LRE water reports that CEM had prepared. Andrews and Foster, owned by Don Foster, drilled wells on Redtown Ranch in 2023 and Pine Bliss in 2024. So the labeling of these wells to be permitted as test wells is misinformation. I just recently found out about this, not in time, I didn't have time to ask the Groundwater District, but I had questions about these test wells, exploration wells being drilled already. Were there permits issued for these wells? Because these are the first I've heard of them. Were they labeled as test wells? Has the Groundwater Conservation District known about this since 2023? Or were they secretly done? You can find the state well report for the Pine Bliss well on the Groundwater website that shows all the public wells of record. You cannot find the ones for Redtown Ranch. I'm sure they were asked to be labeled private, just like Mr. Bass's wells on Barefoot Ranch were labeled private, and they don't show up on the state website, so I can't see any credentials or details on them. Some discrepancies that I saw in the LRE water report were that completed groundwater availability studies used water levels from the Texas Water Development Board well report website. These numbers are usually inaccurate for a couple of reasons. They may have been taken up to 25 years ago, and static water levels and drawdown levels have changed, obviously, by the numbers I told you before. So if they go and look into that website right now to try to use that data, it's inaccurate. It's 25 years old, it could be. They have not been physically checked. I'm sure LRE did not send anybody out to the field with a sonic radar to check water levels in wells. They're just going off what's on the website that we know can be inaccurate. A lot of the static water levels that are on those reports are inaccurate because there are some drillers that when they take water levels, they'll drop a rock in a well and try to count how many seconds it takes until they hear water, and then try to do a calculation on that instead of using an actual water level meter or sonic radar to get those water levels. And if they take that water level reading too soon after you finish a well, it might not be the correct one, but they go ahead and put it on that state report because they've been taking inaccurately. Models used to explain the projected impact to the aquifer. Models are used to explain the projected impact to the aquifer, but models are wrong. No one or no model can see underground. All we have is real world results that people like me see every day. Their website claims that there's only 6 feet of decline in the Carrizo-Wilcox aquifer in Anderson County and 5 feet in Henderson County. We know it's more than that. I see it every day. We see it in the numbers that I mentioned earlier. They state Texas is in a water supply crisis. They're wrong. Texas is in a water usage crisis. Wastefulness of our good water in Texas is creating issues, and maybe areas that have been running out of water but have not taken on the responsibility of regulated water usage and controlling water waste should step up and do their fair share. I'd like to touch a little bit on the lack of transparency from the Groundwater District and some conflict of interest that has been going on there as well. I found out about these permit applications about a year ago from the managing director of another groundwater conservation district. As soon as I left his office, I called the managing director of the Natchez Trinity Valley Groundwater Conservation District and asked about these wells. And the response was, "How do you know about that?" And my response was, "It doesn't matter," and that's not the correct answer to the question. And I was told, "Well, we're trying to keep this quiet. We don't want the headache." I said, "Well, that's your job. And that's what y'all are there for." And then I was told that, I asked, "What are we going to do about it? Can we stop it?" And I was told, "Well, I don't know if we can stop it, but we can't fight it because we don't have the money to fight it." And other people have already brought that up today. So I was glad that issue was raised today. Don Foster is the owner of Andrews and Foster's Drilling, and he is a Natchez Trinity Valley Groundwater Conservation District board member until about 4 weeks ago. Don is the drilling contractor that has been hired to drill these wells if permitted. He resigned disgracefully when the public found out about his conflict of interest before the meeting in Jacksonville a few weeks ago. He signed a conflict of interest on July 18th, 2024, and presented it at a board meeting. The same date that CEM first had these wells permits on the agenda. CEM states that they introduced themselves and their plan to the Groundwater District Board on April 18th, 2024. I could not verify that because they do not have those minutes. That's the only month of the minutes of 2024 they do not have posted online for us to see. Why did Mr. Foster wait 3 months to file a conflict of interest, knowing he had drilled test wells already on Redtown Ranch and Pine Bliss in 2023 and 2024? He already knew he was hired to drill these potential wells. Matter of fact, he's already drilled wells like this for Mr. Bass on Barefoot Ranch in LaRue. They drilled high-capacity wells. They completed hydrogeological surveys and installed a pipeline around the ranch as farm irrigation, but he was really doing his own private study. None of the Groundwater District Board meetings state Mr. Foster recused himself from discussions about these two projects. There was only once in the last year he abstained from a vote. Starting in November of 2024, he went into many closed sessions about these well permits, and there's no mention in the minutes that he recused himself. On July 18th, 2024, he voted on subject matters related to these well permits, the same day he acknowledged his conflict of interest. I would ask that maybe the Attorney General's office can look into this and make sure that there's not anything else going on behind the scenes that we haven't seen. And I'd also like to state that this is going to be a continuing issue. It's not just Anderson County and Henderson County and Houston County right now. I've verified in the last few days that the city of Dallas has been contacting landowners in northern Smith County along the Sabine River and attempting to buy their water rights from their property so they can get their water and send it to Dallas as well. And that's from the city of Dallas. So that concludes my testimony. I'd be happy to answer any questions.
Thank you. We'll hold questions for the end of the panel, but I'm sure there will be a lot for you, Mr. Calicut. Mr. Oliver, if you would, state your name, who you represent, and proceed with your testimony.
So my name is Wade Oliver. I'm a Vice President and Principal Hydrogeologist at EKI. We're a water resources science and engineering consulting firm. Quick administrative note here. I sent some slides in. I hope they've all been distributed to the group. My intent today is not to run through that as a slide presentation, although many of my remarks make reference to some of the materials in there. Some of the other slides I hope you find as useful references for you today and moving forward. The other administrative note is that I don't have an interest in the outcome of these applications, not professionally in terms of clients, and not personally in terms of my philosophy on these things. I've worked in the Texas groundwater industry for my whole career with applicants, or not applicants, with clients that are on the development side of things, and with clients that are on the groundwater management and regulatory end of things, including many groundwater conservation districts. So in that time, it has become very clear to me the interests of both of those parties, that there's significant value to those parties and the clients in the state of Texas to develop water and then meet the needs of today. It's also very clear to me that there is significant interest and value to the state of Texas in conserving water and meeting the needs of tomorrow. The balancing test in Chapter 36 of the Water Code actually lays that out really clearly, where it directs groundwater conservation districts when developing desired future conditions to provide a balance between the highest practicable level of groundwater production and the conservation, preservation, recharging, prevention of subsidence on the other end of things. Okay, so that's the balancing test that districts run through when they're developing desired future conditions. And of course, the obvious thing is it's a recognition that both of those things are valuable, but also both of those things are inherently in conflict. Okay, so so that's the background that I bring to this. My remarks are basically some basics about groundwater, which we've been learning a little bit for the last couple of hours, and also some specifics about these applications. But I come to you from the perspective of a hydrogeologist, of someone who does groundwater modeling, who has led joint planning processes across the state, and so I'm happy to answer questions along those lines. So in some ways, groundwater is really simple. It can be as simple as it's just wet dirt beneath our feet. It's dirt, or the water within that wet dirt flows downhill, or said a little more pointedly, it flows from areas of high elevation to low elevation, or high pressure to low pressure. Okay, it can be that simple. The thing with groundwater, though, is that there are many elements about it that are not intuitive once you start digging into it. I think the conversation earlier today about total estimated recoverable storage is a really good example of that. Because if I were sitting in your seat, I would be thinking, how on earth is it that the total volume of water in these aquifers is not one of, if not the most relevant aspects of groundwater availability? And then we've got people before me saying, it's probably 1% or less of the TERS that is useful before all of that pressure is bled off. I want to state here very clearly that I agree with that assessment, and I think that the total estimated recoverable storage serves to make conversations like this about groundwater availability more difficult than it does contribute to the question about groundwater availability. If you're still skeptical, if you total up the total storage across all the major aquifers in the state, it's about 11.5 billion acre feet. If you rule of thumb that we use 20 or so million acre feet per year as a state, at least over the planning period, it's a little less. That would mean that if it doesn't rain again, we've got hundreds of years of water just sitting there available for use. Okay, that's if the TERS meant availability. What I'm trying to communicate to you is that as a hydrogeologist, there's, outside of the Ogallala and shallow, highly transmissive, unconfined aquifers, it has very limited utility in these questions about groundwater availability. So keep that in mind. So that's the non-intuitive piece. The reason that is the case is because there's two main types of aquifers. There's unconfined, which I mentioned previously. Think of unconfined as shallow, near the surface, when the water level rises, it fills up more of the aquifer space, okay? It's filling up, it's replacing air, it's filling up. When it goes down, the reverse is true, right? Water goes down, leaves behind damp soil. A combined system, which is most of what we're talking about today, is an aquifer unit is typically deeper and it is overlain by a what's called a confining layer. It's typically clay or something where water cannot travel through it easily at all. And when you sink a well into a confined aquifer, the water level in that well rises above the top of the aquifer. So you would say the water level in the well might be 100 feet below land surface, but the aquifer is, the top of the aquifer could be 600 feet below land surface, all right? So it's that confining pressure that is why most of the most productive wells in the state are in these confining zones, because that confining pressure means that you can draw the water level down in that well a lot more than you could otherwise, which creates a steeper ski slope or whatever sort of you know, metaphor for slopes that you want, but it drives water towards that well, leading to the higher yield of those wells. It is much easier to deplete confining pressure than it is to deplete an unconfined system where you drain the pore space, okay? So that is why there's a big difference in response between unconfined and confined aquifers. In an unconfined aquifer, the cone of depression, which was a term used earlier today, maybe hundreds of feet, depending on radius from the well, depending on what the production rate is. In confined systems like this, the cone of depression can extend many, many miles, okay? So the responses to pumping of these different type of aquifers is really important. I've put a table in my slides that breaks down the Henderson and Anderson components of the pumping. I did not include Houston County because it wasn't in the groundwater district. Apologies to the Houston County interests in front of me. But this compares the model available groundwater for the Queen City and Carrizo-Wilcox aquifers in each county to estimates of current pumping. And that's for 2022. And then the difference between the two. So the MAG for these two counties together is about 61,000 acre-feet per year. Estimated current pumping is about 17,000 acre-feet per year. So there's a substantial amount of availability above the MAG. The Pine Bliss and Redtown Ranch applications to the groundwater district together, though, are about 50,000 acre-feet per year. So on its face, even without doing groundwater modeling, it's pretty clear that this is not consistent with the current desired future conditions. We talked about desired future conditions earlier, and that they're redone every 5 years, but most of them are articulated as and including these, as a drawdown over some time period of 50-plus years. So the way that districts respond to applications like this really is key to whether the desired future conditions are working as a forecast of future groundwater conditions or as a regulatory goal that is managed by a groundwater conservation district. The last few slides that I've included show some drawdown estimates through use of the groundwater availability model. I didn't do this modeling. This was done by the applicant. So nor do I have the model files to do some technical review on them. But in general, what you see is drawdowns of 100 feet or more within about 10 miles of the project. Obviously, this depends on which aquifer unit you're in. And then drawdowns of tens of feet out to about 50 miles from the project. And these are substantial drawdowns that go out a long way due to a significant amount of pumping. And so I'm in my remarks there to say that there's legitimate interest both in developing and conserving water. Fully recognize that this is obviously a very large project that would have, if implemented, very large impacts, and that I will add to your list of many considerations the precedent that this sets for what DFCs mean as a forecast or as a regulatory number for groundwater districts. Thank you.
All right. Members, any questions? Representative Ashby.
Mr. Chairman, well, that was a lot. So I think I'm going to wait, if I could, just pick up where you left off. So just to make sure that we're all clear on this, and this is specific to the hearing today with regard to the permit in the 3 counties aforementioned. But and I'm really glad you said what you said earlier about looking at the TERS, or the estimated recovery, because I've heard it represented by the applicant's attorney in our public hearing in Jacksonville that this would use less than 1% of groundwater in the Carrizo-Wilcox. And what you said very clearly is that the number that that's a smokescreen, that what we need to be focused on is the MAG, the modeled available groundwater. And according to the Texas Water Development Board and the local groundwater conservation district, they currently have, and you cited these numbers, 61,000 acre feet. They're using about 17,000 acre feet, which, if my math is correct, leaves us with about 44,000 acre feet to be utilized for future projects, consumption, etc. The application that's pending with the Natchez Trinity Groundwater District is for approximately 49,000 acre feet. So it is above what is available. And to your point about the regulatory and legal standing of a groundwater district in meeting the desired future condition, which is the policy that they are required to regulate, that they cannot do that legally with these numbers. And so I think the question a lot of people have is, why would the GCD do that? I guess let me ask it this way. Do they not have the legal authority to deny or at least amend this permit based on that simple fact alone?
So as a hydrogeologist, I don't really want to opine on the legal authority.
Come on, we're all lawyers here today.
for whether that, I mean, I'll say this. It seems pretty clear on this side. And the one thing that I want to add to that is that and I'm speculating here, but perhaps the political will is such in the district, again, total speculation, that they plan to update the desired future conditions to incorporate something like this, which goes to my comments about it being a forecast instead of a regulatory number. The district can't unilaterally update its DFCs, though it needs a majority of the groundwater conservation districts within groundwater management area 11 to do that. So, yeah, that's a group decision, not a single decision. If that were the path.
Well, I think, again, and I will move on from the questioning on this one, but I think that is the head scratcher for a lot of folks, not just in the affected region, but across the state, is how just common sense would dictate, much less the legal standing they have, why they wouldn't deny this permit, because what they're requesting in terms of the volume is not there, according to the state of Texas and the Texas Water Development Board. So that's one point. Mark, good to see you again. Almost didn't recognize you without your ball cap on. I told Chairman Harris, I said, you sure that's Mark Callicut over there? Good to see a new Summerfield boy get all dressed up. You, as you cited, you drill a lot of wells across the entire East Texas region. And you gave some great examples of what you're seeing in terms of the depletion of our aquifer, and this is multiple aquifers across East Texas generally. In your opinion, is there any scenario that if this permit was approved, that it would not have a significant and degrading effect on people all up and down East Texas? I think somebody said that the impacts would easily be felt within 50 miles of the aquifer, which is way bigger than the 3 or 4 counties we're talking about here today. Is there any doubt that this will have a profound and negative impact on East Texas?
There's no doubt in my mind it'll have a negative impact on East Texas. It'll destroy the aquifer.
Yeah.
For sure.
Well, I just, again, I think several members have talked about this, but I think that we as policymakers, we've got to be cognizant of what is happening around the state with these groundwater, these commercial groundwater projects, respecting private property rights, looking at the rule of capture, of course, and recognizing that we've got to make some policy decisions. And at the very least, give our groundwater conservation districts some teeth to do what everyone knows is right. And so, anyway, I appreciate all of your testimony today, and thank you for being here.
Senator Nichols.
Oh, well, I'd turned mine on and then I turned it off, but Trent was hitting kind of where I was going. I enjoyed talking with you, Mark, and I very much appreciate you coming down. And I wasn't going to get into the board actions. I was going to get into the practical. Your family's been drilling wells, as I understand, for 3 generations?
Yes, sir.
Yeah, that's a long time. So y'all have, and there are other well drillers in the multi-county area,
Yes,
I
sir.
would assume. And so y'all probably have a good feel, maybe better than the average person that would even be on a groundwater board, is what the practical impacts are to our aquifer. Would you say that would be fair?
Yes, sir. We see it every day.
Okay. I had read that the aquifer was slowly going down, but then when I started looking at some of the monitoring numbers, and then I talked to some other people, the amount that had dropped, like in Anderson County, for instance, like 90 feet in a short period of time. When I went back, started checking some of the monitors, I was saying it had dropped like 130 feet. But some of the things that you were mentioning were pretty shocking. You're talking about numbers, depending on where you are in this 3 or 4 county area, or even lower than that. So if you got with some of the other well drillers and compared numbers and put your own information together, I know they're going to be looking at hydrologists a lot and what those reports are, and you're going to have different reports. Some are going to be high, some are going to be low. But, and that's one of the first things you mentioned in your comments, that you can make some of the scientific data come out however you want it to look with statistical stuff. But nobody can argue wells are going deeper. And if you start sucking out that top layer of the aquifer and your pressure that you were referring to, it's going to get really hard. I know I was mayor there in Jacksonville. We relied heavily on our water wells for our communities, and most of the other communities in the area, I represent all 4 of those counties. It's critical. It scares them to death. And you've got some very valuable data. So I hope you would take some information, maybe look at some of your dad's work, maybe even your granddad's work on what those well levels were, call some of those others and gather that information up and share it with the groundwater board, because they're going to have a lot of information together and put a lot of data. So anyway, that's all I had. Thank you, Mr. Chairman.
Representative Bell.
Thank you, Mr. Chairman. Mark, question for you. Do you drill municipal wells too?
I do a very small percentage of municipal work, and what municipal work I do is for small rural water supply companies.
Well, you may be able to answer my question anyway. The question I have is, when you bid a contract, there's usually a test well component. You drill a test well, determine whether it has the chemical analysis to be developed at that level, determine kind of what the capability of pumping is, production capabilities are there. What happens to that test well if the determination is made to make a well there?
Sometimes the test well is plugged. They'll plug it with cement back to surface and abandon it. Sometimes the test well is saved and they can use it for a little extra well. It may make 40 gallons per minute, but it gives them an additional 40 gallons a minute to be putting into the tank. So it can go both ways.
So there's not an instance where that well is under-reamed and developed as the well?
No, sir.
Okay,
Usually not, no, sir.
okay.
Most of them are smaller diameter. Test wells are smaller diameter than what they're going to end up doing.
Yes, sir. So the other thing that, and I talked earlier with Texas Water Development Board, but when you drill a well, and I mentioned this earlier, do you check the production at whatever level you're supposed to be setting your pump at? Do you do logging of the well, and do you do chemical analysis?
Depends on the situation. Residential wells, there's no logging. There's
Right.
some people do chemical analysis. On a municipal well, you're going to do logging. You're going to do you're going to have the water tested, and then you're also going to do a pump test. You're going to do at least a 24-hour pump test, sometimes more.
Yeah, 36-hour development, whatever.
Yes.
Yeah. So to Senator Nichols' point, I guess, this is what I was talking to Water Development Board about. I mean, we have people like yourself drilling wells on a regular basis. We should have a dynamic understanding of what's happening, and that dynamic understanding should come in every permit application and the information you have to submit in the follow-up of a commercial well or a municipal well. And residential, that may be a different conversation just because of the nature of how we treat residential wells versus other more high production wells. But anyway, that just is kind of following up on Senator Nichols' comment, not so much for a response. But thank you for your testimony, both all three of you. Thank you, Mr. Chairman.
Senator Perry?
Thank you, Mr. Chairman, for having a hearing that is getting a whole lot of members involved in water conversation. And truthfully, it is a void that we need to get serious about. So specifically on the hydrologist, gentlemen, I didn't get your name, and I'm sorry.
Wade Oliver.
Wade Oliver. So you said 11.5 billion is the estimated total reserve
From the major aquifers.
from the major aquifers. Do you have the estimated recoverable?
So the way that recoverable is laid out in the administrative code is that's 25 to 75% of that. So it would be,
So it goes back to the very thing I was hitting at earlier today with Water Development Board, that the GMA in there. And I've heard kind of similar comments about the 11. Usually, it's funny, when the science is on side of the production seeker, it's good. If it's not with them, then science is all a matter of what lens you're looking through, whether it's good science or bad science. But in that analogy, you've got a huge gap, and we're making plans around huge gaps. But I've heard the 11.5 referenced as, what are you worried about, Perry? We got all the water in the world. And that's just a false. And you make the point so eloquently. If nothing else you learned today, members, you don't focus on total reserves because it's not, you can't develop it. There's a whole kind of reasons you can't. One, you just can't for some reasons of technology and things. But if you develop it wrongly, you end up creating sinkholes. So there's just a whole lot of science involved in this. So I really appreciate your testimony and the way you laid it out. But I found in the 10 years down here on the water side, if science works for you, it's good science. If it doesn't work for you, it must be bad science. It doesn't matter which lens you are. So that's the challenge we have. Do we trust the science? And the truth of the matter is we've got as good a science as we can afford to have. But you make the point that anybody in this panel should walk away with. You can't go get what they say we have. Even if it's true we have 11.5, we'll never touch it. And then you're playing with 25% of it up to 75 of it. Somewhere in the middle is probably where it's at. But either way, you lose 25% under any scenario. And depending on where it's at and what kind of aquifer is, it may not be able to get to anyway. So it's just, you did a really good job. I appreciate, your way you laid that out scenario.
Thank you.
Dr. Buckley.
Yeah, thank you, Mr. Chairman. Mark, as a driller, do you report your findings when you drill a new well, or you have to, go deeper or whatever to the groundwater district if the well is contained within the boundaries of a district?
Yes, in a groundwater district, I have to first apply for a permit to drill the well, whether it's residential or municipal, or irrigation, either one, no matter the use. I file an application for a permit. They review it, they approve it, notify when I'm going to drill the well, notify when I'm done, and then every well, whether there's a groundwater conservation district involved or not, I fill out a state well report. That goes to Texas Water Development Board. And then certain groundwater districts require extra information. So Natchez Trinity Valley Groundwater Conservation District, I provide a driller's report where it's got information about the hole sizes I drilled and the amount of sand and the amount of screen I ran and different things about the well. And then a pump installation report that has all the information about the size of the pump, where I set it, total dynamic head calculations, the productivity of the well, and those sorts of things.
So that information then can be used by that groundwater district. It's kind of real-time, real-world information, right, for them to make decisions moving forward. And to me, I'm certainly not a well digger or driller, but it is kind of, I guess, real contemporary information as to the condition of that aquifer. And trends, you can see trends amongst the data.
It'd be more useful for trends, as far as, using that data to project maybe how much water that well can make or the aquifer would make right there would be a little bit iffy, because we're putting small residential pumps in that make 15, 20 gallons per minute. We know for sure that well will make 15, 20 gallons per minute, but it might possibly do more.
Yeah.
And we don't know that because we're not putting a bigger pump in it, and we're not doing 36-hour pump tests.
But if you, and maybe I have the science all wrong, but if you were to report a trend that you're having to go deeper, and that the amount of water recovered is becoming less and less, or the speed or the number of gallons per minute, if you're reporting that to a groundwater district, is it not accurate that the implementation of a large wholesale permitted water project, I just don't, would most likely have impact on those small folks?
Oh, for sure.
Okay, so that's really important information for a groundwater district in areas. I have a well at my house. That's the only source of water we have on my house and ranch in the Middle Trinity, and it is a less healthy aquifer than it was many, many years ago. And so I find the information that you're providing to someone in the real world to be very important and to be considered, I believe, by a groundwater district in terms of the overall number of straws in the ground, if you will. So thanks for being here. Appreciate it.
Thank you. Members, any other questions? All the questions I was going to ask were already taken by the other members. So thank you all very much for being here. It's very informative. For the audience, I know it's very warm in here. It's extremely hot. The State Preservation Board is working on fixing the air conditioner. What a heck of a day for it to go down today, but they're actively working to make sure that we get some cool air pumped in here. We do have the overflow rooms and the AC is working in those rooms, just not this one. I'm going to go out of order really quick, just one time, and then get back on track to accommodate a travel schedule. So at this time, the chair calls Dr. John McCall. Dr. McCall, thank you for being here. If you would state your name, who you represent, and proceed with testimony.
Thank you, Mr. Chairman, members of the committee. My name is Johnny McCall Jr. I am a commissioner on Texas Parks and Wildlife. I'm not here representing Parks and Wildlife. We have not taken a position on this. I will be asking for this to be put on the agenda in August of our Parks and Wildlife meeting. I'm really concerned about the fragile ecosystem of our springs. Some of the better flowing springs come up, as the gentleman was talking about, through pressure points. And those are some of your better springs, like Hayes Springs out of Grapeland, which is almost legendary. I think we will see springs like that the wildlife are dependent on potentially go away. But I'm here today not talking from Parks and Wildlife, but as a neighboring landowner to Redtown Ranch and LLC. When I say neighboring, I share a fence line with them. So I have a long relationship with all the previous owners of Redtown, to the extent we were all good friends. I've hog hunted with them, had a rifle range over on their place. I mean, When the new owners came in, I've had zero contact with them at all. Found out this, I guess, the same way y'all did, just because it just happened to surface back up. But this will create a zone of depression. Now, I don't know how far that's going to go, but I know it's going to come over the hill to me, because that's where I'm going to be, and I rely on that for the wildlife. We have a wildlife exemption. We've actually been designated a wildlife preserve. My dad has planted, in his lifetime, over 5,000 live oak trees. We have wells that supply for the wildlife, for the ducks, and we have seen, I can remember back in the 70s when my dad first drilled these wells, they were free-flowing wells. And nothing's free-flowing anymore, but the submersible pumps that we have to put in there have to go deeper and deeper and deeper. And as Mark just stated, as a well driller, I mean, I'm telling you, it is what it is. You have to go deeper with that to reach the water. So the rule of capture, I know the Texans are very proud of the rule of capture, and we've got it, we own it. Cattle ranches depend on this. I am from Houston County. We are the county without the water district. I can assure you we will be closing that loop. I made a mistake of attending a meeting here recently and came out the chair of the exploratory committee on that. So when we do pass, if we come to the legislature, I think it will be an advantage for us having not had this before, because we looked at this issue, I don't know, 15 or 18 years ago and decided not to go with it. We would not have had a district we could have taken to the legislature and anticipated the problems that we're having right now. So I think we can. Some districts are written a little stronger than others. I think we have the opportunity to come to the legislature with a much stronger district there that would do. Houston County is the second largest cattle producing county in the state of Texas. This is going to be devastating for some of these ranches. Since the rule of capture, Mr. Chairman, as you stated, what's changed in 121 years? High-capacity pumps, increased power delivery. When that was written in 1904, we didn't have what we have today. And the rule of capture, I don't think was ever meant to stick a straw in the ground and take it all. That was not what it was meant to be back then. And that brings us to regulatory takings, and I'm glad this legal theory was explained, because I won't have to lay near as much foundation down. But basically, under regulatory takings comes nuisance takings. And nuisance taking is when you take a resource that devalues your neighbor's property. And that's pretty much what we're talking about here. Specifically, the doctrine of nuisance-based takings consists of cases where the government or a third party acting pursuant to explicit government authority, which is what's happening here under the rule of capture, uses its own property in ways that interfere with the ability of others to use and enjoy their properties. This legal theory really came about as I was studying this back in the 1960s with the Pennsylvania coal mines. They had rule of capture there, but it had to do with coal because it was such a valuable resource. So basically, if you went in and hit a strain of coal, you could follow that vein even if it went outside your property line. And that's how valuable coal was. Problem is, some of those veins went under houses. And that initiated some lawsuits, because I think all of us here would have a problem if our house suddenly had a coal mine under it. And so that went into the legal courts, and they started getting some legal redress from that. Before it was mentioned, there have been some regulatory takings lawsuits. The City of Del Rigo versus Clayton Samcold Hamilton Trust in 2014. The court ruled that drilling a well that unreasonably interferes with a neighbor's access to groundwater may constitute a nuisance. It opens the door to tort liability. As I mentioned, I think Texans have always been proud of our rule of capture, but I do think it must be updated with safeguards. The rule of capture was never meant, as I mentioned, to drill a hole and take it all, just because it's below you. So, members of this committee, the balance between rule of capture and regulatory taking will be decided. Do we want this decided by the courts, or do we want thoughtful Texans to solve this ourselves with the legislative process? I have complete faith in the legislative system. I have complete faith in Governor Abbott to foresee that we have problems here and give us guidance on that, I have less faith in the court system. So thank you for allowing me to testify in front of you. And again, I'm testifying as a neighboring landowner to the Redtown LLC.
Thank you, Mr. Chairman. Commissioner, good to see you again. Thank you for being here. Thanks for your patience. First off, appreciate your friendship. So I was glad to hear you say that as newest commissioner on Parks and Wildlife that you're going to ask this to be put on the August agenda to talk about, because clearly, not just with respect to the state parks throughout the region, but certainly our wildlife across the state that's owned by the public, that needs to be a consideration, and the impact this would have on those springs and other water resources you cited earlier. I have just a simple question. I know you're an adjacent landowner, and you and I have talked a lot about this, but you're also a resident of the oldest county in Texas, Houston County.
I am.
My simple question is, are you aware of anybody in Houston County that is for this project?
No.
Thank you.
And I will tell you that the Redtown Ranch, just to give you a little bit of history since you haven't lived next to it like I have, originally this was a 15,000-acre ranch owned by Vernon Calhoun out of Palestine. And when he sold it in two tracts, one to Redtown, one to Puzzlewood. One over 7,000 acres, the other over 8,000 acres. The 8,000 acres is a huge, Puzzlewood is a huge cattle ranch owned by a gentleman out of Switzerland. And that is for sale right now. And it wouldn't be for sale if he was not happy with, what it was generating on income. If this first domino falls, what's to keep Puzzlewood from going in there and saying, wow, this is the answer to all my problems? You think somebody that lives outside of Houston County or outside of our neighboring aquifer may not care about us? What do you think somebody from Switzerland's going to care about us? It's all about money. So this is a domino. If this first one is allowed to fall, it's going to keep falling, and it will totally collapse this aquifer. Thank you.
Mr. Money.
Thank you for your testimony. You said something, and I misheard you the first time, but I think it works both ways. You said the rule of capture was not intended to take it all, but I think the rule of capture also was not intended to take it off, carry it away somewhere else downstream. And so the idea of rule of capture generally was to use it where it is, whether that's watering your crops, providing water for your family, and to take all the water from one area and put it toward another area is a concern of mine. And as we, as state legislators, look for a solution here, especially the people sitting behind me who are on the committee, and we are thought to take a state approach, I want to remember your testimony as a local person impacted who went locally to develop a groundwater conservation district. And I hope that we look to empower the locals to address some of these problems that we have discussed here today, and not just try to do a statewide solution where people like you and the people in this room have to come to the state to decide what's best for your area of Texas. Thank you.
Thank you for your comments. I agree with you 100%.
Dr. McCall, is there anyone else who wants to ask questions before I go? All right. Dr. McCall, as the adjoining landowner, do you have any water wells on your property?
I do. We have 6 water wells. 3 of them are in use right now. One of them continual use to basically run my ranch house, my ranch, and what we do there. And the other are used for wildlife, and they're sporadically on and off depending on the season.
How deep are they?
They're roughly, give or take a little bit, around 470 feet.
Okay, all right. So if we have a cone of depression around the well field, proposed well field, that's 500 feet, that's going to affect you a bit.
I'm dead. We've already, our primary well, which runs the ranch house, we've had to re-drill that one time already, but it's probably not going to be deep enough now. So that will be a problem. I lease that with a business that I have, a rifle scope business, and we go out and a rifle range, take customers out there, shoot out 1,200 yards. You guys would like this, and I know my good Senator Robert Nichols likes that, being a big hunter like me. But I mean, when we lose water there, we can't flush the commodes. I mean, it's gonna have an impact.
I'd like for you to speak a little bit more, and not necessarily, I'm not asking you to put your Parks and Wildlife hat on by any means, but as a landowner who uses that water, the springs, everything like that, for the wildlife. I think that's something that might be missed by a lot of people on the potential impact if we lose artesian pressure in this aquifer system, what that could mean to who knows how many springs out there that are feeding creeks, feeding ponds, creeks that are feeding the river. What do you think the impact could be? Let's just talk on your ranch, to the wildlife population, birds, everything else that are dependent on that artesian pressure.
I think it's gonna be devastating. I do border the Trinity River, so we've got that aspect of it. We have, probably 6 duck ponds that and we have a piping system through there that brings it all the way to the front, which ironically is the part that's closest to Redtown LLC right now. And we can, it's probably over 1.5 miles of piping that we've laid through there, and we can pump water all the way up there. Now we have the deer they depend on that water up there. So it's either that or 1.5 mile walk back to the river.
Yeah. Thank you. Mr. Bell.
Thank you. You brought up something that's somewhere between a comment and a question, but talk about bordering the Trinity River. I border the Trinity River too, a little bit upstream from you. But the Trinity River has junior and senior water rights in it, and and so one of the things when you mention springs and spring-fed creeks that feed the river, if we lose the artesian pressure, then we are affecting the junior and senior water rights in the river. So it's a bigger point being just, this is a massive conversation. Any piece of it creates it's like Tetris, the little game, except with either thought out consequence or just a chaotic outcome. But if we don't figure out the answer to this problem, then we will reduce the amount of water flow in the river. When we reduce the water flow in the river, even though the rule of capture might allow that to happen outside the river basin, then we're taking the junior and senior water rights that belong downriver. It's a complex problem that I think we need to come up with a statutory solution to sooner than later, not just to protect your water wells and everybody else adjacent to what might be a fast or high production well, certainly a model that will, I think, be seen continuing to expand as private sector seeks to take advantage of the monetized nature or monetizable nature of water. But obviously those springs, deer water out of them, all kinds of species water out of them, cows, we have all kinds. What is the what is the ultimate problem with losing those springs? Is it that our wildlife moves away from and finds that water somewhere else, and we're left with a totally different scene? What is that consequence of those springs being depleted?
Well, Representative Bell, that's a great observation. I have a spring on my property that flows into the Trinity River. There's untold amount of springs up and down there that help supply that. Those of us that live in East Texas will remember the drought of 2011, which was a 100-year drought. And we still had that spring that I've got flowing in there. As a matter of fact, some trees started growing around it, just stopped flowing because the root system sucked it all out. We cleared them all out and it started flowing again. It's a fragile ecosystem. And we have no idea how many keep that river flowing in a time of extreme drought. And we do have extreme temperature shifts right now and weather shifts. So I'm telling you, we're in a wet pattern right now. It's not going to last. And it's going to happen again. So those springs, you're right, the wildlife's going to have to move if they depend on that. But that's an area that not a lot of has been talking about is our fragile spring system. Most springs are water that's trapped, kind of think of it as a shallow aquifer that can't get into the other. The big springs are because there's a fissure under pressure, and maybe that shallow spring that's already there is being fed by the carrizo. And we won't know it's not there till it's not there.
Or at least pressurized by the Carrizo.
Right, exactly. And that's how you get the big springs that flow into lakes, and I mean, they form their own creeks. It's amazing.
And the bottom line is, wildlife can't live without water.
Can't live without water.
Humans can't live without water. Land without water is not very viable. Thank you for your testimony.
Yes, sir, thank you.
Anyone else? Thank you, Dr. McCall. Appreciate you being here to testify.
Okay, Mr. Chairman, thank you.
All right, to accommodate a flight schedule that is about to be missed, I'm going to move one more. Chair calls Ben Matthews. Mr. Matthews, please state your name, who you represent, and proceed with your testimony.
Good afternoon. My name is Ben Matthews. Before you today, I represent the following public water systems and rural utilities. The cities of Rusk, Troop, and Crockett, the Houston County WCID number 1, and the following water supply corporations: Norwood, Concord Robbins, RPM, Kraft Turney, Virginia Hill, Rusk Rural, Walston Springs, Alto Rural, Dialville Oakland, Maydell, Bethel Ash, and Anderson County Cedar Creek Water Supply Corporation. Good afternoon, Chairman, members of the committee. Thank you for inviting me to speak. Thank you for the accommodation. My law practice is solely devoted to water and public utility law. This afternoon, I represent these individual interests before this committee. These are not large corporations. These are small systems, local systems, that have been built over generations to serve their communities. They've invested in wells, pipes, and pumps to deliver their water reliably and affordably to the people who live there. Today, their ability to serve may be in jeopardy. Our first concern is the risk of harm from high-capacity groundwater development. When massive amounts of groundwater are pumped from the ground and sent miles away, aquifer levels can drop fast. That drop, which we have learned today, we call drawdown, doesn't stop at the fence line. It doesn't stop at the county line, and it doesn't stop at the boundaries of a GCD. It affects every well around it. And when that happens, my clients, these small rural utilities and municipalities, are the ones who pay the price. They pay for broken pumps and failing motors, for deeper drilling or new wells or water treatment. They were here first. They shouldn't be punished for somebody else's profit. The applicant has portrayed itself as being poised to solve a statewide problem, moving water from where it exists in abundance to places where, in their words, it is often most needed. That language, taken directly from the applicant's public-facing materials, casts this project as a public service. But make no mistake, this is a private, for-profit groundwater export operation. The PR is polished, but it doesn't change the core facts. The applicant has signaled that exporting groundwater is a planned part of their phased-based project. And moving water out of one region to sell it somewhere else has real risks. Their models say there won't be meaningful aquifer drawdown. But models, as we have learned today as well, are not guarantees. They're built on assumptions that can be wrong. We've all seen that happen. Let's be clear. It's worth noting that the applicants plan to drill exploratory test wells to validate their hydrologic assumptions. But test well data is not the same thing as 20 years of continuous pumping and large-scale drawdown. There's no guarantee that they will reflect what will actually happen to the aquifer once extensive and sustained pumping begins. It's important to recognize the MAG, the Modeled Available Groundwater, is not a perfect tool. You've already heard as much today. The Texas Water Development Board has acknowledged that the MAG values are based on long-term average conditions. They don't necessarily reflect what happens during drought or under sustained high-volume pumping like what's being proposed here. That's why the board developed something called the MAG peak factor to allow temporary pumping above the MAG in certain cases, But even that doesn't apply automatically, and it's only available if explicitly approved. On top of that, there's an ongoing mismatch between when the MAGs are updated and when groundwater districts are required to adopt or revise their plans. That disconnect leaves districts planning with outdated or incomplete data, and addressing that will likely require your action. So the question is, what if the modeling fails? What happens if neighboring wells are affected? If drawdown is worse than predicted? What commitments has this company made to those landowners, to the communities that will be left dealing with the consequences? If the applicants truly believe that this project is low risk, they should have no problem supporting a real mitigation framework, one that actually protects the people that are on the ground. Here's what that could look like. A mitigation fund that is evergreen, meaning it stays funded and available 10 or 20 years down the road from now, no matter who owns the project. Terms written into statute, not left to private contracts. And a clear and accessible process for affected well owners to get compensated without the need to lawyer up. Our second issue is the importance of local groundwater control. Texas has, as we have learned, a unique system of groundwater conservation districts. It's a good system because it works. Local boards, elected by local voters, managing local water. They understand the land, they know the aquifer, and they are accountable to the people that they serve. But when large-scale export projects like this one are proposed, the decision-making often shifts beyond the district's reach into broader regulatory or policy arenas. That's why it is critical that local districts not only retain their authority, but they also be given the statutory tools they need to respond effectively. The legislature can support this by ensuring districts have the authority not just to require mitigation plans, but to set export fees that realistically reflect the potential for long-term impacts, especially in cases where the current statutory limits may fall short of actual mitigation needs. Allowing districts to revisit permits based on new data or unanticipated drawdown, and giving them greater flexibility in enforcing production limits and managing impacts over time. Local control is not just a principle. It's the operational foundation of groundwater management in this state, and it only works if we give the districts the tools to do the job. Our third concern is ensuring that the groundwater conservation districts actually use the tools that they have to protect existing wells. Districts like the Neches and Trinity Valleys GCD already have authority to collect production and export fees. But those fees are only meaningful if they are tied to action. If a permitted project causes an existing well to fail, there needs to be a timely, transparent response, not just after-the-fact reports or deferred studies. The legislature can help reinforce this by requiring clear public mitigation protocols for responding to well impacts, by clarifying that fee revenue should support real mitigation, including well repair or replacement where appropriate, and supporting administrative remedies that don't force landowners into costly, drawn-out legal fights just to protect their groundwater. Protecting existing wells is not just a regulatory function. It is a test of whether this system actually works for the people that it was designed to serve. In closing, on behalf of my clients, we urge the legislature to take 3 simple, effective steps to protect local communities. 1, mandate impact mitigation. If a permitted groundwater export project causes harm to a well, there should be no ambiguity. Mitigation should be required. 2, align the fees with real-world costs. Production and export fees must be sufficient to fund actual mitigation needs, not capped below what real protection requires. And 3, affirm that local supply comes first. No export project should proceed if it threatens the sole or primary drinking water supply for a town, rural water system, or a school. These aren't radical changes. They're practical, protective measures that are grounded in the values that Texas has always claimed: local control, responsible stewardship, and putting communities first. This committee, this legislature, has a role to play. You don't have to accept the applicant's word that everything will work out. You can write protections into the law and give regulators the tools to act when problems arise. At the end of the day, this is not about opposing progress or innovation. It's about making sure that if the water runs out, the people left high and dry won't be the ones who had no say in the deal. Texas stands for fairness, accountability, and local decision-making. Let's make sure our groundwater laws do the same. Thank you for your time. I welcome your questions.
Thank you. Representative Berry.
I want to thank you for coming out today, and it sounds like you have a plane to catch, so I'll be brief. You talk a little bit about local controls, but more importantly, you mentioned that your clients were small municipalities and private water systems. Is that right?
Public water systems, yes, sir.
Right. And it's fair to say they probably have a plan to update their water systems or maybe deepen their water systems as time goes by, long-term plans, right? Maybe 10-year, 15-year, 20-year plans. I know that our cities do, so most of them do, I would assume, right? And so when we have takings of this sort, it expedites those plans. Wouldn't that be fair to say?
Yes, sir. It would be fair to say that and more. It would also be fair to say that in some instances, we have clients who know that if the time comes to deepen the well, that deepening the well is not an option. Because of the way that the well was originally constructed, a brand new well would have to be drilled, even if it was 5 feet to the left of the existing well.
No, I understand that, and that's a fair point. I guess my point is the cost that it would the burden of the cost associated with updating those wells and/or moving those wells, and the shorter timeline for them to actually have to do that maintenance would bear a cost, right? And how would they recover that cost?
They would recover that cost through rates.
Through either rates or bonds, if they're capable of selling bonds to be able to replace those. And bonds are long-term debt associated with the cost of projects and things of that sort. So I think it's fair. It's obvious to me that when you have a large taking like this that's going on, it's fair to say that it does impose an unfair burden to the small and private municipalities for their water systems, and those are very, very expensive. And then, God forbid, you have to somehow convert to a surface water treatment facility, which again is another very expensive endeavor. It takes a long period of time to be able to do. So your point is well taken with me. I appreciate you coming out to make that point. Thanks a bunch.
Thank you, Representative.
Thank you. Anyone else? Mr. Matthews, you may not be able to answer to the number, but roughly, by estimate, how many citizens or customers do you think the total of your clients serve?
I have asked for a collective amount of that data from my clients. I don't have that at this point in time, so I don't want to give you a wrong number. Right? It is in the thousands, for sure. If I may add, I know you're about to make one more point. Most of my clients are nonprofit water supply corporations, which means they don't have some sinking fund or massive bank account that is just set aside for one day if we need to re-drill all of our wells.
And their only option is to raise rates. in most cases, right? Several of them can't go out for bond.
There are worlds where they could attempt to apply for Texas Water Development Board funding or apply for a hardship or buy water from somebody else. But effectively, the most accessible tool to most of them, and the one that I would expect most of them to move toward, is to find themselves in debt for having re-drilled the well and raising rates to cover the cost of that debt
So
service.
even if they go out for bond or they take out a loan, rates are going to increase.
That's correct.
And so, I mean, you guys who represent both rural and urban communities, you know how many constituents we have who are on fixed incomes who an increase in your water bill affects whether or not they can eat that month or that week, whatever it is. So this affects people at the very most minute level in their daily lives. How many of your clients have wells servicing these customers that are inside the depression cones or the proposed depression cones between these two properties?
A very significant number. And as I have also stated, as we recognize, those are just what the models demonstrate.
Yep. Okay. Thank you for being here. Appreciate your testimony.
Thank you.
The chair calls Matthew Semank, Marty Kelly, Ron Hudson, and Kevin Ward. Gentlemen, thank you for being here today. We're going to start with Texas Parks and Wildlife, then TDCJ, then Trinity River Authority in that order. So let's start with Matthew Semank. And if you would, state your name, who you represent, and proceed with your testimony.
Well, excuse me. Thank you for having me here today. Yep. So my name is Matthew Semank. I work for Texas Parks and Wildlife Department. So I'm here today as a representative of what we call the Middle Trinity River Ecosystem Project, which encompasses 5 wildlife management areas. And it totals about 38,000 acres of state-owned land in Anderson, Freestone, Navarro, and Leon County. So that's what I'm responsible for managing and representing today. Each of these state-owned properties is carefully and thoughtfully managed by the department for the benefit of Texans and for the best possible wildlife habitat, including aquatic habitats and the expansive Trinity River bottoms, creeks, and springs. One of the agency's most important habitat projects is on Richland Creek Wildlife Management Area along the banks of the Trinity River, and that's where I come from. Your Texas Parks and Wildlife Department began a partnership with Tarrant Regional Water District on that property in the mid-1990s, and our goal was to come up with a solution to the water supply needs of a growing Texas. One of our goals in this partnership was to reduce the need of additional reservoirs throughout the state, therefore preserving farms, ranches, and wildlife habitat, originally viewed as an alternative to reservoir construction. Our wetland filtration solution is officially known as the George W. Shannon Wetlands Water Reuse Project. It authorizes the diversion of about over 105,000 acre-feet of water from the Trinity River onto the state-owned wildlife management area, Richland Creek, where we constructed about 2,000 acres of wetlands that we use to clean the water, remove the nutrients from the water, before we divert that water into Richland Chambers Reservoir, where it's used as a component of the water supply for Tarrant Regional Water District. So this is a partnership between Parks and Wildlife and Tarrant Regional Water District. So it's an important component of the water supply to 2.5 million people. So ecologically, you can consider wetlands as like nature's kidney system, so to speak, where they remove phosphorus, nitrogen, and other nutrients and act as a water treatment facility. So the wetlands act as a water treatment facility. It's just nature's version of it. So at maximum capacity, this system can add an additional 90 million gallons of water a day to Richland Chambers Reservoir for water supply. This wetland project, it was completed in 2013, and the 2014 drought made this project a critical component of Tarrant Regional's water supply. During that year, if you remember, 2014 was just a really dry year, and so that wetland system, we had it pumping at near full capacity, and it supplied 20% of Tarrant Regional's water just from that one wetland system on the state-owned property. So a near identical system is also constructed on the East Fork of the Trinity River. It's known as the John Bunker Sands Wetlands, and it's operated by North Texas Municipal Water District. And so that one increases the water supplied for Lake Lavon, so that goes to the DFW area as well. And then a third wetland system is going to be constructed. It's currently in the planning stages by Tarrant Regional Water District, and I give credit to them for kind of help pioneering this concept. It's going to be constructed adjacent to Cedar Creek Reservoir. And last estimates was they'll begin construction about 2028. So that would make 3 of these reuse wetlands. The economics of these projects are of critical importance to Texas. So we're able to provide water, the water districts are able to provide water at a fraction of the cost. When you look at the Regency strategies, and I included some of those in my testimony, you know, if you kind of sort through those, the reuse concept is much more economical than a lot of these other concepts that Regency has. Now, there's going to be some variation in there as far as specific projects may cost more than others, but in general, they've been more economical. So, for example, the wetland that I come from originally in the dollars that we were talking about, 2010 dollars, it was about 63 cents per 1,000 gallons, and then the Cedar Creek one, they anticipated that one according to the Regency plan. It's going to be about $1 per 1,000 gallons. So, in general, these projects are pretty economical, which is important to Texans. Because your Texas Parks and Wildlife Department is involved at the project on Richland Creek, on the wildlife management area, we manage these wetlands for maximum wildlife benefits. Some of these wetlands are some of the most productive wetlands in the state in terms of how we manage it as far as productivity for wetland wildlife and waterfowl. It also has outstanding public recreation benefits and waterfowl hunting, so we provide all that, and as your state of Texas Parks and Wildlife Department, we manage all that for the use of the public. So we're proud, Parks and Wildlife, we're proud of the 3 decades that we've invested into this concept. It's over, again, this is over in Freestone and Navarro counties, so this is not what we're talking about today. We're proud of the 3 decades that we've invested in our time and our labor and developing this concept on behalf of the people of the state of Texas. So the wetland reuse concept, we view it as a win for Texas. We view it as a win for rural Texans, a win for urban Texans. They get the water. Rural Texans get the recreational benefits. Human needs are met. Wildlife habitat is created or enhanced. There's no negative benefits or no negative issues with this. I mean, we're making things so much better out there. It's a fraction of the cost of alternatives, and it doesn't threaten rural communities. So as Parks and Wildlife, it's very important that we work with the private landowners. Those guys, our district biologists work with these guys every day, and supporting farms and ranches is very important to us. So an issue like this where we can maybe have a platform and talk about the things that we're doing that are really good for Texas as far as looking forward, as far as the water supply. You know, I just really do appreciate you allowing me to be here to highlight this project and to talk about this as the future of Texas, and as you guys are here today contemplating this very important issue. And with that, I can take any questions.
Thank you. I'll come back to you with questions. Mr. Kelly, please state your name, who you represent, and proceed with testimony.
Good afternoon, Chairman and members. For the record, my name is Marty Kelly. I am the Water Resources Program Coordinator in the Coastal Fisheries Division with Texas Parks and Wildlife. And I've been invited here to talk about the differences between groundwater and surface water and their respective regulatory constructs. And I think we've talked quite a bit in previous testimony about groundwater and the rule of capture, so I'm not going to revisit any of that. But I will mention briefly surface water, which is regulated through the legal doctrine of prior appropriation, which is often referred to as first in time, first in right. So simply put, this means that the older the water right is, the more senior it is to get in line to exercise the right to appropriate those surface waters, which are also known as waters of the state. I'm also going to talk about surface water groundwater interaction. So we've discussed that surface water and groundwaters are regulated separately, but often are connected hydrologically, so out on the landscape. One of the most common interactions between surface water and groundwater is through streams and rivers. So the hydrological connection can be characterized as gaining streams and losing streams. A gaining stream is a stream that receives water from emerging springs and seeps, and typically they hold water, flow year-round. A gaining stream is one that can lose water through the stream bed back down into the underlying aquifer. And those losing streams can sometimes go dry or have lower flows. Some streams and rivers that flow over variable geological formations have sections or reaches that are gaining and losing. So a stream can have multiple sections that are considered gaining and losing. Understanding the geographic extent of the gaining and losing reaches of streams and rivers can help more effectively manage water and aquatic resources. So part of Texas Parks and Wildlife's mission is to manage and conserve the natural and cultural resources of the state. In Texas, we have what we call species of greatest conservation need, or SGCNs as an abbreviation. These are state-identified species at risk that may lack legal protection, but are prioritized for conservation and planning in the state. Texas SGCNs are important because they help guide proactive conservation efforts to prevent species from being federally listed, so protecting biodiversity before populations reach those critical declines. In the Trinity River ecosystem, in this whole basin, there are 89 native freshwater fish species, including 9 species of greatest conservation need and 1 state-threatened fish. There are 29 freshwater mussel species, including 14 SGCNs, 5 state-threatened freshwater mussels, 1 federally threatened, and then 2 that are proposed for federal listing. And I have provided in my written testimony a table that outlines the SGCN species, both fish and mussels, that are in the area that we're talking about today. And again, I've provided more written testimony that goes a little deeper into the differences, and that concludes my testimony, and I'd be happy to answer questions when appropriate.
Thank you. Mr. Hudson.
Yes, sir. Mr. Chairman, members, representatives, senators, my name is Ron Hudson, and I am the Director of the Facilities Division for the Texas Department of Criminal Justice. I am here as a resource witness to testify on the posted topic. As you are aware, the Texas Department of Criminal Justice touches upon incarceration, parole, and adult probation. The agency is responsible for over 100 prisons, almost 138,000 incarcerated individuals, the parole supervision of over 75,000 individuals, and the oversight of the 122 local community supervision and corrections departments, better known as probation. The agency operates 12 prisons in East Texas, where over 23,000 individuals are incarcerated and over 4,700 East Texas residents work. These prison units also manage agricultural, livestock, and crop operations, which offsets the state's appropriations to the agency by $59.6 million. TDCJ operates several manufacturing operations within these prisons of goods and services to support key state functions such as TxDOT road signs, TxDOT dump trailers, and TxDOT dump trucks and trailers. Given the proposal for high-capacity and large-volume groundwater production in the Natchez and Trinity Valley Groundwater Conservation District, this means, along with other units in Houston, Rusk, Freestone, and Madison counties, may see its direct water supply impacted. There are 7 TDCJ prison units depending on water directly from the Natchez and Trinity Valley Groundwater Conservation Districts. In addition to the 7 units within this GCD, there are 5 East Texas prison units dependent on water from the Carrizo-Wilcox Aquifer. In total, these 12 Texas prison units depend on water from the Carrizo-Wilcox Aquifer for consumption, agricultural, and domestic uses to operate and maintain public safety. Thank you for allowing me to speak today, and I will be available for any questions once everybody's done.
Thank you. Mr. Ward.
Well, good afternoon, Chairman Harris, Vice Chairman Martinez, members of the committee, as well as visiting senators and House members. My name's Kevin Ward. I serve as the General Manager for the Trinity River Authority of Texas. I really appreciate this opportunity to appear before you and provide my testimony on the impact of high-capacity and large-volume groundwater production in the Natchez and Trinity Valley's Groundwater Conservation District. So I'm going to try to summarize this instead of just reading it. I was going to read it, but for the benefit of time, I won't. But suffice it to say, we're fairly large. We serve about 2.2 million Texans in the state of, so we're pretty big. And then we are a partner with the city of Houston in Lake Livingston. And Lake Livingston was constructed in the 1960s. Houston owns 70% of the water in it. We own 30%. But we've contracted with Houston for the majority of that water. We also hold, and the water rights in that are 1.2 million acre-feet of water. It's the only water on the main stem, the only lake on the main stem, so it collects all this water we're talking about today that comes downstream from all the creeks and from all of the springs and that. In addition to that, TRA has 246,000 acre-foot of water rights from our return flows from our wastewater treatment plants. And by an uncontested permit, after having a really good stakeholder process, we moved 70% of that back up to the Metroplex, which is now being used by Tarrant Regional Water, or will be used by Tarrant Regional Water District. It's being used by North Texas Municipal Water District and some others. The other 30% has to go down and help benefit the yield of Lake Livingston for the benefit of Houston and folks in the south. So we're dependent on flows from the Trinity River. The recharge zone, or the outcrop of the Carrizo-Wilcox Aquifer, covers about 500 square miles of our Trinity Basin, and we're an 18,000-mile basin. Much of it's located in the river's floodplain, and the area comprises about 20% of the Carrizo-Wilcox recharge zone in Groundwater Management Area 11. Historically, we've been a gaining stream system. You just talked about that. And we've been supported by discharge from the Carrizo-Wilcox. So when I first had this issue brought up to me and we were invited by Chairman Harris to come here and testify on the issue, I thought, well, we really don't have a dog in this fight. I'm not sure what we'll do. We're surface water, not groundwater. Much to my chagrin, after reviewing all the reports and using my, I guess, historical knowledge from being the executive director for the Texas Water Development Board at one time, I realized that such was not the case. So I talked to my guys to run some numbers, and they looked at the Carrizo-Wilcox outcrop and the gauges between there and Dallas. And the USGS stream gauges at Rosser and Trinidad during the drought of 2011, we're still gaining about 0.7 of a cubic foot per second per river mile. But from Trinidad to Oakwood, which is the reach of the Trinity that lies over the Carrizo-Wilcox Aquifer outcrop, the river converted to a losing system, and it was losing an estimated 1.62 cubic feet per second per mile. It then reverted back to a gaining system just south of that between the next two stream gauges, gaining about 0.74 cubic feet per second. We've also observed this pattern during other years, and not just during the extreme drought conditions seen in 2011. So while it's not totally conclusive, pattern suggests the river is leaking water into the alluvium, and by extension into the aquifer, precisely when surface water supplies are most vulnerable, during drought. We're going to investigate this phenomenon a little bit more because we're very interested in what that is. But we really don't have to guess about this. Why? Well, because we know that if you do drill wells like this, it's going to change the gradient within the aquifer, and you're going to see some drop in creek flows and stream flows and things like that. So in digging through the GMA 11 Desired Future Conditions report, we stumbled upon some really interesting information. Now, I can say, I could just say that we're going to be losing stream flow. It's going to go into the aquifer. So basically, you're going to be borrowing from Peter to pay Paul. So I looked at the report, and I found, and I've provided these 3 pages to the clerk this morning after, you know, it's in my testimony, but I decided to provide these 3 pages so people knew it's there in the report. It's not something we tried to come up with. But under baseline condition, the aquifer right now, or was in 2013 anyway, was estimated to contribute about 45,624 acre-foot per year to the rivers in GMA 11. That's 45,000 acre-foot it was giving. Now with this DFC, they're projected to draw 138,466 acre-feet annually from the adjacent alluvium. That's from the 3 rivers that transect the aquifer. So that's the Neches, the Trinity, and the Sabine. And so it's a net reversal. So you add the 2 together and you get to what the budget is in water here. And so in this budget, to come up with the 250,000 acre-feet of additional pumping that they want to have with this DFC, they're going to get 184,000 acre-feet a year from surface water going to groundwater. So we've got a problem. We've got permits for that water, and it goes to Houston, and so I think that we're going to have to really look at this and determine what we want. But it's in their report, 72% supposed to come from the alluvium. And they show that all of the net budget would change. So then I decided I was going to dig into it a little bit more. And this comes into some of the questions that were answered earlier, or asked about earlier on science. And I just want you to know that when you were being briefed on all of what a desired future condition is and how that works, that was not this desired future condition on this GMA 11. That was how it's supposed to work. And unfortunately, that's not the way this was done. In the 3 pages I provided you, the author of this report, which is it's a PhD, he is Dr. William Hutchison. He's also a professional geoscientist. He goes on to talk about the impact on property rights and all that, and he mentions that in the 2016 DFC, which is also what this one's based on, all current projected uses as defined in the Region D plan and the Region I plan, as well as the 4-star project, were included in Scenario 4, which is the basis for desired future condition. So that explains why you would go from pumping, which is illustrated on here, in the 1981 through 2013 of 130,000 acre-feet to 385,000 acre-foot in 2080. You know, it's basically based on what the folks that got together in the stakeholders process, the stakeholder process for joint planning on this, decided what might happen in the future if these folks developed their water and we needed to pump it. So they came up with that. And then they went from there and they came back in and they looked at how to do their desired future condition. And I found it rather fascinating the way that the gentleman characterized it. He characterized it like this. In GMA 11, several runs were completed. The results discussed prior to adopting desired future conditions. Some critics of the process asserted that the districts were reverse engineering the desired future condition by specifying pumping, for example, the model available groundwater, and then adopting the resulting drawdown as the desired future condition. However, it must be remembered that among the input parameters for a predictive groundwater model run, one of those is pumping. And among the outputs of the predictive groundwater model run is drawdown. Thus, an interactive and iterative approach of running several predictive scenarios with models and then evaluating all the results is necessary and time-consuming, and is a step in the process in developing the desired future conditions. So he goes on to say, one part of the reverse engineering critique of the process has been that science should be used in the development of the desired future conditions. The critique plays on the unfortunate name of the groundwater models in Texas, groundwater availability models, which should suggest that the models yield an available number. This is simply a mischaracterization of how the models work. Therefore, what a model input is and what a model output is. So essentially, they had a target they were shooting at, and they decided that's what it was going to be, and the end result was all of the math that they ran to show what the drawdowns would be in each of the counties. Then they made the, I'll say mistake, but they assigned it to all of the various areas so that they could say this is how much for each of these areas, each county, and for the Neches and for the Trinity Valley and all that. So they assigned it that way. And it just so happened that Anderson County ended up on the side that had a lot of available groundwater in the modeling from the Water Development Board. But it was based on the fact we're going to pump this much. At least that's what I read here. Now, knowing that I'm not a geoscientist, and everyone thinks I'm an accountant, although I was in petroleum engineering at the University of Texas for 3 years, so I took a lot of courses in all this. I called Dr. Mace this last weekend, and I talked with him, and he's provided testimony as well. And so he confirmed that I had it right. So that concludes my testimony, and I'll be glad to answer any questions. And hopefully I did it quick enough this time.
Senator Nichols or Senator Perry? Which one of y'all were?
I guess what I'm hearing you say is.
Hang on, let me figure out how to work this system, just a second. Are you on now?
I didn't actually hit my button. I did have a
Okay,
thought.
there you go.
I have one a year. I don't want to miss it. Sometimes it slips out. So, to be clear, the groundwater is being supplemented with river water.
That's what the report says.
Okay.
And the
that was a
plan is
two-
to get it from there as well.
That was a
going future.
14 or 16 number.
No, that's the new.
Is that the
That's
new-
a new number.
new
The
number?
13 was the number where they were getting nothing from there, and 45,000 acre foot were going back into the rivers.
So what number is that today? Is that the 22 number? What is that number?
They ran this in probably the 21.
Okay,
Right.
so as the river authority person that you are and is
Yeah,
solid quality,
20.
are you seeing what they were suggesting they're going to need to do happen? And I know you had some of the metrics on the front. Is the river truly supplementing?
It appears to be, yes.
It appears to be.
Yes, but we're gonna have to look at that a lot closer. I mean,
Yeah.
we just found this out after our scientists looked at it on Friday and over the weekend, and I just got the information late yesterday.
So you raised a lot of issues that start talking a whole different conversation for stuff that you and I are working on anyway. So this is not, I guess it's not a shock if you're paying attention to the interactions, but it is a shock in this respect that the way the district has fulfilled the supply need and the reverse engineering on the loss. That's not news to me. I know they have an objective and they reverse engineer it. That's been the complaint with DFCs for decades, but it's the best we do today. So, but if you, not but for your testimony today, we would all leave here with an impression that those are county-specific, but they just kind of backfilled, right?
They now have if their report, the way the geoscientists did this, if this is really where the water is gonna be budgeted from and it really comes from there, then it's coming from the alluvium, which means
Right.
it's going to drain the springs and all those other things that
Sure.
feed the river, and it's gonna have an effect on water rights. So someone
Well-
needs to study this, because we certainly don't wanna lose the water rights in Lake Livingston.
It just continues to go back to, we need to develop supply, new supply. We can't keep robbing Peter to pay Paul and calling it good. Thank you.
Senator Nichols.
Thank you. By the way, this light automatically turns on green. It's happened. I've got a witness.
Yes.
Y'all do it a little different in the House than we do it in the Senate.
It's only this committee room that does this.
What you just told us, the story of what you just told us, kind of fits in with something I heard a little bit earlier about some streams are kind of start disappearing early and some just keep going, and that's soaking down into the aquifer. So what you're saying is in that area of the river, there's a huge, I would call it like a pipe with a big leak in it, so it's flowing into the aquifer.
Not currently, according to this report. Now, I don't know that for a fact, because those numbers were based on 2013 study numbers. This is a 2021 study
Okay.
that continues to say that that's the case. But hearing the testimony earlier that we had from these folks, it concerned me that we may be to the point where actually, instead of it flowing into the river, it's going into the aquifer. We could be at that point now.
Yeah, okay, so
Certainly during
anyway,
drought.
so you're guessing that we need to go back and review the desired future condition because of the math, there may be some major errors depending on the assumption. Is that fairly?
Perhaps it just needs better guardrails and more guidance from the legislature as to how they can adopt these, instead of it being it was supposed to be local control, I'm sure, that's the way this all started, but at the same time, what's going on is you're getting an ability for folks to determine how much they want to pump and then back into it without a very empirical analysis of what the impacts are on surface water and on spring flow and all of these other factors that need to be done. And, you know, if you go back to the 1917 constitutional amendment that told the legislature to manage water, certainly the legislature has the authority to look into this and decide whether they want to do it or not.
So if you've got that much water loss in the river, that big of a river in that section,
Yes.
if you were to be pumping out from the aquifer, that would be basically sucking it faster from the river.
That's what this report says.
Yeah, which means that was water that y'all had previously under senior water rights, either dedicated to Dallas or Houston. So if we pump more out of the aquifer, we're gonna be reducing the flow from those metropolitan areas.
Right, but we don't know
Could
what
be.
the amounts are. We really don't
Right.
know. That's the real problem.
But
is we
in
don't know.
earlier testimony before that, when we were talking about the depth of some of these wells in the aquifer, one of the things that concerned me was I'd heard the comment that the usable water that's available in the DFC, in other words, you only got, let's call it 1 to 100, that the remaining that hasn't been used, that somebody could use, that they're wanting to claim more of, because Representative Ashby said, well, what they applied for is more than is available. But we're only using roughly 40% of that usable, and only using 40%, the aquifer levels are dropping.
I think what's happened is we've oversimplified what's usable in that discussion, and what you've got instead is you need to look at what the policy is about what the interaction between surface and groundwater is, and what, you know, how you want that allocated, because certainly the groundwater's always benefited from the surface water. That's not a question.
But one thing we do know, under current pumpage, the aquifer's going down in those counties. That we heard from the people who drilled the wells. I don't think anybody refuted that. That's not a matter of calculation, that's a matter of real practical on the field. It's going down, sir, and I'm here to tell you that. And this really makes me want to go back and review. So if the permits are dependent upon the desired future condition, what's usable, we've got our math off. Going to do a lot of damage quick. All right, thank you. And this thing does keep turning on.
Representative Romero.
Yeah, thank you all for being here. Just wanted to tell Matthew, thank you for your testimony and
thank you.
And for the partnership between Texas Parks and Wildlife. You said it's only 2,000 acres, the wetlands.
Correct, sir. So the wildlife management area itself, Richland Creek, is 14,570 acres, but the wetlands itself is roughly 2,000 acres. 1,730 acres is the actual wetland acreage, but, you know, with levees, canals, those sorts of things, it's a little over 2,000.
So in slowing down and creating this natural, you know, cleaning device that Mother Earth has provided for us, are you in essence also helping to recharge the aquifer or those that may be underneath?
Not really. I wouldn't say that. So when the water comes into the system, you know, it's pumped from the river. We put it into some sediment basins, let the river sediment fall out, clean it through the wetlands, and then it goes back into Richland chambers. Because the soils are just a really tight, heavy clay, it doesn't really recharge through those. So.
And then you mentioned two different locations of these wetlands. Are there others planned, or is there more of this? And the reason why I'm bringing this up is because we've heard so much about other reservoirs, potential for new reservoirs that aren't in existence yet. And I know that because of the partnership that you have with Tarrant Regional Water District, these are the things that are being done proactively to ensure that we move those dates out as far as possible to ensure that people of DFW. I was shocked to hear that you said 20% of the water.
That was a
in
figure that was
2014.
given to me from Tarrant Regional Water District, sir. Yes.
Well, that's an extremely large amount of water. So I just wanted to say thank you to the Parks and Wildlife for the work that you're doing.
Yeah, you're welcome.
Representative Berry.
I'm not. Yeah.
Representative Gonzalez.
You know, it goes on.
First of all, thank you all for all that you do for the state of Texas. I really appreciate y'all. As chair of 145, I've worked for a long time with TDCJ to have the appropriate resources for our agency. I think when I started hearing about this, of course I care about the larger implications, but I also think about the state budget because that's my job. And so I know, Mr. Hudson, you have talked a little bit about the numbers that exist in East Texas, but could you talk a little bit about if this permit was approved, what is the potential impact on the agency, the state investments, and the need for future state investments?
Okay, within those within those 7 units that's in that groundwater district, we maintain 12 wells in that area that takes care of the 5 units within that Tennessee colony area. Those wells are between 900 feet up to about 1,300 feet, and we're already seeing some of our gallons per minute already go down, but a lot of our wells are old. So I can tell you we have dug 2 new wells throughout the agency within the last probably 3 years. And for each well that we've had to drill, it's cost us somewhere between $1 million and $1.3 million. So if we had to dig new wells because the aquifer lowers, you know, our wells are so old, I don't know if we would be able to drop those pumps down. So there comes a cost associated with that. And some of the quotes we've got on it is about $450 a foot to drop some of those wells down, or somewhere between 1.2 and 1.5 million to dig new wells.
Or maybe even relocate the facility as a whole, if there's larger negative implications. Is that accurate?
Well, to relocate 23,000 incarcerated individuals is just impossible. And some of the figures that we give to y'all during session was to build a new prison would cost somewhere between $1.4 and $1.5 billion to build a new facility that would hold about 4,000 individuals. So it would be costly to move 23,000 individuals. Yes, ma'am.
So we would put it, to paraphrase, it would put a significant strain on the agency and the state of Texas and the budget.
Yes, and on our agricultural operations, as you heard a lot of testimony today, you know, just to kind of throw out some of our agricultural numbers, you know, 100% of our feed mill production is in that area. 88% of our swine production is in that area. 72% of our egg production is in that area. And 41% of all of our cattle production is in that area of East Texas. So that would have huge implications on the agency. And we maintain over 40,000 acres in East Texas that we take care of also.
I really appreciate all of y'all talking about the impact to all of your areas and the areas that you lead. I just happen to be, you know, half a decade been leading with y'all and funding TDCJ, and it'd be a shame that we've been doing all these investments and now I'd have to really recalculate what that means. And so I just want to say thank you for everybody who's been here to share the devastating impacts of permit approval.
Thank you.
Representative Bell.
Thank you, Mr. Chairman. Mark, quick question for you, and this is more just a curiosity question, but you talk about the wetlands at Richland Chambers. Is that the forbidden zone?
It's next to the forbidden zone.
It's next to the forbidden zone.
Yeah, that's Tarrant Regional is the forbidden zone.
Yes, I've always wanted to deer hunt the forbidden zone, but just because it's the forbidden zone. Yeah. But I have not, just to be clear. Thank you.
Well, that's good.
Thank you, Mr. Chairman.
Representative Ashby.
That's good. I like that, Representative Bell. Ron, just to put a fine point on what you said to Chairwoman Gonzalez's questioning on as it pertains to TDCJ, when you talk about the affiliated cost with, I'll start with just having to re-drill wells, and you talk about the cost of that. Let's be real clear. Who pays for that?
The taxpayers pay for that.
The taxpayers would have to pay for that.
That's right.
And I'm glad you highlighted your operations throughout East Texas and, of course, just in the GCD, because y'all are a significant part and presence throughout the East Texas region. And
yes,
so I'm glad you're here and appreciate your testimony. Kevin.
Yes, sir.
We still need to work on that flooding along the Trinity River Basin.
I know.
I always would be remiss if I didn't start with that, especially in Trinity and Houston counties. So one thing that has really been eye-opening to me is this interplay, and I think Senator Nichols did a good job kind of teeing that up, and Representative Bell earlier in some questioning. I didn't really appreciate the interplay between surface water and groundwater and the magnitude of that until today. And, you know, when I think about the Trinity River, you know, feeding the Metroplex, of course, all the way down feeding the largest part of Harris County, the city of Houston, and the impact that this could have on the citizens up and down that river basin, I hope that it really highlights the importance of this as a statewide issue. You mentioned Lake Livingston, which, you know, I'm proud to represent some counties around that. That is for the city of Houston. And to your point in your testimony, if we're impacting or impeding the flows that flow into Lake Livingston, we're directly impacting however many citizens live in Houston, in the millions. I'm not exactly sure. But also significantly, we talk a lot about junior and senior water rights and permit holders when it pertains to surface water, something that we hold sacrosanct in Texas. And there's a lot of downstream users, big industry, hundreds of thousands of jobs tied to manufacturing, petrochemical, et cetera, that are senior water right holders in that Trinity River Basin. So the point is that the magnitude of what we're talking about today with this simple little issue of a port fee or an export permit, the volume of that would have statewide impacts. And I really appreciate you highlighting the impact along the Trinity River Basin.
Thank you, sir.
Representative Berry? Malfunction again. Representative Dyson?
Thank you, Mr. Chairman. Mr. Hudson, has the department taken a position on these particular permits that we're talking about here today?
We have not.
Does the department plan on taking a position?
We do not.
Is there a reason for that? I guess because I hear that there's significant impact, and I'm thinking that it might help a lot of people around there if the state of Texas was involved in this, if there's going to be a significant impact to the state of Texas on and what could require additional taxpayer funds being paid out. So is that something that the department might consider?
Yes, sir. It's something we would consider.
Okay.
Anyone else want to ask questions? All right, I won't take very much time. I do want to go back to Matthew. I want to drive it home because a lot of what we talk about is new water supply. And what you guys are doing along the Trinity River. Tell me again, off of 2,000 surface acres of water, how much clean water are y'all producing off of that 2,000 acres?
So on that 2,000 acres, the permit is for 105,000 acre feet.
Per year?
Per year.
What's the cost compared to pumping that much water?
Well, the initial cost was at 63 cents per 1,000 gallons back when the project was originally created. I can't speak to what that cost is now. That would be a Tarrant Regional Water District question. Obviously, electricity's gone up, and we have a lot of pumps, but it was in everyone's best interest economically to move forward with this plan.
How many times could you replicate your project up and down, not only the Trinity Rivers, but the Neches River, the Angelina River, and so on and so forth?
Good question. I don't know. It could obviously, the concept is solid. The biology is solid. I mean, that's what we spent decades working on. When we built this, we built it in phases because we weren't really sure how it would work. And we were the first project between Parks and Wildlife and Tarrant Regional, and then the John Bunker Sands one came on. So those are the two operating projects that the state of Texas has at the moment. And obviously the concept is solid enough that Tarrant Regional is doing a very large investment in the third one for Cedar Creek. So yeah, we could. I don't see why it couldn't be replicated down the Trinity, other than, I think the limitation will be what water rights are available, the permitting, and that's something I can't speak to. I can as a land manager, and talk about the success of the project and the concept work. So yes, if we found another location or another two locations or whatever, sure. I think it could be studied and looked at and probably replicated. Yes.
Thank you. I hope everyone really gets to absorb the potential that we have and what y'all are doing out there. Thank you guys very much for being here. It was very informative testimony. Appreciate your time. Chair calls Kathy Calvert. Ms. Calvert, please state your name, who you represent, and proceed with your testimony.
Thank you, Mr. Chairman and committee members. I'm Kathy Calvert with Houston County Electric Cooperative, And we are the electric service provider for Red Town Ranch there in Houston County and southern Anderson County. And I will say I am a square peg in a round hole today because I am electricity and not water. But even as a power person, I would say I would take water every day of the week over electricity. It is that critical. We saw it Winter Storm Uri. It's very important, so I'm proud to testify. As a nonprofit electric cooperative, we are singly certified to provide service to any member applicant who wants electricity. Red Town Ranch LLC approached us with their agent, Don Foster, in February 23, looking to reconnect existing 75 horsepower well that was on the ranch already into exploratory test wells. Since that time, we have had no additional applications for service. My only awareness is because of the public application for the water wells in the conservation districts. So it's hard to speculate on the magnitude and the capacity that would be required to serve this site. Today, I did do some preliminary engineering analysis. We can serve up to 1 megawatt of electricity capacity to the Red Town Ranch site. So that is equivalent to about 200 homes. In terms of water wells, that's about 10 125 horsepower water well pumps, 3-phase service, without upgrades. Beyond that, the numbers that have been discussed are much greater than that. We would have to upgrade our system, and the system upgrades could include anything from voltage conversion, conductor upgrades, more regulation, or even a substation upgrade. The substation upgrade would be an expansive project, would run around $4 to $5 million in upgrades minimum, and would take 4 to 5 years to complete just due to the distance from our existing infrastructure to the site of Red Town Ranch. So we are perfectly capable of meeting service requirements for this, but we do not have any applications other than that initial interest in 2023 since that time. So happy to answer any questions.
Thank you, members. Any questions? All right, so just really quickly, it sounded to me like the wells that 10 wells, 125 horsepower motors for 1 megawatt.
Yes.
So it's going to be exponentially higher than that.
Yes.
In theory.
Yes.
Okay. And so who bears the cost of the upgrade if that's required?
The member applicant, it wouldn't be placed on the burden of our membership. So industrial customers such as this would pay for the cost of infrastructure upgrades.
Okay. If you had to construct a new substation or different things like that, anything for the upgrade system, would you have to condemn anyone's land in order to do that upgrade that's not the applicant?
Our preference would be not to. It just depends on system constraints and what they're requesting and what our capabilities. We always try to leverage existing infrastructure to the extent possible.
Okay, maybe not. Not
Maybe,
enough
maybe
information
not.
to know yet.
Until we have an actual application of we need X horsepower for this number of wells and these are the locations, it's hard to fully answer that.
Okay, all right, thank you. Any other questions? Thank you for being here. Appreciate your testimony very much.
Thank you.
The chair calls Terry Morrow and John Stover. Gentlemen, thank you for being here. If you would state for the record your name and who you represent and proceed with testimony.
Chairman Harris, members of the committee, senators and reps, my name is Terry Morrow. I'm the president of the Natchez and Trinity Valley Groundwater Conservation Board elected in January. I'll tell you just a couple of things real quickly. This district was created in 2001. It consists of 3 counties, Anderson, Cherokee, and Henderson County. Each county has 2 representatives to the board, plus a 7th rotating representative that serves for 2-year terms. We meet monthly. I've been on the board since 2017. And I will say right at the start that I am not a hydrologist, I'm not a geologist, I'm not an attorney. I'm just a regular person. I'll give you a quick rundown of the procedural history for what we're talking about today. And I'll tell you that Mr. Bass and I think a hydrologist and maybe an employee or 2 came to our board meeting in either March or April of 2024, introduced themselves, and they gave us a quick overview of conservation equity management, and told us that he would be submitting some applications. So we, on June 3rd of 2024, they submitted Pine Bliss drilling applications, 22 of them, and 21 Redtown Ranch drilling applications. Those applications were gone over by our office manager, and then Mr. Stover, our attorney, in his office got into looking at them. And sometime in the summer of 2024, we were notified that Don Foster had drilled a well, a test well in, I believe, Henderson County, and at that point, he signed an affidavit of conflict of interest and abstained from discussing and voting thereafter. Applicants submitted hydrological reports for Pine Bliss and Redtown Ranch in September, and the conversation went on for a number of months between Mr. Stover's office and the 2 application locations. They went on until, pretty good, until June 5th of 2025. And I'm sorry, maybe I got a date wrong, but I've got a lot of notes.
That's okay.
Here. Yeah. May 15th of 2025, at which point our attorneys informed the board that the applications were procedurally correct, and they were accepted. At that point, according to Water Code procedures, we were required to hold a public hearing within 35 days, and for everyone affected by the proposed wells, 22 in Henderson County, 21 in Anderson County. That hearing was held on June 19th. I'll tell you that approximately 200 to 300 people came. We were expecting 60 to 70, and 75 or so signed up to tell us their thoughts, and they did. At that point, this is where we are now.
Mr. Stover, please state your name and who you represent. Proceed
My
with your
name
testimony.
is John Stover. I represent the natives in Trinity Valley's Groundwater Conservation District. And in 2001, the legislature passed Senate Bill 1821. And the person responsible for that has been standing in the back of the room. And he went by the name of Todd Staples. Now, I don't know, well, I'm not too sure he's willing to admit he started all this, but he did. The district has a general manager, one full-time employee, and one part-time employee, and that's it. And they have been totally overwhelmed by this process. As Terry said, notice was given, and the district has received over 5,000 protests in the form of emails, letters, other communications. Of course, I don't think most of those people will be able to meet the requirements for standing to be a party, but anyway, they know about it, and I'm sure they're going to stay with this process. The district has approximately 611 operating permits and has one permit for transport out of the district. And it's been a very, and the board has seen to it, it's been a very low-key operation. They haven't tried to build an empire, do all these other things. So this is really creating a lot of issues for them. Now, a lot of what I was going to say has been already said, and so I'm going to be polite and not say it again, unless you want me to, but anyway.
We appreciate the brevity.
But one of the things I want to go back over and emphasize is managed available groundwater and desired future condition. In the drawings that you were shown, there was one that showed the groundwater management areas. The Water Development Board was charged with dividing the state up. And the reason for doing that was the potential of having one groundwater district here that wants just to pump the aquifer dry, market it, get it out, use it, versus a district next door that's trying to preserve the amount of water. So you've got conflicting goals that some of the districts may have had. So the management areas, the process was designed so that they had to come together, compare notes, and work out a plan that would work for all of them. So as part of that, as you know, is the managed available groundwater. And statutorily, the district needs to keep their eye on that number and the DFC. Now, I'm not going to say what I was about to say about the water being muddied, but anyway, you've heard about the TERS, total estimated recoverable storage. That is not a regulatory factor, and it's not part of the permitting process. The permitting process only includes DFCs and managed available groundwater. There's been talk, and I'm really glad it came up, about takings. You know, what constitutes a takings? I'm sorry to say the district was a defendant in a takings case here a couple of years ago. It didn't have anything to do with permitting. It had to do with threatening to enforce its regulation. I'm glad to say the Tyler Court of Appeals upheld the action of the district, and the Texas Supreme Court denied the petition for review. But it was, as has been said, that's an expensive process. And looking at how that would apply to this matter, I think the water code is real clear as to what the district's responsibilities are. And as Terry said, the board had the preliminary hearing on it, and the matter's been referred to SOA to conduct the hearings. And fortunately, under the water code, the applicant, if they request SOA, they pick up the bill for it. So we got a long road to travel here. And importantly, as you have heard, but I want to emphasize this, the applications are strictly to drill wells. Under the district rules, after the wells are drilled, they have to come back and apply for an operating permit. Then, if they want to take the water out of the district, that requires another permit. And one of the, from a lawyer standpoint, one of the traps we've gotten into is the understanding of what the court said in the East case back in 2004. I want to emphasize that that was a matter between one neighbor and another neighbor. And each neighbor was going to use the water themselves, not pump it off somewhere. The case deals with two neighbors arguing over who was entitled to water. And if you read some of the, well, there are not that many cases, Supreme Court opinions in the dealing with water law, you'll find that the courts have looked on with disfavor the district's regulations. But they've said, and going back to the Conservation Amendment, Article 15, Section 59, the legislature has full authority to declare the law applicable to the groundwater. If it wants to regulate it, it can prescribe how to do that. And another thing I'd like to emphasize is the talk about a mitigation fund. Right now, under the water code, the district can collect a transport fee, but it doesn't say what it's supposed to use that money for. And I think that's a loose end that needs to be closed, and it needs to be specified that it's to be a mitigation fund. And I can just imagine all the people trying to get a piece of that bounty. So whenever that, if that ever happens, I would hope there would be some guidelines on who's entitled to get money out of the mitigation fund. With that, I'm going to give you a break and quit.
Thank you, Mr. Stover. Senator Perry.
I appreciate you guys, and I was kind of looking forward to hearing from you guys direct. So I got a couple of really high level, not related specifically to the permit first. Earlier, we had a well driller, and he kind of led us to believe that there was 2 wells drilled, 1 permitted, 1 not permitted. Are you aware of an unpermitted well?
No, sir, I'm not.
You're not aware of that second?
I am.
You are. So there is actually 2 wells where both of them are supposed to be permitted,
They were,
and 1 is not.
correct.
And that's in violation of?
District rules.
All right, so that's one issue, an unpermitted well, shows kind of credibility sometimes. Secondly, you had a board member named Foster.
Yes.
Now, he signed a conflict of interest after he had drilled the well or before he drilled the well?
It was after he had drilled the test
So
well,
did he do it because he had a guilty conscience, got caught, or decided to come clean?
'cause I told him to.
All right. That's pretty dadgum effective. I like how you run your store. So that's a different issue altogether, and I don't want to get off on the squirrel, but that shows some real issues, right? And it shows integrity. And I think you showed integrity when you knew about it, you caught it, and you fixed it. But on the other side, it shows integrity for permitting well or not permitting well. That's a different conversation. Move forward. Do y'all currently have an export fee on the 1 export that you have?
Yes, there's 20 cents per thousand.
And a lot of times, as a legislature, that's up to each district, and sometimes they ask for it, we give it to them, and they specifically say it should go to mitigation. So when there's a well dropped, it's for people to use. So that's a different one. But here's the question I have for you. And I'm sorry that I'm going to ask this because it may not be something you can volunteer, but clearly we've had testimony all day regarding MAG and the importance of MAGs and what they're used for and what is not legitimate conversation on what metric you're using under your MAGs. But here's the question I have for you. On a 10,000 foot, very layman's perspective, we can add up the pull request, the production request, and compare it to your current MAGs, and it's already over MAG. So just based on reading between the lines, if you can't answer it yes or no, I'm going to suggest to you what I'm hearing from you is y'all don't think y'all can support these fees, these permits.
Because of the SOA hearings, I cannot give you
I appreciate
my
that.
personal opinion.
Well, I will tell you this, just listening to how you presented your position, it's clearly to me that you guys are understanding, even as one-arm shop that you are. You got the head chief cook and bottle washer doing his job. You're trying to be efficient. I think that's a mirror of a lot of our districts, and that's part of the challenges. But clearly, you've given me some confidence that y'all know where your position is with respect to the science that we all depend on, and I think you're moving in the right way to make that decision. And ultimately, I guess SOA's challenging. Yeah, it was permit was administratively complete, right?
Correct.
So I guess there's no permit issues today. They're at SOA. SOA will respond to y'all.
Well, you're a little ahead of us here.
Sure.
The board approved contracting with SOA at the last board meeting, and the back and forth with SOA. Only a week or so ago did we get the contract.
If you pull that mic just a little closer so you can respond to that. So y'all contracted with SOA to get the legal cost.
Yeah, we're in the process of getting
Okay.
all the I's dotted, T's crossed with SOA.
Have they given you an estimated time?
The board specified that they did not want a hearing before 90 days. so that the people who are opposed or otherwise interested would have time to get their consultants or whatever they want.
Correct. Okay. Mr. Chairman, I appreciate it. I just, I'll say, I've been looking forward to y'all's conversation. It was better than I hoped it would be. You create self-imposed
Well,
demons. It sounds like you're on it and you're doing your job the way we'd hope you'd do it, so.
It is, I know they sign my paycheck,
Right.
so to speak, but they're very conscientious in their responsibilities.
Thank you.
Representative Gerties.
Thank you, Mr. Chairman. So you say you have 611 permits
Correct,
and 1 export permit?
correct.
So how many registered exempt wells are in the district?
I don't have that number.
Okay. We effective June 20th of this year, the before you issue or deny a permit, that took effect to consider the registered exempt wells in a GCD. And so I just wanted to see if y'all had taken that into consideration. So that's something to think about.
That was part of the modeling, or has to be.
Well, I know it's not part of the modeling in some GCDs. That's why we had to make a law to get it
Right.
in there
Right.
to protect those exempt wells that that folks use to feed their livestock. So, anyway, thank you.
Representative Ashby.
Thank you, Mr. Chairman. Mr. Morrow, it's good to see you again. John, how long have you been practicing water law in the state of Texas?
Can I say over 50 years?
You can. I was aware that it was over 50 years. I just wanted everybody to know that you have.
Probably longer than a
long
lot of
time.
people have been alive.
You've been doing this a long time. I've known you for over a couple of decades, and I know you've been a great resource to a lot of folks in East Texas on both surface and groundwater. One of the things that I hear a lot about, and I'm sure Chairman Harris hears a lot about in terms of the affected counties, is people are a little unclear about the SOA process. And I want to make sure I heard you correct a minute ago. Did you say that the groundwater district is picking up the cost of the SOA hearings, or the applicant? The applicant is picking up the cost of the SOA hearings. As a little bit of a side note, I'm curious, what is the annual legal budget? We heard an attorney earlier testify that that's a limiting factor for a lot of GCDs. They don't have the ability to fight in court a lot of these issues. I'm curious if you can share with us what your annual legal budget is.
I didn't bring those figures with me, and it changes from year to year. Some years we don't need John Stover, and that's fine.
Next to you.
Oh, I know. So I can't tell you.
It varies. Okay.
May I answer?
Please.
Under the district rules, the applicant has been required to put up funds to cover the front-end cost of evaluating the application. So we've been working on their nickel.
Got it. So I know there's a lot of people back home that are curious about the timeline here that Chairman Perry referred to, but to be clear, you said that y'all have 90 days, or the SOA is going to give y'all 90 days for interested parties?
The SOA will not have a hearing for 90 days.
For at least 90 days?
Yeah.
And then
I don't know what their schedule is.
And when there is a public hearing, where will that be located?
Definitely in Palestine, and possibly also in Athens.
Okay.
But we're clear on Palestine.
Okay. Maybe the Civic Center there? It's not
I don't
open
have
anymore.
an address yet.
Okay. Well, I will say this, Chairman Morrow, to your point earlier, when I showed up to that public hearing a few weeks ago in Jacksonville, you said there was at least 200 or 300. I was there 15 or 20 minutes early, and I saw a number of people turning around and leaving because not only was there, again, I'm not being critical, but the meeting room was full. The fire marshal wouldn't let anybody else in there. The entire building was full, and there were people all the way down the sidewalk standing waiting to get in. So I would submit that number was a lot bigger than just a couple or 300 people that wanted to be there to participate.
Right.
So in terms of what to expect, so the administrative law judge for SOA that will oversee the hearing, they will conduct it like a normal trial, as I understand it?
A SOA contested case hearing is like a trial without a jury.
Right. Okay.
Rules of evidence apply, rules of procedure, some apply, and SOA has its rule, and the district has rules for conducting hearings.
But ultimately, the administrative law judge for SOA will make a recommendation to the board of the Trinity Natchez Groundwater Conservation District on their recommendation on what to do on this permit application. Is that correct or factual?
It's called a proposal for decision. And the ALJ will summarize the issues, the evidence, the law, and give his or her recommendation.
And historically, can you give us your best guesstimate, John, on about how long we might expect from when the judge concludes? No, can't give any type of timeline on that. Okay. Well, Mr. Morrow, Chairman, you reside in Cherokee County, is that correct?
In Jacksonville.
And you're appointed by the county judge?
Yes, sir.
I just happen to be looking at him back there. I'm sure you probably want to publicly thank Judge Davis for your assignment.
I have several times, thank you.
I'm sure you have. Well, anyway, we appreciate what y'all are doing, and obviously a lot of folks watching this closely, and thank y'all for being here today, and God bless you.
Representative Money.
Thank you. I have a few procedural questions that are really my goal and focus here is to try to let people know exactly where we are in the process and where they are allowed to insert themselves into the process or not. So there has been an application, and that application has been determined to be procedurally correct, and I assume that is under Rule 5.4. Administratively complete. And that's things like the naming and mailing address of the applicant and owner, and documentation about where the wells are going to be, how big they're going to be, those kinds of things.
Correct.
And so procedurally correct means that you or whoever reviewed their application and said, yes, they did all the things the application that they were supposed to do and provide.
They had answers for every blank.
Right. All the blanks are filled, and it's in English, and people can read it, and they know what it says. And part of that is that there's supposed to be a hydrogeological report that we talked about a little bit with previous witnesses. Is that correct?
Correct.
And is there anybody at the water district who is qualified to evaluate the quality of that report, the veracity of the data, any of that?
No, but we have hired a consultant, a hydrologist, to review that.
Okay, so the Groundwater Conservation District hired its own hydrogeologist, I guess that's what it's called, to review that. And will that be part of the SOA hearing?
If it's introduced, you've got the applicant and its attorney offering evidence. We'll be offering evidence, and any of the other parties can offer evidence.
Okay, and so then that gets to my other question. How does someone else, somebody sitting here in the room or watching at home, that believes that they're affected by this, how do they become a party to that SOA hearing?
First, they would have had to submit it a contest and a statement as to why they are an affected party by 11 a.m. on June 19th.
Okay, so that's already passed.
That's passed.
Okay.
And it's going to be up to the ALJ to go through those to make the determination as to who's an affected party.
So the administrative law judge will decide who is an actual party, and then those parties could hire their own hydrogeologist or
Correct.
bring their own experts to evaluate this. And then the permit that we're actually talking about, is that a drilling permit?
Strictly a drilling permit.
Okay, and then assuming that it does get approved, there's then an operating permit.
Right.
Okay.
They will have to apply for the operating permit.
Okay, and then that operating permit, will the same process apply again?
Yes.
Okay, and so there's an opportunity for that to be contested, that to go to SOA again?
Yes.
Same judge or different?
It's so they administer things
Okay.
beyond our
Okay,
control.
so that would go through this whole process again?
Let me back up. The district has three means of conducting a contested case proceeding. One, it can hear the matter themselves. A quorum of the board can sit and hear that. Two, it can engage its own hearing examiner, which we have done before. Or three, it can delegate it to SOA.
Okay, so they could, the board would have those three options again the
Correct.
next time. And then even that point, they have if they had passed the drilling permit, they passed the operating permit and it was granted following those two hearings, in order to transfer it out of the district, they're gonna have to have a transfer permit as well.
Correct.
And that would go through another opportunity again. So we are, we've been doing this a long time, but there's a long way to go. Is that fair?
That's correct.
Okay. I think I'll save my other questions for somebody else. Thank you very much. Appreciate it.
Senator Nichols.
Thank you, Mr. Chairman. John, my question is real simple. Can some of the testimony that was used today be presented as evidence in the SOA hearing?
No. No.
All right, thank you.
No opportunity of cross-examination.
Members.
It's hearsay.
Any other questions from the members? Either one of you can take the questions as I present them, but first off, over 300 people at the hearing, over 5,000 written protests. Has the GCD ever had an application like this before with this type of response?
Never.
Has the GCD ever had an applicant apply for this much water?
Back in 10 or 11, it had an application from 4-Star. I don't have the statistics for that.
Okay. The one unpermitted well that we've kind of uncovered through this hearing, what are the penalties for drilling a well that's not permitted when it's supposed to be permitted?
I think the Water Code provides a civil penalty of up to $10,000 a day.
Per day?
Per day.
Do we know when this well was drilled?
We know pretty close to when it was.
Give me a minute.
However, based on experience, it's very hard to get a court to assess a $10,000 penalty a day. The district has what we call a penalty matrix. that allows the board to go through and determine the criteria for seeking enforcement.
Okay, thank you. Are the SOA hearings open to the public?
Absolutely.
So anyone can come whenever we have these hearings, or whenever y'all have these hearings, in Palestine or Athens, and
Correct.
witness it, listen to the testimony provided,
Yeah, unless they're, and I can't think of a.
unless they're
basic-
disruptive or something like that, then.
Yeah, or, trade secrets,
Mhm.
They're very limited on the number of matters that can be used to close a hearing like this.
I want to go into some of the questions that I've gotten from constituents in the district. I'm hoping it's a lot of misunderstanding or, not full information out there. But let's go back, low-hanging fruit, the April 2024 minutes that aren't on the website. Is there a reason those minutes aren't on the website?
Not that I know of.
I wasn't aware of that until June, and I'll find out. The minutes are there somewhere. We'll find them. We'll
I
make
have
sure
y'all's
that.
commitment to get them posted to the
we
website
make-
as soon as possible.
I will make sure personally they get posted. Yes,
Thank
sir.
you. The meetings where the conflicted board member was present, I believe, Mr. Morrow, you stated earlier that he took no action, made no comment on anything related to this applicant whenever he was, whenever this was discussed prior to his resignation. Is that correct?
The board was very strict that he could be in the room, according to our attorney, he could be in the room, but he could not take part in any discussion, could not vote on anything, and we very strictly held to that.
Okay. There are a few times in the minutes that the minutes reflect that the board went into executive session. That naturally causes people to have red flags go up. Like what was discussed? Why did the board feel the need to go into executive session to discuss this? Why couldn't it be discussed out in the open? So can you help provide some clarity to those instances?
Wait, I need to bring up an issue.
Mr. Stover, go ahead.
With the meeting law, that they require what's called a certified agenda. That it's a statement of what was discussed in that closed session, and the Open Records Act provides that that is to remain sealed unless it's authorized to be opened by a district court. So what was in those minutes, I frankly don't remember, but I do know that the open meeting law was followed.
Okay, so the contents of what was discussed in a closed session can only be revealed by a district judge, basically, is what you're saying.
Correct.
Can you tell me what instances prompted the board to go into closed session?
I'd have to look at the agenda.
It was them, it was the applicant, right? So that,
Not that I know of.
not necessarily?
No.
Okay,
No, the board can talk about the applications in a closed sessions.
okay. The next question I'm gonna ask you, Mr. Stover, but it's more permission for Mr. Morrow to answer, okay? When y'all were in closed session discussing a matter related to the applicant and the conflicted board member was present, did he ever at any time engage in the discussion regarding that applicant? Can he answer that question?
No, he never did. Not, I may have missed a meeting or two, but no, the meetings I was at, he did not.
Okay.
We're very strict on that.
Okay, thank you. A little bit more light right now, just going, as a board member of a groundwater conservation district, how long did you say you've been on the board, Mr. Morrow?
Since 8 years.
How much training, classroom training, technical training continuing education have you received on how to be a Groundwater Conservation District board member?
None.
What about your other board members?
I know there's still one on the board who worked for a water company for many years. The others, I don't know. I'm one of the newest members, so but the others I don't know.
So my point in asking that question is to point out that primarily the people who make up a Groundwater Conservation District board are members of the community who are volunteering their time. You get paid probably less than we do to do this job, which ain't much at all. And you do it voluntarily, very little training, and then most things are run-of-the-mill, right? Very run-of-the-mill applications going through the board until one day you have an application like this.
In a conversation earlier today, another member of a different board and I agreed that it takes about 3 years of being on the board to begin to understand the business. It takes 3 years of on-the-job training, and we're volunteers is what we are. We're all volunteers.
Relying on the advice of counsel, who hopefully gives you good advice.
Yes, sir.
For the SOA recommendation, when the SOA ALJ makes his recommendation to the GCD, is the GCD required to honor that ALJ's recommendation?
It is not obligated to do so, but it's limited on the reasons for not following it. And I'm sorry I can't quote those off of the top of my head, but we all know that two of us could look at this book and come up with one opinion, and conclusions and procedures.
And y'all didn't have a choice whether or not you went to SOA, if I understand that correctly.
That's
the
correct.
applicant elected to go to SOA, and the board is required to go along with that decision. Is that correct?
Correct.
Okay, because they're paying for the cost of the hearing. What happens, what are the risks of SOA, say, recommending that you approve the wells, and the board saying, we disagree, we disapprove these applications?
The board can't just say, we don't like this. It would have to be upon some issues in the proposal for decision. Evidentiary issues, conclusions of law issues, and other matters that aren't cut and dried. But if the evidence is overwhelmingly supportive of the applications, then it would need to go along.
How many, outside of this particular process, how many other SOA hearings have you been party to, roughly? Not an exact number.
Me?
Yes, sir.
How far back do you want to go?
As long as you want.
When I went to law school, I worked at the hearing section at the Texas Water Quality Board.
All right, let's limit it to those SOA hearings with regard to Groundwater Conservation District.
Two.
Two. In any of those, did the ALJ not side with the applicant?
You know, I can't recall the exact result, but I don't recall either side being really upset about the result.
But the ALJ is going to have to follow the same, look at the same parameters that the GCD would, right? So these mags that we're talking about.
Correct.
The ALJ has got to make their recommendation based off of the desired future conditions as in relation to the mags. Is that correct?
Correct.
All right, that's good. Chairman Bell.
Thank you. You had mentioned
something with regards to the, if I understood it correctly, to the SOA process and aftermath of the SOA process, what gives the board the option to basically go against what might be the SOA recommendation? And if I understood it right, you said it had to be something within the evidentiary side or some other compelling piece of information or knowledge.
The SOA judge, the product of all that is called a proposal, and that's the key word, proposal for decision, in which he or she makes recommendations back to the board. And it's the board of directors that has the final say.
And my question in that is, just from listening to it, it sounds like you've got an applicant that took it upon themselves to drill a well without a permit and without discussing that particular well. Does the integrity of the applicant come into play in the board's decision, or is that something that's off the table and only the SOA judge gets to take into account, whether you're a responsible business owner and conducting yourself in a reputable manner?
I think that's a matter that we'll just have to see how that plays out, if it comes up.
Okay, so one of the things, would it be your comment to us that we need to be concerned about making certain that in the future statutorily acting above board and within the confines of guidance in the law, being a responsible party should be something we ought to be concerned about?
No, like I've said, I've been doing this a long time, and I know Mr. McCarthy over here, the applicant's attorney. He has a sterling reputation among the lawyers, and I don't foresee anything sneaky.
And I'm simply saying that if there's a permit application process required, then if you know that permit process application required and you used it one time, you didn't use it twice, is that indicative of simply an oversight to drill a well that took a long time, or was it, and is there, and really this was I don't know the players, I don't know the participants, so I'm not trying to malign anybody. I'm simply asking the question, does that come into play? And if it doesn't, if we're going to look at this statutorily, is it something we should consider whether or not the applicant acted in good faith throughout the process?
Oh, I think you can't ignore that at all. Now, I'm not too sure what the next step would be, whether it would disqualify. There's a provision in Chapter 36 about an application by a party who is owes the district fees and things like that. I'd have to look at that to see how that would fit.
Thank you for your testimony. Thank you, Mr. Chairman.
Senator Nichols, your light came on. Were you wanting to ask any more questions? No, it was the ghost that pushed the button again. All right. One final question from me, Mr. Stover, Mr. Morrow. We heard testimony earlier that when the witness called the GCD and spoke to, I guess, the administrator, whoever managed y'all's office, saying they had heard about these applications, and the response was, yeah, we're trying to keep it quiet. How did y'all hear about it? Do y'all have any response for that?
It just amazes me that someone in that office said that, and yes, I will personally get to the bottom of that. It makes no sense.
Thank you.
Did have to publish notice in newspapers in all 3 counties and send out individual notices. And that was probably, what do you think, Terry, 30 people, landowners.
Okay. The public notices that were posted in the newspaper, is that for the hearing that we had in June?
Right.
Yes.
Okay.
But I think the incident you asked about was last year sometime, and I just can't imagine why an employee would say that, because we didn't try to hide anything. It just doesn't, unless there's, obviously, maybe there's something I don't know, but I'll find out.
Okay, thank you. Members, any other questions for this witness? All right, thank you all for being here. Appreciate your time. All right, next up, we've got local elected officials, and I'm going to ask that the witnesses be as brief as possible, while still getting out what you need to, what you want to convey to the committee. If any of the subject matter that you were planning on testifying on has already been covered, I would ask that you skip that and go on to the rest of your testimony. At this time, the chair calls Henderson County Judge Wade McKinney, Anderson County Judge Kerry McKinney, and Cherokee County Judge Chris Davis. Some of them may be in the overflow room, so I'll give it just a minute. We're in trouble if you're the only one that's going to testify.
It's going to be tough. Do appreciate you turning the air conditioning on.
Yeah, it's working now, isn't it? Come on down, judges. All right, we'll start with Anderson County Judge Kerry McKinney. If you will state your name and who you represent for the record and proceed with testimony.
I'm Kerry McKinney. I'm the county judge in Anderson County. And I'd like to thank Chairman Harris and members of the committee for calling this hearing and an opportunity to present testimony today related to the protection of our groundwater for Anderson County and our surrounding counties. And since Chairman Harris mentioned it earlier about the air conditioning, I want to reiterate something that happened in Jacksonville, which you'll probably remember.
It was hot
Their
in
air
there.
conditioning system was over capacity.
Yeah.
And wasn't working real good. So it's kind of what we're talking about today is making sure our groundwater is protected and the aquifer isn't taking over capacity.
That's right.
Okay, currently, and let me kind of give some background for our county. Currently, Anderson County depends solely on groundwater from the Carrizo-Wilcox Aquifer through water wells for two of our three municipalities, Frankston and Elkhart, one in the north end of our county and the other in the south end of the county. City of Palestine depends on surface water from Lake Palestine, but at some point they may have to drill wells just as a backup system, like in a drought situation, or we have about, Palestine has about 20% of the water rights for Lake Palestine, so that's essentially their water supply. We have approximately 15 community water well systems that are all on wells for mostly the residents in our county. Major businesses that will be affected that are on water wells, Sanderson Farms for their poultry processing plant and their grower houses. All those are on water wells. Talked to Walmart Distribution Center, and they are actually depend on water wells for the distribution center as well as fire suppression out there for the warehouse. We've got private farms and ranches that depend on water wells throughout the county for irrigation and for watering their livestock. And I know there's been prior testimony, but I wanted to reiterate, because it's a major employer for our county also, is we've got in a major interest for the legislature and the governors, the 4 prison units and state jail facility that house about 12,000 inmates in our county. Coalfield, Michaels, Beto 1, Pallage, and Gurney. Also to mention, and I think that was previously mentioned, in Freestone County, the Boyd unit, and in Houston County, the Wainwright unit. And I would imagine that they're on water wells based on the prior testimony that I heard earlier. Families throughout our county have been and will continue depending on individual water wells for years for their families. I know when I was growing up, both of my grandparents had water wells, and that's all the water source that they had. There were no community water systems back then. I talked to Nucor Steel over in Jewett, over in Leon County, not in Anderson County, but they depend on water wells over there, and that's a major industry and a big employer for Leon County. Some of the organizations that are very concerned about these water wells are a lot of those that support our agribusiness, and our Realtors Association are very concerned because that determines whether we'll be able to have economic growth and development of subdivisions and as we grow as a county. And that is happening right now. Our county depends heavily on groundwater for economic growth, for the health and safety and well-being of our citizens. Conservation Equity Management seeks permits on 43 wells, 21 in South Anderson County and 22 in Henderson County, just north of the Anderson County line. These are separate applications for each site: Redtown Ranch Holdings in Anderson County and Pine Bliss in Henderson County. These 43 wells are a well field and should be shown together as one project. They're going to affect our county because we're going to be right in the middle of all these other counties that are surrounding us right now. And both of those are going to have a major impact on the aquifer and especially in Anderson County. Conservation Equity Management's message that we've been hearing is one of conservation, but the citizens of our counties recognize it as confiscation of their groundwater. When you control the food and water supply, you can control people. I think this may be a bigger issue than what we're even thinking about. And that came from when I was listening to Sid Miller, our Ag Commissioner, on Real Texans. His quote was, you can't hold onto your freedoms if you're dependent on foreign powers to feed and clothe you. This is serious. Our limiting factor is water. Our state is out of water. We're sounding the alarm as an impending threat to our counties, all East Texas, and potentially the entire state of Texas. We need legislation to have reasonable production limits that prevent excessive amounts of groundwater by a single producer from being taken out from under our feet and transferred around the state to other areas. Not only do we need production limits, but we need to make sure, and I think that was probably a concern why some of the groundwater districts, the voters didn't approve groundwater districts, as they were afraid of over-regulation. So the other part of that is, without creating overburdensome regulations for private wells, local industry, community water systems, or small rural municipalities. And it would be beneficial if the legislature could help with grants to help some of these counties. I mean, we've got a groundwater district, and this is happening to us. If you don't have a groundwater district, you may consider creating a groundwater district. But the other part of that is you need to have the right regulations and rules that are going to protect your groundwater. So the stronger policies, one of the things that we don't have in our groundwater district right now is production limits. And that creates a major problem for us in these applications that we're dealing with. I've got 3 children, 10 grandchildren, and expecting 2 great-grandchildren at the end of the year. It doesn't take a rocket scientist to see we have a major tragedy staring us right in the face over groundwater in Texas. This will have a far-reaching effect on our future for generations to come, and we together as state and local leaders need to help stop this, working together. And this, at some point in the future, will be defined as a legacy of leadership. I hope that it's not a tragedy of non-response. I feel like listening to the testimony today, there's been just some outstanding testimony in the interaction with the committee and Chairman Harris. It's been outstanding that the things that we've learned that we didn't know about groundwater. But on behalf of our counties in East Texas and around the state, we're asking the House, Senate, and Governor Abbott to try to address this in a special session. We need some action now if we can get this done. And one of the things is we stand up for those that can't stand up for themselves, and that's part of our responsibility. Just some figures I want to leave, the impact on Anderson County and maybe a little bit about our surrounding counties. Redtown Ranch proposes production on 10 billion gallons per year, approximately 33,000 acre feet per year. The Pine Bliss project is 5, and these are from their applications with the Groundwater District. So 5 billion gallons per year, or approximately 15,000 acre feet per year for the Pine Bliss project. Anderson County alone, the usage is approximately 10,000 acre feet a year is what our water systems total are using a year. So the Redtown Ranch project or application projects taking out 3 times more water than what we're even using as a county right now. 3 times what we're using. Combined, Redtown Ranch and Pine Bliss are 15 billion gallons a year, approximately 48,000 acre feet per year. The Groundwater District's plan, the model plan, through 2080 for each year is Anderson County alone is allotted, and I like the words, it's looking at it as a budget, what's allotted in the budget. I think that for everybody, they understand that a little better. But in the model plan, it's 27,000 acre feet per year. So the Redtown Ranch is talking about taking out more than what we have available through the Groundwater District right now in the model plan. And if you combine Anderson, Cherokee, and Henderson counties, altogether is what's allotted in the model plan is 49,000 acre feet per year. If you take, which is 98% that they're projecting taking out of the aquifer that are allotted in the model plan for all 3 of our counties in the Groundwater District. CEM 48,000 acre feet that they're projecting with our 10,000 acre feet. That's not counting Henderson counties and what's allotted, what's being used by Cherokee County. We end up in a deficiency right there. So for the future of Anderson County and some of our surrounding counties, what does that mean for us? No permits for other wells. We've got multiple water systems right now trying to keep up with our growth. We just approved a 100-home subdivision in North Anderson County that Frankston Rural Water System is going to supply water to, and their own water wells. We've got Brushy Creek Water System that's trying to do 2 wells to keep up with growth. Norwood Heights is right now working with TCEQ to try to expand and either have some storage tanks or something to meet up with their capacity. Walston Springs, we've had some problems having, because they couldn't supply the water for certain areas, that we've had to have developers that had to get approved through TCEQ to make sure that they could provide individual water wells for each one of those properties that's selling in that subdivision. So where are they going to be if this aquifer goes down? And just to mention the NACHIS monitoring well, and that may be talked about by somebody else, so I'm just going to briefly just mention that the graph shows that from 2016 to 2025, that well has dropped 20 feet. So we can see that our water level is going down, and I've heard a number of the members of the committee, I think Senator Nichols touched on that earlier, and maybe some of the other members, but I'm worried about our new businesses. You know, Sanderson Farms, they've got plants in Bryan College Station where some of this is taking place right now too, trying to send, I believe the water's going to Georgetown if that works. So I don't want to see us not be able to grow because somebody's transferring our water to somewhere else in the state. And I'll just say this, I agree with Mark Calcote. You don't do 43 wells. You don't do 43 wells as test wells. And if you look at the map, you can pull up the map on Redtown Ranch. There's one on Pine Bliss, one test well, but there are 2 stars on that map on Redtown Ranch, and that were test wells. We're not talking about 21 test wells on that property. And this, let me kind of finish up. One thing I would like to point out is conservation equities management. Mr. Bass, talk about conservation and doing conservation projects around the state and other areas, and talked about doing youth programs and supporting other community programs. But I'll just remind him, you do 100 things right and nobody remembers, but you do one thing wrong and nobody forgets. And I implore the House and the Senate and the governor to look at this issue, and I think everybody understands the concerns after everything that's been said today. So thank you for the opportunity, Chairman Harris and members, and God bless you for what you do.
Thank you,
And
Judge.
God is in this, I can promise you.
Sir, thank you, Judge.
Okay.
Judge
I'll
McKinney.
take any questions when
We'll
everybody
let
else gets through.
We'll let all 3 of you go, then I'll
Okay,
open
that's
it up
fine.
for questions.
Well, first of all, again, Chairman, thank you. Thank you very much for inviting us, and thank you for very much your leadership in this. Also want to thank the committee for having us here, the senators as well for participating, those that are not here, and just express a strong desire to be a part of. We thank you. Surprisingly enough, this isn't the first time Henderson County has been at the epicenter of water in Texas. I take you back to 1996 when the parent company of Ozarka Water Bottling Company chose to drill a well just 5 miles north of my house, which is in Eustis, Texas, and sat down at Roar Spring, and I think there's even still some of the bottles you can buy that finds Roar Spring water on it, which is from my county and 5 miles from my house. Now, this well got put down and began...
Judge, would you mind pulling the mic a little closer to your mouth?
I apologize. I'm terrible about this. That well went into production and immediately had impact upon the surrounding tracts. These individuals, Mr. Bart Cipriano, Harold, and Doris Fain, went together and filed suit in Cipriano versus Great Springs Water of America Incorporated. And this case went all the way to the Supreme Court. And the Supreme Court, as been alluded to earlier, ruled upholding the rule of capture. And really in its ruling, put the impetus back on the legislature and said that, yes, the rule of capture is here, and we really want the legislature to work on this. Since then, we've had other rulings that have come along. There's, as mentioned earlier, there has not been many cases on it. But again and again, the judiciary has been hesitant to step in and want the legislature to act. Now, as has been said before, the rule of capture goes back to 1904, and as we've heard, they were not envisioning the amount of capacity that's being produced today. They can be produced from these locations. But I do know that Henderson County knows firsthand what the firsthand damage of unchecked water extraction can do. And actually, that's what started the creation of our Groundwater Conservation District, was this very case. And I can tell you, I've been on court 27 years. I get a lot of history and fill in a lot of the whys. And we didn't know that the district was going to pass. The public was very skeptical of governmental overreach. They were saying then, oh, they'll put monitors on your wells, they'll charge fees, X, Y, and Z. And this was the bare step that we could take to get some coverage. Well, here we are 25 years later, and I want you to understand 50 to 65,000 residents of my county depend upon this aquifer. Even though we've got Cedar Creek Lake Palestine, they carry, and Lake Athens with AMWA, but AMWA has pumps as well, wells involved in this. But in this, there are 17 rural water corporations in my county that depend solely on the aquifer. 3 municipalities as well. There are 6 municipalities that rely on a combination of ground and surface water. And this does not even include the 4 other rural water corporations that we share with Anderson County and Van Zandt County to the north of us. This problem is much larger than just our 3 counties. 63 counties are impacted by this aquifer and sustains these communities. Y'all know as good as anyone, population density is what's driving all of our decisions. The demand for resources, the demand for space. And it's a struggle that I don't envy y'all in having. But we know that there is an instance here where people's property rights has been eluded before or at stake, and even their livelihoods. So I thank you very much for having us here and be happy to answer any questions later.
Thank you, Judge. Judge Davis.
Mr. Chairman and members, I want to thank y'all for allowing.
Just a sec, Judge Davis. Judge McKinney, if you would, real quick, state your name and who you represent for the
I
record.
do apologize. I'm Wade McKinney. I'm the county judge in Henderson County. Thank you.
Everybody knows. We just got to get it right
There's
on the record.
two
There's
McKinneys here.
Yeah,
That's right.
no relation,
Yeah, exactly.
I promise.
All right, now
I'm
Judge
brother
Davis.
from another
I'm not related to either one of them. Mr. Chairman, members, and I just want to thank y'all for allowing us a chance to fight for our most valuable natural resource today, our water. You know, we've known this battle was coming for a long, long time. And thanks to Todd Staples for starting our groundwater district years ago. And I know it wasn't an easy thing to sell. And, but over the years, now we're glad we have it. And hopefully they can do us some good in this. We've always kind of been hid behind the pine curtain, and so a lot of times maybe Houston, Dallas, but we knew the water needs of our state were coming. And we've tried to plan lakes and different things to try to address these needs. And those things all seem to fall through, you know, because of the environmentalists, whatever, they're not gonna hardly let you build a lake. And our groundwater conservation district was set up, and it was set up to keep our water from being exploited. That's the way I see it. And we thought maybe the big city, but we never thought like privateers or water pirates, whatever you want to call them, would come in and just take the water. And the counties that don't have a groundwater conservation district, when they suck the water out from under them, it's all under us too. It's our water too. So, I mean, this is something that we've all got to work together on because, as you say, the high capacity pumps are just going to take what we never dreamed of. Years ago, I mean, they talked about the 4-star project that came up. That was just going to pump water straight out of the ground into the river and be recaptured downriver. I mean, it's hard to even imagine how much water that was going to just waste. But I've been on the East Texas Regional Water Planning Group now for, I guess, 20 years. And you sit and you listen to hours of scientists discussing all of these WUGs and different, you have no idea. It's kind of like our groundwater people. If you're not trained in water science, you're listening to a lot of stuff that's very, very complicated, but it's also very, very important that we do this. And I realize that our groundwater people, the ones that we've appointed, probably after this, I'm not going to get invited to the Christmas party anymore. But we search out people, first of all, that are willing to volunteer and help in the community, that we can ask to serve on this. But also, you want people. We've talked about, it was brought up about Mr. Foster. I don't personally know Mr. Foster. I've met him before, but if we had a chance to have my other fine citizen back here from Cherokee County that gave such good testimony on this board. You want people that know something about groundwater because there is no training or anything else. It's something they're volunteering for their community to protect their water. And I think that's what we have here. And it was a good idea. I think they need more teeth in what they're doing so we can get this saver of water. One of the things that I don't like seeing about this is that we're going to go, the courts are going to decide this. I mean, we're doing all this, we've got our groundwater people, but sooner or later, the solar courts are going to decide it. So who's going to decide this? If y'all don't step in and help, it's going to be whoever's got the best lawyer. And that's personally very scary to me and the citizens of our county because our county water's going to. We don't have a well yet or an application for a well, but I promise you, once this takes off, it's coming. And then when you see a dollar being made here, then there's going to be more people coming and everyone that can. And I don't think that's what Texas was ready for. I live on a farm that my grandparents sharecropped on during the Depression. I married the granddaughter of the people they sharecropped for. My father-in-law, J.C. Holcomb, when rural water wells were first started, the rural water, so everybody had water. The highest hill is there behind our house. They come to him and say, J.C., your neighbors all need water. And could we drill a well up there? So he sold them, gave them a little square of land up there. Now I have big water tanks up behind my house, but it supplies the water for our whole area. And I pay a price for it every month. You know, whatever I water, I pay for my own water, but that's still okay. And sometimes I look up there, hear the roar of the pumps, and it kind of troubles me. And then I think back, you know, that was so great that you worry about your fellow Texans and your neighbors, that you would give up something like that so everybody can have water. And I don't want to see somebody just take this water and scientists, everything you read is you can change a number, you can do anything. I trust more the well drillers, the people that work in the industry, and I think those are the ones. And I just think Texas can do better than having all this decided by the courts. And I hope y'all can figure out a way. It's not going to be an easy answer, but I really think we've elected y'all, and we've got good people in the state of Texas that's going to do what's fair and what's right for us and for all of Texas. And I'm going to close with this because I said I was going to be brief. W.H. Alden said, and I've quoted this many times, thousands have lived without love, but no one without water. And that's just the way it is. None of us can survive without this. And I think I've served this on the East Texas Regional Water Board with Representative, is that your dad, David? I've served with his dad for years on the East Texas Regional Water Planning Board. Great guy. It's complicated, but the water, it just keeps going down. If the springs are deleted, everything they've said, it's just an eco nightmare all the way even down into the Gulf. And if you sit and listen to these meetings, that's the importance of these rural waters getting their reports in. I know they're trying to fix leaks, they're trying to get things done, but we have to get the numbers right. So when we do go to a solo hearing to decide what we're going to do, all the numbers are going to be right. So thank y'all very much for y'all's time today.
Thank you, Judge. Senator Nichols.
I had no question.
Go, Scott, your button. Chairman Bell.
Look at that.
Thank you, Mr. Chairman. I think I'll address my question to Judge McKinney of Anderson. Use the nomenclature
He's the
we
one
use
on the
here.
right.
Yeah, he's the one on the far right. You made a comment, and I just really want to make a statement. You said, what are we going to do when all the water in Anderson County gets sent to, by the way, I ranch right across the river. If you happen to go across the bridge there on 79, well, if you look on both sides as you go towards Oakwood, you'll be looking in my place in Freestone County. I don't live there, which means I'm still in the right area that I represent. I live in Montgomery County in Magnolia. But I just want to be clear. No. But now my wife might say she lives there, but I live in Magnolia.
I've been counting the number of days your truck's been in the driveway.
I know. If you could see my house, you might. But anyway, we had this same conversation in Montgomery County a long, long time ago. And what happens is everybody is going to still need the water. They're still going to be granted access to the water, and you're going to overpump. And what's going to happen is your water conservation district and your county and everybody in it, they're all going to be in a fight over water. And that's just the reality of the matter. And I say that not to tell you anything you don't already know, but to just say it for the room. I mean, your point that you made is very succinct. You know, what are we going to do? We got people coming, we got growth, we got businesses, we got all these things. You're going to overpump the aquifer until there is no water, or you're going to use the surface water until there is none, because that's the only thing we have right now. And it's up to this body, I think, to figure out how to put in place constraints that prevent the economic future and viability of Anderson County and all the other counties, 254 of them,
Yes,
to maintain the necessity of water and not have that water show up somewhere else, where it's also a necessity, but it takes away the inherent opportunity of the citizens in the area the water's being moved from. Life, liberty, pursuit of happiness. Those are three things that most of us are familiar with. And without water, you won't have any of them because you can't get to that one life piece. Liberty and the pursuit of happiness go along with that. But I'll stop talking. But I just when you made that statement, I wanted to say that. So anyway, thank you all for being here.
Representative Ashby.
Yeah, thank you, Chairman. Judges, thank you for being here. Judges McKinney, Judge Davis. Judge Davis, I want to highlight something you said, and Representative Bell just mentioned as well, but I think there's a broad consensus here that we would prefer our elected officials, in this case our legislature, not lawyers, determine the future of our respective regions of the state. And I think that's what expects of us. And Judge McKinney, I liked your legacy of leadership comment. It's not lost on me. I think a lot of folks here want to do the right thing. We want to protect our water for the constituents that live there, the private landowners that technically own it in terms of groundwater. But I think this was pointed out earlier, but Judge McKinney from Anderson, you mentioned this, and I think you just can't say it enough. The Redtown Ranch project, you said, would pump over 3 times what you currently utilize in all of the groundwater in your county alone.
Yes, sir.
That's correct.
That's correct.
And then when you add up all 3 of your counties, Henderson, Anderson, and Cherokee, when you look at the future economic viability of the citizens that live there today and that want to call that area home in the future, that this project alone would siphon off 98% of the available groundwater that you have available to us, according to the Texas Water Development Board. And, and I think, again, depending on each member of this committee and my fellow colleagues, no matter where you live, I think that the point here is that you don't want to see proposals that would stymie, limit, have a profound negative impact on our hometowns, our communities, the people that you represent here today, affected by those proposals or projects that have no economic benefit for the people that we're blessed to represent, or those people that we call neighbors and live in amongst our communities. And so I don't really have a question as much as I just appreciate your passion and you being here as the lead official in each of your respective counties and doing such a good job. I guess I do have one simple question. Without maybe an exception of one person, is there anybody in your respective counties that supports this project?
No.
No, sir.
One person, okay, all right. So collectively here, we're talking 170,000 people, and we know of one person that lives there that would support it. And I think that drives home the point here that we're making, and certainly I'm blessed to be an East Texas representative, but nobody wants this in our region of the state. Nobody wants it. And it provides no benefit. And so I'm with you. Now, there's no daylight between us. And so anyway, thank y'all for being here.
Judges, I want y'all to know how much I appreciate y'all being here, and for the leadership. Judge McKinney, you've been ringing the bell, organizing meetings, all of that. Thank you for doing that, for bringing it to the attention of the public. All three of you have had an incredible role to play in getting us to this point. I can't remember which one of you were talking about the economic impact that it could cause that Chairman Ashby was just referencing, but the only way, it seems to me, let's say the Groundwater Conservation District approved the wells. And the entire budget for future pumping has been eaten up. I know how hard y'all work on economic development and recruiting new industry. I think all throughout Texas, that can be said for pretty much any county judge, any county commissioner. That's one of the main things y'all focus on, is attracting new industry and business and economic opportunity for the people that you represent. It's gone, absolutely gone, unless the GMA decides to change the DFC and the budget, which they should only do if the real data suggests that should be done, not to avoid the consequences of denying an application. Do y'all agree with that?
Definitely, and we've experienced 7% growth in population over the last 4 years.
Yes, sir.
Absolutely.
Gentlemen, thank you for your time today. I appreciate you waiting, your patience. Thanks for being here.
Thank you.
I'm going to let y'all clear the room before I call the next set of witnesses. Chair calls Greg Chapin, John Wilbanks, Mark Richardson, and Gene Stokes. Commissioners, thank y'all for being here. If y'all would proceed in the order in which I called you, we'll start with Commissioner Greg Chapin from Anderson County. If you would state for the record your name, who you represent, and proceed with your testimony.
Okay, I'm Greg Chapin. I'm Anderson County Commissioner, and proud to be able to be here today to speak in front of y'all. I appreciate everybody and y'all being here and taking time for us to hear our pains and what we do. I think they pretty much hit on everything. They didn't leave anything out. I think it's been repeated over and over. I think I'd like to touch on the economic impact that I feel like that our local East Texas area is going to suffer. I'm very proud of our East Texas accomplishments of what we've done, taking the resources we've done and built the industries and all that we have. You know, looking at the timber industry itself, over the whole package deal, you know, with the United States saying there's over $200 billion worth of timber processed a year, over 1 million jobs here in our East Texas region, over these 37 counties that we're pretty much representing today. We're looking at about $8.5 billion of that, so that's a little over 8.5% of our production over the United States as a total, and employing over 76,000 people in that industry today, right here in our hometown, along with our cattle industry, which is very strong. You know, we're in a cow-calf more operation. We don't compete with the feed yards out in, you know, the panhandle and all, but we have a really good opportunity growing forages. You know, even some of our crops are peanuts, pecans, you know, our corn growers, some few cotton growers left. We've got all that to do, but one thing I wanted to touch on that's very important, and there's one thing I think that Representative Bell can appreciate, because I spent time on his place with his dad over the years. He's got a place that you better have you some pretty tall brogans on or a pretty stout mule to pull, because it's as boggy as you could ever be to. I'm telling the truth. I've rode over every inch of it and caught cattle for him in there. And he would tell you, Senior would tell you, son, you ain't but 3 weeks away from a drought. And that's the truth, okay? And that's one thing that it's going to, our industry, with our pine industry, you know, we're looking at pulling for the first 12 to 25, first 12 inches to 25 foot is what our pine trees survive on. And a lot of people don't realize that an 18-inch pine tree that's marketable is pulling about 100 to 150 gallons of water per day out of that local groundwater. It's not necessarily in our storage aquifer, but it's in that push of those, you know, springs that are running, the underground creeks that are supporting the creeks and ponds and lakes and stuff that also provide the surface waters for our cattle and stuff to graze with. But 3 weeks of dry weather, those start drying up and our grasses go away, our trees quit producing. You know, so we can just take a simple 3 to 4 week drought and start suffering on production in our tree industry, our cattle industry, our crop industry, the whole bit. It's not going to take much pull on this aquifer to stop that pressure from pushing and giving us that local groundwater that we live on. You know, we're not reaching down deep. There's, you know, looking at the statistics, we got 33% of this aquifer supporting basically our needs for drinking water, potable water to our you know, constituents. But it's that local groundwater that keeps us alive, that keeps us on top, of competing in the markets that we're in. You know, I'm proud to say, like with the pine industry, I think we're the capital of Texas, you know, being Corrigan, Texas, being in our pine production. But all that would go away if I feel like that we start challenging this aquifer, you know, to where even at the shallowest amount to start dropping that water down to try to get in that recharge stage of where it start taking our local water away from us. As commissioners, all of us here, our jobs are to try to build and structure opportunities. So, you know, like they was talking about Sanderson Farms coming in. They drilled 4 wells for Sanderson Farms when they come in. And Todd Stables called me and said, hey, work on this, Commissioner, work on it. This was 11 or 12 years ago, and we fought to get this thing to put together. It added 1,171 jobs to our local, you know, area. We was at about 7% unemployment at the time. It added $192 million to our tax base right then. We had 253 of the farms that didn't fall under the abatement, and today Sanderson Farms paying over $733,000 a year. Well, everything that we can structure and build, every $400,000 that we can gain in capital gain as far as taxable assets, we can knock a penny off the tax rate. Our job is to try to save these people. The people are the ones that are struggling. The rooftops are needing the help to try to get those tax rates down. As you know, John and I, we've worked on this at 61 cents. We're at 47.5 cents, and we got goals still set to try to get it down. But if we deplete our natural resources that we can offer these companies coming in, we'll be limited on taking them in. I mean, with Sanderson Farms, they had 5 proposals on the table, 2 states and 3 other counties, and we were competing with them. If we would have told them we don't have enough water for you, that would have been it for us. So I think that's one of the main things that worries me the most, is that we're not going to be able to compete in that market of trying to get in these business, you know, opportunities to be able to try to grow our tax base to meet the financial demands of the county, to try to help the people. That's one of my goals. And I'll get off the rest. I know y'all got a lot to talk about, but the groundwater districts, I think their volunteers are great. I think my hat's off to them that they'd even take the time to do it. I think they need the training. I think they need the support. They need the backbone given to them to be able to make decisions, do things. I think that they're a little bit reserved. You look at some of them, they make rules. Some of them don't know if they can or can't. I think that's a shortage of something. I know it's a different area, but we got to work on and try to strengthen our groundwater districts like that. But thank you all. I appreciate y'all.
Thank you, Commissioner. Well, most of us understood you, but do my urban friends need me to translate what he just said?
Yeah, it's kind of tough.
I don't think so. All right. Y'all sound similar, yeah.
Yeah, he working.
Commissioner Wilbanks, please state your name, who you represent, and please proceed.
My name is John Wilbanks, Anderson County Commissioner, Precinct 3. I appreciate the opportunity to be here today. Chairman, thank you. Chair members, Senator. representatives, thank y'all so much for being here. First little quote, I hadn't heard it all today, but whiskey's for drinking, water's for fighting. And I hadn't heard that be said not once. But anyways, just wanted to kind of touch on that real quick. I got an update on some statistics from Brushy Creek Water Well Service, actually at 450. So well number 1 was drilled in 1978. In 2025, the static level has dropped 61 feet. Well number 2 was drilled in 1977. In 2025, static level has dropped 31 feet. Well number 3 was drilled in 2022. Static level has dropped 10 feet. 10 foot. Well number 4, drilled in 1986, now in 2025 has dropped 91 feet. Well number 5, 2003 was drilled, 2025 dropped 87 feet. You can see we've got a decline already. We're already in a bind right now with what we're dealing with. And with these water companies doing this stuff, where are they going to get the funding? Well, they're going to go out to you guys. They're going to go to state, federal, whatever they can get the money. Whose back is that on? That's on the taxpayers. That's on you guys. We need y'all's help. We need y'all's help in dire ways. Rule of capture. I know we've talked about this 100 times. It's like beating a dead horse, but the legal framework still governing our groundwater use, first adopted at Texas Supreme Court in 1904 and only modestly addressed in 1917 Conservation Amendment. This doctrine may have suited the needs for a simpler time, but not in Texas in 2025. No way. Back then, we lacked the science and understand how aquifers function, how fragile they are. Today, we know better. Yet we continue to operate a law that is virtually unlimited groundwater pumping, even if it drains our neighboring wells and damages ecosystems. This isn't about erasing landowner rights. It's about updating our policies to reflect modern realities, scientific, environmental, and economic. It's about protecting our communities from being outdrawn, outspent, and left behind. If we fail to act, the burden will fall once again on the backs of everyday Texans. Companies will drill deeper, tapping into shrinking reserves, often to help from taxpayer-funded grants. Water prices will rise, wells will go dry. The ones with the longest straws will win. And the rest of us will all pay the price. And make no mistake, in the decades ahead, the value of land of Texas won't be measured by the oil beneath it. It'll be the water beneath it. We need your help. And that's all I've got today. And thank y'all. Thank y'all for all that you do. And I have no doubt in my mind that y'all are going to represent us the best that y'all can. Thank you.
Thank you, Commissioner.
Thank you, Chairman. Thank you, committee, for having us all here today. My name's Mark Richardson. I'm the Henderson County Commissioner at Precinct 4. These wells that are being drilled are right in my precinct, right next to my cities, just 5 miles north of Pointer, a couple miles south of Moore Station, and to the west of Caney City and Berryville. A lot of my citizens are concerned, and as we heard in the statements before, the closer to this you are, the more your wells are going to drop quicker. A lot of these are co-ops. They're already struggling to keep water to the people. A lot of broke lines, different stuff like that. And we all know where we come from on water. I don't know how many of y'all ever lived off of a well. I did when I was a kid. It tastes like iron, and my white shirt would be orange. So we've come a long way on water. And my constituents are proud to have what they have, and they don't want to lose it. And nobody wants to go back to the old days. The little shallow wells, they were hand dug, and we know when you hand dig one, over your head as deep as you can go, you know, up to your mouth. And when you had a drought, all you could do was go down to the creek and get water. They'd dry up. And nobody wants to see their wells dry up. These towns are already struggling and stuff. We look after them. We want to take care of our constituents. We took $2.4 million of our ARPA money and bought water generation for our plants and stuff. That's where we invested a lot of our ARPA money. So we're looking out for our citizens, and we need some things, rules changed and stuff to take care of them.
Thank you, Commissioner. Commissioner, go ahead.
I'm Gene Stokes. I'm Commissioner in Houston County, Precinct 3. I kind of feel like when I was primaried about 5 years ago that I drew number 3 at a public hearing and our community gathering, and the other two guys got to tell everybody what I wanted to tell them. So anyhow, with that being said, Houston County is opposed to the permits to drilling and removing alarming massive quantities of water from the Carrizo Aquifer. 21 wells in Anderson County and another 11 wells in Houston County. Specifically, the permits should be denied by Nature's Trinity Valley Groundwater Conservation District and should be denied or at the absolute minimum put on hold by the state agency responsible under the Water Code for groundwater and the Committee of Natural Resources. Sid Miller, in an opposition letter on June 10th, 2025, rightly stated the volume of water is alarming, and it is. I think we've all decided that it's an alarming amount of water to be exported out from underneath us. I would ask y'all that, we've seen today through the testimony that the system needs help. Groundwater conservation districts, they need more teeth. And I think y'all can help them. Just to touch on a few highlights, the public interest of East Texans and their private and public rights and water security and economic development. The water level drops, economic activity in East Texas is stopped, is the bottom line. I figure, our community spent a lot of money on water, drilling wells for public water, and this threatens that. This threatens a big investment made by Houston County and the residents there to secure water into the future. So I would ask that y'all consider doing everything that's in your power to, at the bare minimum, postpone these permits. And I won't beat y'all to death going over all the stuff you've already heard. Like I said, I think it's pretty clear that it needs help. The system's not designed for what's being asked of it. So with that being said, I'll turn my time over.
Thank you very much. Senator Nichols.
Houston County Commissioner Stokes.
Yes, sir.
Question. I know in redistricting in 2011 is when I picked up Houston County. Immediately, I didn't wait. I went straight there. And I remember my first day. I went to a lot of meetings, and one of them was one of your service clubs. And I found out I was a programmer that day after I got there. I didn't know it when I walked in. But I threw it back to the audience and to what would y'all like to talk about? This is 2011, 14 years ago. And they wanted to know where I was on groundwater districts. My answer was, whatever, if you want one, I can do the legislation, but y'all have to vote for it and support it. If you don't want one, you won't get one. And the whole audience said, we don't want one. I think after all this happened, my gut feel is the people of Houston County probably would like one today.
I believe you're 100% correct on that. I think the fear of metering agricultural wells and private wells in 2011 probably packed a lot of fear to the community there. But I think today you would get a different answer if you come.
Yeah, well, we're talking. All right, thanks.
Commissioners, I appreciate y'all being here today very much. I'm sorry it's taken so long. Appreciate your patience. Real quick, out of all the people y'all represent, this question was asked of the county judges, but y'all are a little bit closer to the people because you represent smaller districts. How many of your constituents support this project?
No.
0.
One.
Yeah, he's the same way.
Same guy.
Same one.
Henderson County.
Same
Thank you,
guy.
Commissioners. Appreciate y'all being here.
Thank you.
Thank y'all.
Chair calls Cy Ditzler.
that about as far as I can get it for you.
That'll work perfect. That will be perfect.
Mayor, please state your name, who you represent, and proceed with your testimony.
My name is Cy Ditzer. I'm the mayor of Chandler, Texas, a small town on the north side of Lake Palestine. And Chairman Harris, committee members, visiting representatives, and Senator Nichols, thank you guys for taking the time to listen to me. I'll try to be as quick as I can. I know you've been here a long time. Many of you probably want to get home to your families. And I had a written statement, but most of it's already been touched on. And a lot of it is about the recharge rate of the aquifer and pumping too much water out. Our city relies on 5 municipal wells that are in the Crezo-Wilcox aquifer. And if this is allowed to go forward, the static level is going to drop. It's going to drop dramatically. And we're already struggling to drill a new well as it is. The cost of doing that is tremendous. I represent a little over 4,000 people at this time. There's not one of them that want this, not one. And I've listened to some of the testimony, and like I said, I had a written statement, but I'm going to be quick. I'm just going to paraphrase some things. One of the things that was touched on was about the river levels dropping. You can look at the Santa Cruz River in Tucson, Arizona. They started pumping water out of the ground in the 40s in Tucson, Arizona, and it was a running river. That river went underground. It's still there, but you have to dig down for it. It's a dry river. That could happen to the rivers here. If that water level gets down and collapses that area, aquifers can be affected regionally, not the whole aquifer, just a small region. And it could collapse that region, and it could die off just like a limb on a tree. The research is there. I was able to Google things and come up with all kinds of things. You guys, you're our crusaders, and the crusade that you're on is a crusade for water. We're counting on you guys to go back, rewrite this legislation, and protect the water for the people that use it locally. You know, I realize people need water in Tarrant County and other places. We need water here too. And I want to thank you for your time. And you guys, I want to tell you, you guys are tough people. You've been here a long time today. Thank you very much.
Thank you, Mayor. This is kind of a short hearing compared to what we're used to in a regular session, so it's not that bad.
Well, I'm proud of you guys, and thank you very much for what you do.
Chairman
Thank you
Bell.
all. Thank you very much.
Thank you, Mr. Chairman.
Yeah.
Mayor, I have one question for
Yes,
you
sir.
before you go.
Yes, sir.
The understanding is that the water is going to be exported out
Yes, sir.
to somebody else for their use. Do you think your constituents are less valuable than those other folks?
Absolutely not. And they're afraid. They are. Everybody's afraid. All these small towns, especially that rely on these water wells, you know, the small water well operators in the area like RPM and the other ones around, we're all afraid. And it's obvious that listening to all this testimony, they're wanting to take out 3 times the amount of water that some of these counties use. That's mind-boggling if you think about it. And the fact that they're not test wells, they're production wells, and they're meant for one purpose, and it's to transport that water elsewhere. And you know, my thoughts are it's going to go to the DFW Metroplex or elsewhere. No, we need to keep our water here. The conservation districts were designed to safeguard these resources for the people within that district. We need to find a way to keep those resources in that district. If you have to go back and change the legislation, please do so. Find a way. You guys, there's so many of you here, you have resources with people on your staff that are attorneys, that are highly intelligent. Many of you, this is why you're here. You know, we're relying on you guys, you men and women, and we're thankful that you're here.
Thank you, Mayor.
Thank you.
Thank you, Mr. Chairman.
Thank you very much.
Representative Berry.
Yes, sir. I apologize. Yes, sir, Mr. Representative Berry.
Yeah, thanks again for coming out. I have just a question, and I think I'm here in the room here as far as all your constituents in all three counties are just not in favor of this, but I just want to ask a question. If you had a business moving into your city that required the same amount of water, what plans do you have in place to support the aquifer?
That's a great question. Right now, TCEQ has rated our city at, when you hit 85% of your production level, you have to go into a mitigation plan. We're at 109%. But luckily, we're able to use what's known as an alternative capacity requirement, and that alternative capacity requirement is based on your annual usage. Chandler doesn't have any commercial usage of water. We use about 17% of our production capacity right now. So literally, we could double the size of our town, lose our largest well, and still have enough water to provide to our citizens. But at those static levels, if this is allowed to go through and those water levels drop, our wells are from about I've got it right here actually, I can tell you, from 489 feet to 710 feet deep. If the static level drops, we're going to lose most of those wells. If we're lucky to keep one of them, and the one at 710 is not one of our best producing wells. So we can't afford to lose that water. What do we have to do at that point? Do an interconnect with Tyler and buy water from them. That's probably our best bet. We don't want to do that. We want to be self-sufficient. And if this is allowed to go through, I don't think we're going to be able to be self-sufficient.
Yeah, I asked you that question because I have a town in my district that's in the same situation. They're faced with impending developments coming into their area. They're a small town of about 500 people, don't necessarily have the resources to extend water lines to the new developments and do annexation and whatnot. So I feel for you, and I understand where you're coming from. So challenging times.
We're growing rather rapidly. We've got probably about 500 more homes that have been approved. They haven't been built yet. And we just found out about this ACR thing just recently by digging, you know.
I got you.
But thank you for the question.
Thank you for your testimony.
Yes, sir. And once again, thank you guys for what you do. Thank you very much, all of you.
Mayor, thank you for being here.
Thank you. Thank you, sir.
Okay, we're going to call up our next panel of stakeholders. We have Jeremy Kilburn, Paul Woodard, Jimmy Reed, and Amber Stelly. Thank you all for being here. Amber, ladies first. We'll let you lead off.
Thank you. My name is Amber Stelly. I'm the General Manager for Consolidated Water Supply Corporation. We're headquartered in Crockett, Texas. We serve primarily Houston County. We also have connections in Anderson County and Walker County. We serve approximately 16,800 or so residents, primarily Houston County. So we're probably the fourth or fifth largest water supply corporation in Texas. We're quite large. And we're located very proximal to the Redtown Ranch well field. You've heard so much testimony today. I think I'm going to focus on the big white elephant in the room, which is that we are primarily in Houston County. So we are, of course, in the white target area, no GCD. You heard from Dr. McCall earlier, the new chairman of the Houston County GCD Steering Committee. I'm his vice chair now. I was asked, because Senator Nichols asked Commissioner Stokes, I too was asked, well, what do you think? Do you think Houston County needs a GCD? Is it time? And I was asked by Judge Lovell and Commissioner Stokes, and I said, no, I think it's a terrible idea. I don't think a GCD is going to help us. You know, it wouldn't help us if If these applications go through, then our GCD means nothing. However, if you're going to do one, I want to be involved with every step of the process, everything. So I got my wish. I'm going to start reading now so I don't miss anything. But because we're talking about Houston County, I want to highlight the volume. We've heard 51,000 acre feet, but that's the amount in the permit, so it does not actually consider those 11 other wells. So when we look at the applicant's hydrology studies, it's actually 61,800 acre feet from the Carrizo-Wilcox area. Okay, that's important. I had trouble understanding that number. It's 20.1 billion gallons just from the Carrizo-Wilcox. I still, and I do this for a living, had trouble understanding that number, so bear with me. It's 10 counties worth of water. So I'm going to read them out to you because I don't want to leave anybody out. Many of them are represented here. But it's Anderson, Houston, Walker, Angelina, Cherokee, Freestone, Henderson, Leon, Navarro, and Trinity counties. So their combined 2022 use was less than the 61,000 acre feet that is proposed in the project documents for this applicant from Carrizo-Wilcox. That's a lot of water. And you heard Angelina County was in there. That's a big one. They're a big user. According to the applicant's own hydrology reports, this is an export project. Okay, I'm going to quote this planning region that, or planning regions that this is destined for. Planning region C, G, H, K, and or L. What's not mentioned is I, which is where these wells are being drilled. Redtown Ranch is in Region I. That's where my 12 wells are for my system. Region I, although I'm very empathetic, all of those regions mentioned, they are experiencing an issue. They have shortages. Region I is also projected to have a shortage of about 183,000 acre feet by 2030, 205,000 acre feet by 2070. That number is more than some of the needs that are cited in the applicant's report for these other areas. Okay, so Region I is in trouble too, and I think we've heard that from many others testifying. And that's according to the 2021 State Water Plan, just so I cite that reference. So what are the impacts of this? If you read through the hydrology studies, we don't have our own yet. Of course, we're going to try to find a firm that's not conflicted that can do those studies for us. But the applicant's own documentation lists several troubling numbers, anywhere from hundreds of feet of cumulative drawdown per formation to 1,434 feet mentioned in the Middle Wilcox formation in the first 5 years. And of course, that number is, I'd say it's qualified as being modeled from a number. Really, that number probably doesn't mean much because the model can't really be tested at those volumes. They had to scale down their pumpages over those 5 years to even get the numbers to work. So that's a terrifying amount of volume. So what I'm most concerned about when I look at those numbers is, of course, my own members. I mentioned 16,800 members or people, voters. But then there are the thousands that I don't serve right now, and I don't know what that number is. But some of the estimates are that we have 1 to 4,000 private wells, maybe, just in Houston County. Right now, those residents are self-sufficient. They have a private well. They don't want my water, and I don't want them to be forced to buy my water if their wells dry up. So I think that our private well owners are very good stewards of the environment. They can do a lot with a very small amount of water. However, if these wells go online, we know from not models. We've talked about the junk science that can be produced with models, but if we just look at observations in recent history, we know that we will have, Vista Ridge is what I'm referring to, by the way, in maybe the first month, hundreds, dozens, I don't know, but there will be private well failures that will be almost immediate. Consolidated, because of where we're located, with our closest well about 6.5 miles away from this well field and distribution lines even on this property and all around it, we will be faced with the pressure and the public health emergency that is, how do we get these people water? They're going to need water. They're going to need it fast. Some of our local well drillers, they might already be 2 years out. So we're going to be faced with I don't want to use the word again, and I'm going to say unprecedented service emergency here. I don't have a solution right now, but I am inspired to see how many people are in this room that care. I'm really pleased. I think that with everyone that I'm looking at right now, we actually have the people that we need to solve this problem. I don't think it's a Houston County GCD. I think that might be a tool in the toolbox, but I think that this is a modernization of rule of capture problem that we need to address, and I really want to work with everyone in here to do that. And I'm not trying to rag on GCDs, but I think from what I've heard today and what my own research, which I'm not an expert by any means, what I've learned is that these GCDs are fragmented. It's a fragmented approach of regulating an aquifer that does not follow those jurisdictional boundaries. And so it's almost meaningless, but I appreciate that it is an option, it's local control. But as I mentioned, it doesn't matter what we do in Houston County if these permits go through. So I'm asking everyone in this room to please consider that while we have such attention, and all of these experts, true experts, not 2020 experts, telling us that what we have, our framework, rule of capture is outdated, that we leverage this information to make some real meaningful differences here before it's too late. I heard a lot of talk about desired future condition. I did some research there. I didn't hear anyone mention a desired future condition that was more water than we have now. It's always less water than we have now. So 155 feet of drop. I think that number was much less before that if we go back and look. But no one here said we really need to gain a foot in 70 years, 50 years. It's always, what are we willing to accept? What is a loss to the aquifer that we're okay with? And I think that is a bad way of thinking, but it's kind of the only thing that we've had. It's the best that we've had is what I've heard. Excuse me, and I forgive you for not understanding what your budget looks like. I should know this. I think it's maybe 233 billion is somewhere around there. I think your job would be so much harder if you were told, okay, next time we're going to give you less, and you need to figure out how to do more with it. And you don't know how much less, but you know it's going to be less. And so I'm asking everyone in the room to please, while we have this attention and this focus on this really urgent problem, if we could work together, I would really like to help, hopefully, be part of the solution. And I'll take questions later.
Thank you. Mr. Woodard?
I had good afternoon written down. I'm going to say good evening. Mr. Chairman and members of the committee, my name is Paul Woodard. I'm an Anderson County landowner, and I'm the president of Lone Pine Water Supply Corporation, and I want to thank you for inviting me to be here today. I'm going to honor your request. Every issue that I have on these pages has been addressed in spades for the last 7 hours, and I can't really contribute anything further to them other than I haven't heard a lot about conjunctive use of ground and surface water. I think obviously that's going to be a part of the solution. There was desalinization efforts. I don't know if the efforts are need to be that much better, but I think the efficiency needs to be on bringing the costs down. And conservation is a huge issue. And all I'm doing is giving you some ideas on how you're going to work to solve this Herculean task that you have in front of you right now. We're talking about issues today and 10 years out. I guess I'm more interested in what's Texas going to look like with water in 100 years. Because nothing moves very fast in government, and a lot of projects that require permits take a tremendous amount of time. So if we're going to look at surface water, we need to be thinking about it right now, because it's going to take a while to get any of that. I love the gentleman's comments about the Parks and Wildlife projects and recycling that water and feeding it back into the systems. It's those kind of ideas that's going to help solve this situation. And I applaud you for this meeting today. I applaud you for your attention and the fact that people that aren't even members of this committee have committed their entire day to this. As Amber stated, we all just want to be a part of the solution. No one is selfish enough to say that we're not willing to share what water we have available to share. But that's no different than helping one of our neighbors. But our neighbor's not going to ask us to give them assistance to our detriment. And so I think, as that's been mentioned before also, that has to be considered. Our immediate demands for water can't overwhelm our long-term future needs of where the water's going to come from. And like I said, it's a Herculean task you have ahead of you. And I have heard some really amazing testimony here today from a lot of people. And so as long as that group of people is working on this issue, I think a very workable solution can be found. And I'll cede the rest of my time, and I thank you for having me.
Thank you, Mr. Woodard. Mr. Kilburn.
Thank you, Chairman Harris, and this committee for holding this hearing today into the alarming circumstances surrounding the applications that we've been talking about today. One note of sort of hopeful levity in light of the fact that there's not going to be much brevity today. When I've served for, in the past, I served for 12 years, almost 3 full terms as a member of our local school board back where I live in Georgia. When I finished that service, I said that is the most underpaid and thankless public servant's job that there is. After this ordeal and hearing Mr. Chairman Morrow, I've changed that longstanding belief that being on a district water board in East Texas could be the most thankless job, public service job you can have. As Chairman said, my name is Jeremy Kilburn. I'm the Chief Legal and Compliance Officer of Wayne Sanderson Farms. We're the 3rd largest chicken producer in the country. We're actually the largest company that just does chicken. Our larger brethren do other proteins. And I've had the privilege to work for the company for over 13 years. I'm a proud native of East Texas. I grew up in Pittsburgh, Texas. Proud to claim that as my hometown. Oddly enough, our CEO grew up in Henderson, Texas, Kevin McDaniel. I think you may have grown up with one of the gentlemen on the dais today. But growing up in East Texas, I know firsthand the important role that agriculture and agribusiness play in the economy for our region. Both my brothers are farmers here in East Texas. One's a chicken, cattle, and hay farmer. The other grows vegetables up around Pittsburgh. And they're not unlike most of the thousands of folks that have chosen to live their lives off the land in small communities from Navasota to New Boston. They work hard to grow the food that the rest of Texas and our nation rely on every single day. And that's the same lifestyle and purpose that drew the first Texans to settle and homestead in East Texas in the first place. That and readily available water. But that lifestyle, that purpose of an agricultural life and livelihood that collectively contributes billions to the Texas economy, tens of thousands of jobs, and puts food on the plates at dinner tables all across this state, has been threatened by under-the-table deals and misleading permit applications, all designed for one clear purpose: to take the water right out from under the feet of East Texans and to get rich doing it. Or in this case, maybe a little bit richer. Wayne Sanderson Farms will not stand idly by and allow speculators to take water out from under our farmers, our facilities, our team members, and our communities. And we're prepared to pursue every legal remedy available to put a stop to these antics. We're one of the largest poultry producers in this state, and our operations depend entirely on a reliable source of high-quality groundwater for poultry production at our 350 family farms with whom we contract, as well as our 4 processing facilities in Bryan, Tyler, Waco, and Palestine. We employ over 5,700 workers in this state. We have billions of dollars of investment in communities across rural Texas, and we contribute significantly to the local economic well-being of our communities. Our operations contribute $185 million in on-farm income annually. That's direct payments to chicken growers. That doesn't even count payments to corn growers for the feed that all those chickens eat. We pay over $325 million in wages annually in the state of Texas, and we pay over $13.4 million in property taxes in this state every year. We produce close to 500 million pounds of chicken, which is the healthiest and most affordable protein every year, just from these Texas operations. And much of that's sold in restaurants and grocery stores right here in the state. We currently have planned over the next 5 years to invest $391 million in projected capital investments in the next 5 years just in Texas alone. That's $391 million. And that doesn't include the $60 million or so in on-farm investment in chicken houses that it would take to support those growth plans here in Texas. Needless to say, those plans are in jeopardy right now because of the uncertainty around water availability that has resulted from the unprecedented actions of Mr. Bass and his companies. We're here today, and for as long as it takes, to fight to protect our investment and ensure that the groundwater users in Cherokee, Anderson, and Henderson counties and the rest of East Texas are protected from large-scale production projects like this, especially ones that intend to pump water away from those that rely on it for their livelihoods. We believe that the current law can be improved to ensure that existing local users are not negatively impacted by large projects. Through the testimony today, we hope to shine a spotlight on these particular applications and what we believe to be a process that was fraught with legal and ethical concerns. First, I thought it appropriate to set as a baseline, if you look up the definition of conservation in Merriam's online dictionary, the definition you get is conservation is defined as a careful preservation and protection of something, especially planned management of a natural resource to prevent exploitation or neglect. And if you read the charter of the Natchez and Trinity Valley Conservation District, you'll see very similar words and thoughts: preserve, protect. There's nothing about the current application or the proposed use that is remotely aligned with that definition or that mission. And naming your company Conservation Equity Management doesn't make it so. We urge this committee to seek answers as to how an agent of the applicant was allowed to remain on the board of the Groundwater District up until a few days before the first public hearing on this matter. We would urge the committee to find out why the applicant chose this particular individual to partner with on his well drilling projects. Of all the well drillers in the world, why did Mr. Bass choose this one? That's a question I'd like to see him answer under oath. We urge this committee to ask the applicant to explain why they believe that none of the 7,000 East Texans who have challenged their unprecedented permit, why they have stated that no one has the legal standing to challenge their ability to drill those 43 wells that are capable of extracting the 15 billion gallons or so of water we've heard about today. We'd urge the committee to ask the applicant to explain why they have claimed publicly and in their application that this request is merely to explore for groundwater. We've heard a lot about that today, when in fact they've already bored and drilled several wells. They've evaluated the production capacity of this aquifer. These 43 wells are not for exploration. We'd urge the committee to ask the applicant and the investor where they intend to use this water and for what specific purpose. Do they even have a contracted customer? Or, in other words, is this just a bet against Texas having a stable and sufficient water supply in the future? His website pretty much says that. And if that's the case, and this is a bet, how does Mr. Bass and his companies intend to cash in that bet? Perhaps through monopolistic and predatory pricing strategies? I don't know. It's something this committee should consider. We urge the committee to ask the applicant how moving this high volume of water from East Texas will impact local agriculture, which is dependent on water, and whether this applicant intends to mitigate the negative impacts on existing local users. Perhaps he can offer to drill a well for all 350 of our chicken growers whose wells will likely not be able to produce sufficient water for their operations anymore. I doubt he's willing to make that bet. We urge this committee to ensure that the pending applications, as well as any future applications in this district, comply with all district rules and are reviewed and voted on by an unbiased and properly appointed board. We think these questions illustrate some of the concerns with these applications and the current application process in the Natchez and Trinity Valley Groundwater District, which need to be rectified. And we'd ask for perhaps some guidance and consistency to be provided to all of the water districts so that this piecemeal process that has been undertaken by this applicant, where they apply for an exploratory permit that they hope is not challenged in the public, allowing them to then invest millions of dollars before they apply for an operational or transfer permit. Because once they apply for that transfer and operational permit, after they've invested millions of dollars, you've heard the testimony today, they have a pretty good case against a denial of those new permits under the takings theory, under the investment recoupment theory. Their lawyers are pretty smart, and they figured this out. There's a reason they chose this district. It's because of the procedures that were there, the availability of a high-producing aquifer and cheap land. So businesses need predictability, and the people of East Texas and the farmers of East Texas deserve better. So we're hoping we can partner and certainly willing to offer any input that we may have on statewide legislative action to provide a fair and consistent process that businesses and citizens can rely upon to make long-term business plans and decisions, and to help ensure that all local users are not negatively impacted by attempts at these large-scale withdrawals like this one. Again, we support economic growth. We're heavily invested in the future of Texas agriculture, but groundwater is a precious resource, and it needs to be managed responsibly and equitably to ensure the long-term health and economic viability of the East Texas region. And make no mistake, we want the folks in places like Dallas and Houston and San Antonio and Austin, we want them to have plenty of water to use and to drink. The question I have for this committee is, what are they going to eat when the good folks in East Texas can't grow it for them? That's all the remarks I have today. I'll yield the rest of my time for questions.
Thank you. Mr. Reed.
Well, good evening. My name is Jimmy Reed. I'm a fifth-generation rancher from East Texas in Anderson County. I'm here to represent myself and Anderson County Farm Bureau. Y'all have heard just about all the information that I would have had today, but I just want to urge y'all to be considerate of the legislation that's made in the future. Mr. Bell several times said we have a finite resource that we're dealing with here. And, you know, I think it is our responsibility, you know, as stewards of the resources that we're given, to take what we've been given so that, you know, our grandchildren, our great-grandchildren aren't facing the struggles that we're facing with water, or that is proposed that we will be facing here. Texas Farm Bureau has fought for the rights, our water rights for the landowners for years, but quantity limits have to be considered when we are making legislation so that each person has their fair share. The fair share needs to be mitigated and legislated. Our decisions are going to impact the future generations, so I just want to urge y'all to consider the decisions that we make. Thank y'all for your time. I know it's been a long day. Thank y'all for your dedication to Texas.
I appreciate y'all's patience today. I know it's been a long day and been a lot of people waiting in hot rooms and all that, but thank you for being here. Appreciate your testimony. Mr. Kilburn, how many wells do your contractors have throughout Anderson, Henderson, Cherokee, Houston counties?
In those counties, I'm going to estimate north of 100.
North of 100. You had to apply through the GCD for all those wells?
For those that are covered by a district,
Those that are
yes, that's
covered.
true.
Did y'all drill any that weren't permitted?
I don't know if our contract partners drilled any that weren't permitted. The wells that we have drilled at our production facility in Palestine and Tyler and Bryan were all permitted.
So 100 wells supplying the water. I can't imagine how much water the chickens drink every day. That's a lot of water, I'm sure.
It is the air conditioning for the chicken houses too, which is an important feature in East Texas.
Massive impact if those wells go dry, have to be lowered, have to be re-drilled, right?
No question. We're already seeing, we're getting reports from some farmers, they're already seeing salinity issues. I'm not a hydrologist, but I've heard the metaphor of squeezing a sponge. Apparently when you squeeze the sponge at the end, you get a little bit of salt water. And that's where some of our farms already are at. They're much shallower wells than what we would typically use in a commercial setting. So yeah, I mean, they're going to have to spend hundreds of thousands of dollars to drill deeper wells if that aquifer level is lowered. And it could put them out of business. They may choose, rather than spend $1 million on a new well, I'll just stop growing chickens. And then their property values plummet, and it'll be every bank that has poultry loans ought to be concerned about this.
Representative Hefner.
There it is. My question is not quite as serious. Mr. Kilburn, I too grew up in Pittsburgh, and
I'm aware.
I've known your brother Jeff since I was a kid. But how did he get? I guess he got all the height, and you got the brains and the looks in the family. I guess, right?
He can play a fiddle too.
He can. Not a bad singer either. We appreciate y'all being here, and I think my wife coaches your other brother's kids in cross-country too, so.
Very possible.
It's kind of a strange coincidence. Appreciate you being here and appreciate your testimony.
Yep, thank you.
Representative Bell.
Thank you. Just a quick question. Obviously, Sanderson Farms is a big economic driver in Anderson County, across Texas in general. And you kind of touched on my question, which was, we've heard testimony suggest that the aquifer may be expected to drop up to 1,000 feet in some areas. So my question is, those wells that are supporting those, even the ones at your facilities around, how deep are those wells normally?
The chicken farm wells they're not going to be probably in that 1,000 to 2,000 foot max depth. They're not deep wells like commercial wells, but what I would say is a 1,000-foot drop or even a 100-foot drop. A 100-foot drop is going to cause a big problem for most of the chicken farmers in Northeast Texas.
If it's any more than that, it's certainly going to cause problems, and that's going to take out most of the residential wells, Mr. Chairman, as well.
Yeah.
Thank you for your testimony. Thank you, Mr. Chairman.
Anyone else? Thank y'all so much for being here. Appreciate your testimony. Chair calls Carl Ray Polk, Tony McCarty, Rob Hughes, and Adam Friedman.
You call me last.
Okay.
I'll sit on the end.
All right.
I'll do that one.
I'll just go right here.
All right, let's go my left to right. Mr. Friedman, you want to go first?
Yes. Good evening, Chairman and committee members. It's nice to be here. My name is Adam Friedman. I'm an attorney here in Austin, and I represent Houston County. Until about 20 minutes ago, I thought we had a unanimous group in favor of a groundwater district. But after hearing Ms. Stelly's testimony, I think it's important to highlight, this is something that we're all going to have to be wrestling with, and that there's differences of opinions, and it's something that we with Houston County will be working on creating a groundwater district, if that is the wishes of the county, and of course the voters will ultimately have to do that. So just thought that was a nice anecdote to start off with. A lot of testimony in unison today, but at the end of the day, these are very hard decisions. You talk about the rule of capture is a monster policy and has been, and there is no easy answer, and this is something that I've been working on and with a lot of folks in this room for well over a decade on what we're going to do about that rule. So very, to use a word of Ms. Stelly, inspiring to hear this conversation go on about the rule of capture. And I wish you all well, and I'm glad to see that we're all doing it together. Now, I represent a lot of landowners, a lot of governmental entities, and a lot of commercial entities, and that can be as applicants for new water. It is protestants, folks challenging big applications, and it's also the decision makers. I represent general managers and board of directors for groundwater districts. I represent cities who are looking for water. So I've seen it from a lot of different angles. Now I'm mostly on representing and working with landowners and folks who are concerned about the massive impacts of projects, big groundwater projects like this one. And that's certainly the role that I'm playing here for Houston County. Picking up on what Ms. Stelly said on behalf of the Water Supply Corporation, the more that we've been digging into the files, the reports, and the applications, the size and scope of this project may actually be even worse than we originally thought, which is hard to imagine. Now, there are 21 wells planned for Anderson County, which is about 10 billion gallons of groundwater per day, and we know that's on top of the 22 wells in Henderson County, which is about another 5 billion gallons per year. What Ms. Stelly pointed out is if you dig behind the notice of the applications that we all saw for that June 19th hearing, there are hydrogeologic reports that have been submitted about Houston County. 11 wells for a total of 18,356 acre-feet of water. That's another 6 billion gallons. So we're up to about 21 billion gallons of water per year from those counties. Now, I think the effect of that has been discussed at length today by multiple perspectives. It's hard to dispute that. The impact it will have on Houston County's 20,000 plus folks is obviously severe. Now, one of the themes is that the challenges that are facing Houston County and Henderson and Anderson and Cherokee County, it's not unique to them. I mean, that can happen anywhere over the state. It sounds like folks have talked about big projects that they've seen. Now, even the groundwater district, or the lack of a groundwater district for Houston County, is not quite unique to Houston County. There are 80 counties about that still don't have groundwater districts that could face similar projects like this. This is a textbook example of what is a common fear of a large well field strategically located in a county that doesn't have a groundwater conservation district. This is not the first time. My first time to experience that was back in 2015 when there was a large groundwater project more locally here in Central Texas. That ultimately led to the expansion of the Barton Springs Edwards Aquifer Conservation District. Houston County is now squarely in the tight hot spot of facing this same challenge, and they won't be the last. And so while it's certainly them that is now facing this, it's not unique. It could, certainly any county can have a big permit application filed, but even the challenges of not having a district could be in many places in the state. So, which leads to the second issue is these groundwater conservation districts, point that was made earlier, the aquifers don't stop at county lines. And so as we talk about how are we going to manage and protect property rights for all Texans, how are we going to size these groundwater conservation districts? And that's something that might be looked at. And for example, the Neches Trinity Valley Groundwater Conservation District does not include Houston County. But we know that the 21 wells in the southwest corner of Anderson County are undoubtedly going to affect the northwest corner and beyond of Houston County. Now, we believe and we're confident that that groundwater district is going to consider the impacts to Houston County from those wells. But I will tell you, if you look at the hydrogeologic reports, the first thing you'll notice on the proposed or the projected drawdown by the applicant intentionally omits the anticipated drawdown in Houston County. It's pretty clear that they intend to try to have the groundwater district put on blinders to look only at the counties within their district. And I think I just want to point that out because that is a problem with sometimes the size and boundaries of these groundwater districts, and we certainly intend to have a seat at the table and raise the issue of the impacts across the border on the Water Supply Corporation and their wells that service Houston County and all the other citizens that use that water. Now, we also talk about the modeling, and if you look at their reports, they modeled for 5 years. Well, the life of this project is much longer than 5 years, and a tip of the hat to the groundwater district, they responded to those applications and they requested that the applicant model for 50 years. Now, all of that modeling will be vetted at a hearing at SOA, but the point I want to make is that is one valuable thing that a groundwater district can do. If those wells in Houston County, there is no groundwater district to push back and say, hey, we think you need to model for a different duration. So I just put that out there as one benefit to a groundwater conservation district. At the end of the day, when SOA makes its recommendation and ultimately the board of directors will decide what to do on those permit applications, that decision will be made without a single representative from Houston County, even though the impacts of those permit applications will have a drastic effect. And so we'll be working with Houston County on what we're going to do about that going forward. Now, the district will hopefully consider the subsidence and all of the modeling and all of the water quality issues and the impacts to existing wells, but it's incumbent on the people participating, the affected persons at that hearing, to challenge those applications so that the judges and ultimately districts see what needs to be done. And I'll just share one last anecdote about groundwater districts. there was a large permit application in Central Texas where an applicant had filed an application and referenced in their modeling that there would be some drawdown, but that it shouldn't be unreasonable. It's really nothing to worry about. Folks got involved, landowners protested it, did their own modeling. What it turned out was over the life of the 30-year project, the drawdown was hundreds of feet beyond 5 miles. And again, not here to relitigate that case. I can assure you there's lawyers in this room that would have differences of opinion of how that went down, but the point I want to make is how nice it is to have a governing body to consider those issues and have a venue for folks to come in and present their case, which is something that Houston County does not have right now. And ultimately, that groundwater district reduced the size of that permit application by about 80%. And it was courageous, it was brave, because of all of the takings litigation and all of the things you've heard about. It took a bold move, and for that one stuck, for now. So I just want to give another tip of the hat to the potential help that a groundwater district can provide. With that, I thank you all. Houston County certainly thanks you all, and we'll be working together.
Thank you. Mr. Polk.
Good evening, and Chairman Harris, thank you. Members of the committee, thank you for the time. I promise you I will be brief. Never thought that the chicken guys would be ahead of the beef guys there, Mr. Chairman, but that's okay. We'll take it. I do thank you for the invitation to be here tonight. My name is Carl Ray Polk, and I serve as president of the Texas and Southwestern Cattle Raisers Association, also known as TSCRA. But I'm also a fourth-generation rancher and landowner in Houston County, Angelina County, and Cherokee County. TSCRA is a 148-year-old trade association, the largest and the oldest state association in the United States. We represent approximately 28,000 individual members, and we care for about 9 million head of cattle annually. Many of our members, as you heard from today, are in this area of East Texas. And to take Dr. McCall's comment, Houston County is about number 3 or 4 in production of cattle in Texas. Our members rely on groundwater every day. It is by far the single most important asset that a rancher has. And they depend on it not only for their livestock, but their land and their families. So we understand how critical that is that we manage and share this resource wisely. TSCRA has always supported local groundwater conservation districts managed by local elected officials and board members because they are grounded in the idea that the area landowners with a vested interest in their aquifers and their groundwaters have a voice in the management of the groundwater. Doing so with honesty, with transparency, and based on local needs. The Natchez and Trinity River Groundwater Conservation District's recent permitting of the wells that you've heard about does give us some pause, but it has raised key concerns about the long-term water viability for the agriculture community across the state. We're not here to challenge the existence of the Groundwater Conservation District or the roles it plays, but we're asking for a fair and transparent process. Many of you, most of you probably heard more testimony this past session from cattle raisers than you've heard in many, many sessions. But you recognize also the critical importance of rural Texas. Since we gavelled out, and I thank each one of you for the efforts that you put forward, this one issue has come to our policy committee and has raised a lot of concern, which we'll be taking up going forward as to how our policies are written around groundwater and groundwater ownership. We thank you. I'll take any questions. And Chairman, thank you for allowing us to be here.
Thank you, Mr. Polk.
Oh, I'm sorry.
Mr. McCarty.
My name is Tony McCarty. I'm the rural water operator for the Natchez Water Supply Corporation. We are located between Palestine and Jacksonville. And I want to thank the committee for actually allowing a rural water system to have a voice. It's not every day that we get this chance, so thank y'all very much. We're a fairly small water system. We serve an estimated population of 2,300. We have 678 active connections right now. We have 3 wells. And if you'll look in the graph that was submitted, the recording well that the Texas Water Development Board uses and the Groundwater Conservation District, that's in our system. But I want y'all to know that that well has no water pumped out of it. There is not a pump in that well. It is specifically just for monitoring a water table. And over 60 years, that table has dropped 98 feet. And you can go back, and if you look in that graph, there's gradient lines, and there's two different wells in that graph. A line above the gradient line indicates a water table drop, and a line below the gradient line indicates a recharge year. So if it stays on the gradient line, that means we didn't lose any water, but we didn't gain any either. And you can go back and find the drought years just based off of those lines right there. And so no matter what the recharge we get, it never goes back to the original static level. So our average water table drop is 1.6 feet per year currently. And so we are located dead center between the two well fields. So there's absolutely no doubt that we will be affected by this. We only have one well left that we can lower the pump in, and our other two wells are at max depth already. And so the number that you've seen, 1.5 million to drill a well, that is accurate. That's just to drill the well. That's not to build a new plant. And if you go drill a new well and put bigger pumps in, for us, we also have to have bigger booster pumps because we are a hydropneumatic plant. So that total cost to build a new plant for us is $4 million. And there's no such thing as low-cost financing for rural water systems. We receive no tax funding. We only receive funds from what we charge our customers. And we simply cannot charge our customers enough to offset the cost of a new plant. And so included in this, I've put an example of what financing would be for us on a $5 million project, because the power, just like the lady from Houston County Co-op said, it would be up to us to get the power to where we need to drill a well. And currently, there's no three-phase power where we need it. So you're looking at extra cost on us to even get power to it if we can find the property. Nobody wants to cut out 4 acres of their land for a water system to drill. So if you look at a $5 million project, and if we qualified for a 70-30 grant, which most water systems will not qualify for that just because of the median household income threshold, our portion would be $1.5 million. And a low-cost loan, in my opinion, would be 3% interest, which I'm sure the interest rates are much higher than that. On a 40-year loan, that's how far out we have to go. Our annual payment would be $65,000 a year, and we would have paid back $1.1 million worth of interest, making us our total cost of $2.6 million. We simply cannot afford that. We can't push that out to our customers either. And so this would have extremely negative effects on us. And sorry, this is a big stage for me. I kind of lost my train of thought.
You're doing fine. You're doing really good.
So if the high capacity wells are allowed, how are we going to pay for it? And once we become a rural water system, we can never stop pumping water. The state says we have to pump indefinitely. So if our wells go dry, we can't afford to drill new wells. Are the state going to fine us until we are able to get that? Or are we going to receive funding from the state in the form of really low financing, like maybe a 90-10 grant or possibly a 100% grant? And that goes the same thing for the rural people too that have their private wells. I mean, how do they afford it? And just recently, February of last year, we had to lower a well pump. 3 joints of 3-inch steel pipe and 60 foot of electrical wire was $7 grand. And I provided half the labor to do it. So if you go to a bigger well, you're looking at higher costs to lower it, if you can lower it, which we cannot. So something that we would like to see on a local level pertaining to the permits is, for one, the notification when it comes to the high capacity wells, those need to be pushed out to the rural water systems because we're the first to be affected on that. The second is, if we're going to have some people on that board that have experience in water, I would like to see that the rural water systems select a representative to serve on that board. That way somebody with some kind of experience is on there based on the rural water systems. And then as far as the funding goes, the new water fund, we need specific funding for rural water systems so that we don't have to compete against cities or municipalities or anything like that. That's all
Mr. Hughes.
Thank you, Mr. Chairman and committee members. Senator Nichols, thank you for being here. Thank you for the opportunity to testify in front of this committee. I'm Rob Hughes, the Executive Director at Texas Forestry Association. As a forester and wood scientist by education and trade, I'm a little out of my element, and I've been fascinated by the talk today on hydrology from engineers and lawyers, neighbors of the forest industry here in East Texas. So I appreciate having to be a stakeholder at the table, which is wood, I would say. So you're welcome. We represent a broad, diverse group of private landowners, timberland investors, foresters, loggers, wood product manufacturers, natural resource professionals who collectively care for over 12 million acres of working timberlands in East Texas. I appreciate the opportunity to share how forests intersect with water policy and why sustainable forestry and its management must be part of the Texas water strategy. All waters, not just surface water. The Texas Forestry Association and the Texas A&M Forest Service have worked side by side for over 25 years to advance voluntary, non-regulatory water protection through the Texas Forestry Best Management Program. These efforts are science-based and highly effective, and here's the statistics. Over 19,000 miles of streams are now protected by forest land riparian buffers. 1.4 million acres are designated as streamside management zones. BMPs prevent 77,000 tons of soil erosion and almost 10,000 tons of sediment from entering Texas waterways each year. BMP implementation has improved from when we started 25 years ago at 75%. Now we're in compliance of more than 95%. This is conservation at scale without regulation, and it works. In areas identified as groundwater recharge zones, forest landowners routinely go above requirements of the BMPs, and many have voluntarily restricted herbicide and pesticide use well below label requirements and have used thoughtful techniques like strip harvesting and things like that. Expanded their streamside management zones to increase natural filtration, even at a significant cost of not removing high-value timberlanders along the stream zones. Adjusted their harvest operations to reduce soil disturbance and allow for better infiltration and lower sediment runoff during rainy seasons. These are not mandates, these are choices made by the stewards of the land who value water quality as much as timber production. I want to thank this committee and you, Chairman Harris, and Chairman Perry, who was here earlier, for securing that $7.5 million in dedicated water science funding in the recent session. That investment is a crucial step forward. As Texas continues to grow, so does our demand for water, but we still lack complete understanding that we talked about today, obviously, of how surface water and groundwater interact, especially in regions with complex aquifer dynamics like this one, and those big bottomland hardwood timber zones that we get our pallets from and make our railroad ties. We're encouraged by the work of the Texas Water Development Board and strongly support ongoing investment in hydrologic modeling, monitoring, and data transparency. With better science, local groundwater conservation districts can and will make well-informed decisions, ones that protect resources, honor property rights, and build public trust. Texas forest lands are part of the water solution. They safeguard our rivers and aquifers, enhance recharge, and anchor our rural communities. As discussions continue about water wells and water use, I urge the committee to keep forests in focus as both a conservation asset and a strategic partner. Captured water is vital in forest products manufacturing, and there will be no working forest or healthy forest without markets. Mills utilize and reuse water to store log inventory, fire suppression, keep their saws cool, and hydrate their employees. We look forward to continuing this water discussion. And one thing is for certain, there's a lot of questions today, but one thing is certain, you can't grow trees underwater. Thank you.
Thank you. Members, any questions? Representative Ashby.
Adam, first off, good to put a face with a name, and glad to know that you're helping Houston County. Look forward to working with you there. Mr. Polk, Mr. Hughes, and I'll reference Mr. Kilburn over there. You know, your three industries, poultry, livestock, and forestry, just are really I guess the backbone of the economy of East Texas. And so I so appreciate y'all being here, your testimony, and the commitments you have for your membership and protecting their interest. And I look forward to working with you on that. Tony.
Yes, sir.
You know, I hadn't thought about the perspective from our rural water supply corporations, but, you know, across the state, do you know how many there are? I mean, it's got to be hundreds.
I have no idea the number, but
There's
it's
a lot.
a lot.
There's
it
a
covers
lot.
a majority of Texas.
Yeah, but I think your testimony was really powerful into describing to us as committee members and interested parties what the real world impact would be on your customers that you serve, those connections, and the Natchez Water Supply Corporation. And I think your example of just being real about the cost of what you would have to incur your ratepayers, your customers would, I mean, it's just hard. I know you can't quantify that because you don't know, again, what a loan would look like or the interest rate, but your point is well taken, that a $5 million project for your customer base is unrealistic.
It is.
And I think as policymakers, we've got to consider if we as a state have said that you as a rural water supply corporation, you have to provide water to those customers, but yet it's unrealistic in terms of the cost. Your question was a very, I think, well-placed question, and that where does that leave us? And I have not thought about that, but we have water supply corporations all across East Texas, and I really, you've got me thinking on that, but I appreciate you being here, making the drive over from Natchez, and
Thank you.
thank you for being here.
Representative Hefner. Nope. Representative Gonzalez.
Thank you, Chairman. First of all, I totally agree with you, Mr. Polk. I cannot believe the chairman. Like, just what is he doing?
It was a chicken guy, not the chicken guys. So just wanted.
I mean, I love chicken, but but sorry. But this is. No offense to anybody else in the room, this is my favorite panel full of friends, and so I just wanted to say, first of all, as someone who genuinely wants to fight for agriculture, I think that agriculture already has enough threats, whether it's the screwworm or whether it's, chicken diseases, which I can't name off the top of my head, or whether the bird flu, I guess, yes, sorry, or whether it's anything else. I just feel like with so many threats already, Texas agriculture will not exist in the same way as we know it 20 years from now. And that's why today's conversation is so critically important, because if we don't do something, we just put even greater threat. I think our job as a legislature is to minimize threats, not ignore threats. And so thank you for standing up for your commodities and your industries and rural Texas as a whole. So that's all I wanted to say, and that I just love you all so much.
Thank you.
I won't take too much time. I just want y'all to know how much I appreciate you being here to testify on behalf of the people that you represent. Tony, your testimony was impactful. It really was. You did a great job. I know it's a nerve-wracking thing to come here from little old Natchez to talk to this committee, but we needed to hear what you had to say. So thank you for being here. Appreciate you guys very much.
You bet.
The last panel for the stakeholders group. The chair calls Julia Parento and Greg Laudadio. Thank you guys for your patience very much. I appreciate it. Whichever order y'all prefer, state your name, who you represent, and present your testimony.
Sure. Thank you, Mr. Chairman. I'll start. I am Julia Parento. I'm the Policy Director for Texas Realtors. Thank you all for being here so late and for having us. We are obviously, you have heard so many great experts today who can talk about aquifers and rates of water and all of that. We can talk about real estate and housing and how water impacts that. Texas Realtors has had a very strong interest in water policy for a long time. Obviously, if the water doesn't flow out of the tap when you turn it on, if you can't water your crops or your livestock, you're probably not going to want to buy or continue living on that property. There's an expectation that when you turn those faucets on, that you're going to get that resource and that you're able to tap into it when you own the property. But also, there's community impacts here, and water doesn't really care about property lines, doesn't care about fences, doesn't care about political boundaries, and it's really critically important that we figure out a balance of private property rights and community needs when it comes to water. I wrote this down. I hate to read verbatim, but Texas Realtors has a very lengthy water policy position statement if you're ever interested in reading it. But there's a part of it that we were looking at today that I think really speaks to what you're talking about here, that says, for long-term planning and community health, it is important to critically examine how water resources are governed and accessed. And such examination should provide for sustainable regional planning, considering, again, that water is not limited by political boundaries. So we're really, really glad that y'all are here today. Water really does impact development and what we can do in terms of how our communities grow. I think y'all already touched a little bit on, Chairman Bell, what's happening in Montgomery County with Conroe and Magnolia and the development moratoria that they've been grappling with there. And we've seen similar limitations on, excuse me, on housing and development in other parts of the state. And when you see those kinds of moratoria put into place, whether they're part of the city, whether they're long-term or even short-term, but particularly if they're long-term, that really can impact, it sets our communities back in such a big way. It damages our housing affordability, it limits our job growth, our economic growth, and it really hits consumer confidence, which is frankly just a fancy way of saying what the mayor said before, that people are terrified when their water sources are threatened. And so I will mention East Texas. Greg's going to talk a little bit more about specifically our folks in East Texas and that specific project. But East Texas really is poised for growth. Northeast Texas may not be the fastest growing part of our state, but it is growing, make no mistake. The property values are up. Incomes in the area are up. And I even found a fun article from the beginning of the year in January in which our famous economist Ray Perryman talked about how East Texas, Northeast Texas in particular, is really poised for some serious economic growth. And when we think about that and what that looks like for the future, water is an enormous part of planning for that and making sure it's sustainable and accessible. Texas Realtors has always considered ourselves the strongest property rights advocate in the state, but we understand that water is a different situation than the dirt under our feet. And so we're just really grateful that y'all are here, spending your time and energy in July to consider this really, really important issue. We want to be as helpful as we can. Happy to answer any questions about real estate and development, but otherwise, Greg will talk a little bit more about the local issues.
Go ahead, Greg.
Thank you. Chairman Harris, committee members, Senator Nichols, thank you for having us today, and thank you for holding this hearing. It's very important. My name is Greg Laudadio. I'm the East Texas Field Representative for Texas Realtors. I serve a large area of East Texas, not just Anderson, Houston, and Cherokee counties, but an area from Texarkana down to Beaumont. And I speak to our members every week, every day, and I've been hearing a lot of concern over this issue. I proudly serve thousands of East Texas Realtor members not just Anderson-Houston counties, but throughout the region, many of whom have expressed their extreme concern over these potential high-capacity water wells. While Texas Realtors remains neutral on the proposed wells that brought us here today, several of our local boards have officially opposed it. Many of the East Texas communities that we serve are wholly dependent on groundwater, as are many thousands of county residents served by community water wells, communities that couldn't exist without them. Many of our East Texas residents feel that aggressive and unchecked commercial pumping of the aquifers they depend on seems irresponsible. The state of Texas is adding over 1,000 new residents each day. It is important to ensure our most precious natural resource is available for all our communities, but not at the expense of one region for another region of the state. Our East Texas members and residents are highly concerned about the future of groundwater resources and what's at stake for the communities that depend on it. Thank you again, Chairman Harris, for holding this hearing and making it a priority. So many of our members, thousands of our members, are extremely concerned about their quality of life and their future.
Thank you guys very much. Members, any questions for the Realtors? All right. Thank you all so much for being here. Appreciate your testimony.
Thank you.
The chair calls Kyle Bass and Ed McCarthy. Gentlemen, I appreciate you being here today. I appreciate your patience throughout the day. I know it was a little uncommon to have you wait until the end, but I wanted y'all to hear all of the testimony. I thought that was really important. So, again, thank you for your patience, and please state your name for the record and who you represent, and proceed with your testimony.
Thank you, Mr. Chairman. If I may, my name is Ed McCarthy. I'm a water lawyer here in Austin. I represent Mr. Bass, CEM, Pine Bliss LLC, and Redtown Ranch Holdings LLC, which are the two applicants for the groundwater permits that are the focus of this panel. I'd like to start first by clearing up some misconceptions, misrepresentations, misinformation, so that we can clear the air about some things. My client did not illegally drill any wells. There were 2 test holes drilled, one in Anderson County, one in Houston County. Those test holes were then geophysically logged to develop data to be used for development of their applications for exploratory wells. Anderson County, and you heard, I believe, Mr. Johnson, counsel for the district, state, the Anderson County test hole was permitted. Houston County does not have a groundwater district. There is no requirement for a permit. So there was no unpermitted test hole drilled, nothing illegal, no penalties. I'd like that to be perfectly clear, and I'd like everybody who isn't here now, who was, including Senator Perry, who was asking questions about it, to understand that my client has not done anything, that their credibility is not subject to challenge for that. That's very important. I'd also like to clear up the idea that we did not file these applications or schedule this till after the last legislative session ended. Our applications were filed in May of 2024, more than a year ahead of that date. I would also like to clear up that our applications were incomplete, sketchy, and didn't provide any information. What I have put on the table here in the white notebooks are the applications for the Pine Bliss wells. The black notebooks are the applications for the Red Town Ranch. They contain all of the permit application forms that the district requires, basically a one-page document. The district rules require hydrogeologic studies and reports to be submitted in some instances. That's all the district rules tell you. They don't tell you what the content of that report is supposed to be. They don't tell you what they want you to tell them. So we had to work at trying to figure that out. We filed reports. Yes, the modeling only covered 5 years. That's because the district rules don't provide any guidance whatsoever. And they don't have any rules for how many years. After the fact, they said, we want 50 years. So we supplemented. We got numerous requests for information, and we supplemented. We have provided substantial detail. We have answered every question they have asked. To the extent there might be information about Houston County, we have some information about Houston County. Our maps and some other drawdown figures may not include Houston County, but that's because Houston County is not within the district's jurisdiction. The law doesn't require us to do it. Bottom line, my client has followed every law the legislature has enacted. I want to be very clear about that. And I know I sound a little bit grumpy. Maybe it's in part because I'm tired, but I take a little bit of umbrage when I spend more than 8 hours today alone having my client chastised for following the laws that you all passed and following the rules that the district adopted. To the extent there is a problem with the program, there's something to be needed to be changed with the laws or with the rules, okay, let's talk about that. I'm happy to talk about that. I've got all kinds of suggestions, and I'd love to answer questions about it, but I want to be clear. My client has followed the rules. Now, my client has also been completely transparent in that when they filed the application for exploratory wells, they disclosed how many wells they planned to drill and to operate and possibly transport water out of the district if, when they drilled the wells, the data they got back, not the modeling based upon a whole bunch of assumptions, modeling that is outdated, modeling that you heard everybody here said isn't very good model. Modeling the development board doesn't necessarily say is a good model, but it's the model that the development board and the state has provided and the district requires we use. So we used it. Now we want to go out and drill wells because the only way we ever know what's going to go on in the aquifer when you pump is when you drill a well and pump it. That's the way this works. And we are committed to the science. We tried to be completely transparent by telling you how many wells, where we would drill them, how much water, if our testing proved could be sustained and be compliant without harming the aquifer or causing unreasonable harm to any other permittees or groundwater rights owners or well owners. That's what our goal was. We haven't filed an application to produce water. We haven't filed an application to transport water. Everybody here has assumed the water's going to go to DFW or it's going to go somewhere outside the county. We don't have any contracts to do that. We haven't committed that that's where the water's going. Those are options. We have talked to people inside the district. We have talked to people outside the district. But everything at that point has been based upon the assumption that once we proved up what the aquifer could handle, we could get a permit for it. This is a very prolific aquifer, okay? I would like to talk about the DFCs and the MAG a little bit. DFCs, desired future condition, doesn't say sustainable what the aquifer can produce. Doesn't say it's a healthy aquifer. It says what the local GMA, groundwater management area, decided they'd like to see as the next 50-year planning horizon, the desired future condition. Okay? Be honest with you, it's an arbitrarily selected number at the end of the day. Okay? And then the TWDB takes that arbitrarily selected number and plugs it into a formula they have, and they spit out a MAG, a modeled availability groundwater number. That is not a cap. It is not a sustainable maximum number. It is the number that reflects the desired future condition that they were given. I heard somebody make a comment tonight, garbage in, garbage out. Well, if the desired future condition is garbage, so's the MAG. I'm not suggesting it is. I think it's a valuable planning tool. That's what the legislature in Chapter 36 said it was intended to be. In Section 36.1132B, this legislature, I mean the institution, said that's a number that you look for planning purposes to permit up to, okay? It doesn't say you're capped at it. You can issue groundwater districts permits above that number, but then you manage the aquifer and you observe the aquifer and you see what the pumping does. And if you have to exercise curtailments, you'll do that. Now, there is also a stated goal to protect historic use as much as possible, okay? But there is no prior appropriation doctrine in groundwater. And the reason for that is groundwater is a private property right. The prior appropriation doctrine applies to state water. The state gets to make the rules because it's the state's water. It's not privately owned. Do you realize that there are only 2 entities in Henderson, Anderson, and Cherokee counties that own the groundwater underneath Pine Bliss and Redtown Ranches? And that's Pine Bliss and Redtown Ranch. They own it. It is a constitutionally protected property right. And this body has a duty to ensure that right remains protected. Now, that doesn't mean we can't protect the rights of other people. It doesn't mean we're not interested in protecting the aquifer. But tonight's hearing and everything I've read about this hearing has been, we're going to take your property away. We're going to tell you you can't do that. And we're going to tell every other large export project you can't do that. And that may be a public purpose. And if it is a public purpose, then the state has the exercise, right under its exercise of its police powers, to do that. But when it does it, it's a taking. And if we're going to do that, the numbers for the budget are staggering. And we don't want to do that. Now, my client has no intent to dry up the aquifer. I heard somebody call my client, and probably me, because I've been called this more times than I even want to think about it, a privateer, a profiteer, a water pirate. I've been accused of stealing water from widows and babies and next generations. The only thing missing from tonight's hearing was a second grade class from Bastrop to come in and tell me about all the water my client was going to steal from them. We're not going to steal any water. We're not going to dry up the aquifer. There is no benefit to my client or any other large groundwater production project to dry up an aquifer or to dry up the wells of other parties. Excuse me, I'm sorry, I'm a little dry mouth here. But what we have to understand is that we do not protect aquifer levels. That's not a constitutionally protected property right. Many private wells are drilled shallow. If you ask anybody, they'll tell you the driller came in, drilled, hit water, went down 10 feet further and say, do you want me to keep charging you X dollars a foot to keep drilling, or I'm good, can we stop? And the answer is always yes, stop. Okay? Mitigation. Mitigation isn't a problem. This body has acted upon it. In 2023, you passed House Bill 5039, okay? 20 cents per 1,000 gallons. It's about a little over $65 an acre foot for water that is exported. That bill actually has instructions that says you can use it to study the aquifers, but really the main reason for it is to maintain the operational capability of wells in your district. And that increases at 3% a year automatically. You have to hold a public hearing to move up to that. But other than that, there's no question, it's a done deal. Do you realize what that's going to do to the price of water long term? Everybody's talking about what their customers are going to have to pay. Well, people who buy exported water are going to be paying that price. That price goes back into the district. Now, there was a bill, I believe Representative Gertis had a bill for Milam County benefiting that district, Post Oak, Savannah, where they can use those funds to repair the roads that the district might have to travel down in order to inspect a well. Come on, guys. It was a bill that provided funding for roads in Milam and Burleson County. It was a bill they tried to get passed 6 sessions ago, and it was really because it was supposed to be used to repair what then was identified as the damage that the oil and gas industry was doing with their heavy rigs and trucks on the county roads. I don't have necessarily a problem with that concept, but this body knows how to fix those kinds of things and take care of them, okay? And if this permit gets granted, if export is involved, we'll be paying that $65 an acre foot plus as it goes up every year into the future. For the size of project we're talking about, assuming we get 100% of the numbers that have been bantied about, you're talking millions of dollars this one project would be paying. It will fund a lot of new residential wells or lowering of wells. Now, I believe we have talked to some local water purveyors, okay? And there's a difference between, oh, they're gonna take all my water, but hey, here's the real thing. If they wanted our water, we have to have a permit to get that water. It took us a year to get these applications just to drill wells declared administratively complete. If you want to fix something, put a shot clock on groundwater districts for that, because it's a check the box. Did they fill in all the blanks? Did they sign it? Had they provided deeds for the guy that owns the ground they claim they're going to drill the water on? That's a 30-day exercise, maybe 60. And you don't go into the merits of the permit like we had to. You don't need a hydrogeologic report for a drilling permit. You need it for a production permit. What we're gonna do, and by the way, we paid $100 per well as an application fee, and then we paid $30,000 for each application, a total of $60,000 to the district, to fund their ability to review our applications on the merits and to engage consultants and pay legal fees. This is not a free ride. And yes, we did request to go to SOA, knowing we would pay that bill. We're not trying to burden the local groundwater district. The other false statement I've heard several times is that there was nobody knew anything about this permit or that it was going on. We were on virtually every agenda of the groundwater district, okay? There is no statutory requirement for any publication or notice or signs or anything other than each month it's on the agenda that it's going to be considered or discussed. We were on it. We attended several meetings when we knew they were looking for substantive information from us, okay? The minutes were there. Again, complete transparency. I want to touch briefly on Mr. Foster, the driller, who has just been slandered terribly in my opinion. I don't know all of the details, I'll tell you that up front. But what I do know is why was Mr. Foster picked? It wasn't because he was on the board. It's because he's one of the best qualified drillers in that part of the country. His company has been around for decades. They are well respected. They drill quality wells. They're long-lasting wells. They got picked on the merits. There are a number of groundwater districts around the state that have water well drillers on their board. If you want to make that illegal and make it an automatic conflict of interest, go ahead. The districts do it not so that applicants will hire those guys, but so they have the technical benefit and knowledge of somebody who's in the business when these volunteers who get no training, other than I'm confident Mr. Morrow misspoke when he said he's had no training, because I'm sure that every member of that board has taken the mandatory statutorily required open meetings, open records, good government hours of study they're supposed to do at least once a year, as well as their fiscal financial studies. But that technical expert on the board provides expertise, somebody who could answer questions, somebody who's on the board. Now, Mr. Foster was plainly identified early on. He signed I forget what it was referred to earlier, but he basically signed an affidavit of recusal, okay? Whether or not he had to recuse himself, I haven't investigated. But if you recall, the statutes, I believe it's Chapter 134 and 171 of the Local Government Code, are the conflict of interest statutes. And I think the standards are higher than the fact that he may have drilled some wells for my client or anybody else's client. But the reason he resigned, the timing was unfortunate, the coincidence of it was unfortunate, but he learned that he's a good public servant. He also sits, I believe it's on the Athens Water Supply District Board or something like that. And somebody said, hey, that's a surface water type entity and a utility entity. Somebody said, hey, you can't be on two of these boards. The county's too big. You don't meet the exception that the legislature has created for districts with small counties. So he resigned. And he resigned from the Groundwater District because he'd already recused himself and he had served longer on the Athens board to begin with. So that was sort of the hometown project. So that's why he did what he did, okay? There was nothing nefarious about it. And I want you all to appreciate that fact. He too was a volunteer public servant, okay? Now, I'm happy to answer any questions that I can for you. I do want to mention a couple of things about water law. Texas has two types of water, surface water and groundwater. The laws that apply to them are different. The reason is simple. The state owns the surface water. Even after that water is permitted to an individual or an entity, and under Texas law, it becomes a property right to that entity against all the rest of the world except the state. The state continues to hold title to the corpus of that water. And that fact is what gives the state, through the legislature and your delegation to the TCEQ, the ability to write the rules and make the laws and do all of the things you do that control surface water, including interbasin transfers. If you try to apply interbasin transfers to groundwater law, you're looking at intrastate commerce questions, you're looking at takings questions, you're looking at due process questions. I would be very slow to go and prohibit export. There's a reason the law was changed. Now, you have in Section 36-122, I believe it's subsection K, I could be wrong. That's a very, very complicated and long statute, and I don't have all the specific sections memorized. But there are 3 conditions that a board can consider in deciding whether or not to authorize export. They include the need in the receiving area, the detriment to the local area, all those kinds of features y'all have talked about tonight. It's already in the statute. It's up to the groundwater district to implement them. It's up to the applicant to prove they satisfy the criteria. The applicant has the complete burden here, okay? And we in our hearings intend to fulfill that burden. But you already have all these rules in place. So please think carefully about what you're being asked to do. There's a lot of unnecessary fear here because, again, we haven't even filed an application for production. We don't know what we're going to do. We have carefully and strategically stair-stepped this. We hired multiple hydrogeologic firms to look at different aspects of this project and provide information that is summarized in the reports that have been provided to the district that look at, based upon the literature review, basically the modeling and the science that's available, do we think we can do the project? The next step, in most instances, would be to file an operating permit application, okay? And when you get your drilling authorization. Because of what we view to be the magnitude of the project and wanting to be completely transparent, we're gonna drill wells. We're gonna apply for all the wells we may ultimately drill. Now, I'm not telling you we're gonna drill every well we've applied for before we file a production permit application. Those are expensive wells. They are big wells. But you know what? Drilling a little 4-inch or 6-inch well and running a 24-hour pump test for the size project we would be doing would be a sham, as opposed to drilling a full-size well, pumping it for a significant period of time, and demonstrating what the impact to the aquifer would be. To the extent neighboring landowners will let us put transducers in their wells, I'm assuming we're going to put transducers in their wells and we're going to measure the impacts of this pumping. A properly done pump test overstresses the aquifer. You pump it more than you regularly would. You cannot pump a well, by the way, 24 hours a day, 7 days a week, 365 days a year, because you'll kill the pump. You'll kill the well. 85% of the time, if you can pump at 85%, that's an efficient, good well. And you can do it in a manner in which you can rotate wells out so you can do maintenance. You can rotate wells, so if you see in an area that looks like it's going to be impacted in the aquifer, you move your pumping, you shift it. You always do what you can to ameliorate impacts to the aquifer and to other landowners. That's the way good operators do it. That's the way my clients do it, or they're not my clients. Okay? So I really, really ask you to think about, are there problems at Chapter 36 we need to fix? Do we have a problem with groundwater districts not following what you put in Chapter 36? Do we have a problem with groundwater districts having rules that just say you have to have a hydrogeologic report? And then when you give them a hydrogeologic report, they tell you, oh, that's not what we want. You know, and we keep redoing the exercise. What detail do we need to put in it? In Chapter 36, you have provided provisions about what needs to be in an application, and you specifically say, and that's all that you can require unless the district already has a rule that details what additional information is necessary. Well, if the district doesn't detail it, how is the applicant going to know what to file? Okay? So this is difficult, I understand. And I understand that, yeah, we've got thousands of people who are going to protest this. We had a very large group. I'm glad there's public interest in this. But we have to remember that as a state, water is in places other than where it's needed. We need to focus on the infrastructure that moves the water, okay? We can't focus just on the bad water. We do need to emphasize brackish. We do need to emphasize produced water, okay? But we've got over 1,100 people a day coming into this state. We want to keep the Texas miracle alive. We want to be at least continuing to be the 8th largest gross national product in the world. You know what? We need water across the state to do that. Senator Perry's bill is going to put a pipeline somewhere in the Sabine and bring water over to Lubbock because they don't have water in Lubbock. I heard testimony in front of this committee where the Sabine River Authority said that we were going to abandon our use of water for hydropower and just pump it and resell it. We'd make the same revenues or more by selling it and marketing it to the east. I don't have a problem with that, except why the devil are you giving up the hydro when we don't have enough electricity in the state of Texas? And you already have the facilities and it's cheap electricity. And it has little to no impact on the environment, particularly from a clean air perspective. We need to be very, very circumspect in how we move forward. We're dealing with the property right. We're dealing with the future of this state. As the legislature, Article 16, Section 59 mandates you are responsible for all of the laws that protect, preserve, and allow for the development, if you read the constitutional provision, the development of the natural resources of the state. Now, when we get into the hearing and all these people show up, we're going to talk to them about water supplier. How big is a piece of property your well is on? Oh, we buy an acre or 5 acres and we put a well on and we just pump the hell out of it. You know what the acre foot per acre ratio is on those types of operations? It's astronomical. It's 10 times what my client's acre foot to acre ratio is going to be. They don't want to talk to us about the ability from our large property overlying a strong aquifer to talk to us about our willingness to contract with them or work with them to provide water in the future, because they'd have to pay for it. Everybody wants it just to be banked at home in their backyard so they can drain it. That's right. They can drain it from wherever their well is. They don't have to go buy it. They don't have to go lease it. There's a lot there. And there are other issues we'll get into about the hearing, okay? You know how much water is wasted washing chickens when you process them? Is that a beneficial use? Where does that waste stream go? Is it recycled? With respect to surface water and the wetlands that are being created, those are great features. We need to recycle, we need to reuse. I fully support those. I fully recommend them to my clients. But keep in mind, you've heard testimony about how much evaporative losses there are from our reservoirs and our rivers, okay? We lose a lot of water in reservoirs. Very inefficient way to store water. But it's conventional and it's the best known, and we're used to it. The one last thing I want to tell you is that water is a magical substance. When it drops from the sky and flows across the land and gets into a little slight ravine or into a creek or a river or the Gulf of Mexico or America, it's surface water. When it flows across the land and it seeps into the ground, it's groundwater. When it comes out of a spring and back into the river, it's surface water. When it hits a cavern in the riverbed and it goes underground and goes into the aquifer, it's groundwater. And with each of those changes in character, the law changes. It goes from being state property to private property. Again, a lot to think about. And I'll stop and turn it over to Mr. Bass. I appreciate your patience with me. Thank you.
Thank you. Thank you, Chairman Harris and the committee. I also am actually, I'm glad, A, that we're here, B, that we're actually having this hearing because this issue is so much larger than these two permits that we're talking about today. So I'll give you a quick rundown on who I am as it relates to the state of Texas and being a Texan. Real quickly, my mother was born in Henderson, Texas, and was the first person in our family to go to college. She went to Stephen F. Austin in Nacogdoches and became the first female sportscaster in the state. I've been a Texan since 1979, 46 years ago. I've been driving to East Texas the first 10 years of my life every Thanksgiving from Miami, Florida to see my granddad who lived in Tyler. I live between Dallas and Henderson County. I served on the board of the University of Texas Investment Management Company for 9 years, and I chaired the Compensation Committee and the Risk Committee, so I've done a bit of service to Texas. I currently sit on the board of the Texas Department of Public Safety Foundation, which I've done for 11 years, and the majority of my charitable dollars end up going to U.S. troops and Texas police. I run Conservation Equity Management as the co-CEO. I'm also a senior advisor to U.S. Military Command on China, both military and intelligence. I care a lot about our country. I care a lot about our state. I am a Texan. Everyone that works with us lives and works in Texas. We're all Texans. And when you think about the greatness of our state, I've heard a lot of people talk about the growth. You know, my background's in macroeconomics, and so our state is the fastest growing sovereign in the world. We are the 8th largest economy. We have a $2.7 trillion GDP. We are the Tigris and Euphrates of growth for the Western world. And what's interesting about this is when you think about our power grid, we all know our 84 gigawatt power grid has to grow. It has to grow a lot. When you run out of power, if you don't provision properly, you can actually still get power. You're just not going to like the price. When you run out of water, you just run out. And what's likely to happen going forward is you're going to see municipalities somewhere west of Dallas-Fort Worth or south of Waco just run out. It's going to happen. You mark my words, that is going to happen. So when you think about the growth in our state, you think about the legislative body looking at this, our state uses 17.7 million acre feet a year. About 2.5 million of that is recycled. The remainder is split pretty evenly between groundwater and surface water. Why we're sitting here today is in 2020, I left Wall Street and started to think about what I wanted to do with the rest of my life, and I happened to just read the state water plan. How many people on this committee have actually read the state water plan cover to cover? I'm super interested in knowing. Has anyone? Keep going. So when I read it, what's interesting to me is it said the state's demographic or demographer in the report contemplates the state growing 73% in the next 50 years, 2020 to 2070. And then in the next paragraph in the state water plan, it says, and water usage is going to grow 9%. So we're going to grow 73% population. We're only going to grow 9% in water usage. I said, well, I must be missing something. And I kept reading. And I read the whole thing, and I said, you know, I'm just some guy that's just come into the water world. Maybe I need to read it again. I read it again, and I called some people on the state water board, and I said, what am I missing? Like, how are we going to grow the population like that and only grow the usage 9%? And they said, well, we really hope that we're going to zero-scape yards and build less swimming pools, and that there's going to be some technological advancements that are going to help us. I said, okay, so that's the plan. That's our state's plan. That is frightening. And that's why we're sitting here today, because I started to dig in and try to understand where our state's headed. And so I think it's vital to think about as we go forward. In the state water plan, I looked at the reservoirs, the number of reservoirs that we're going to build. That is in the plan. In the next 50 years, every contemplated reservoir is in the state water plan. What was interesting about that page is there was no firm yield. There was no, how much more water is the state going to get if we actually build all of these reservoirs? So what we did is we called the Water Development Board and said, what's that number? Why is it not on this chart? They said, oh, we don't provide that number. I said, well, we might want to know what that number is. So we went out and developed that number. That number is 1.2 million acre feet. So the state uses 17.7. If we build every reservoir that's contemplated in a plan, we're going to add 1.2. If you just use linear math, if you take 17.7 and you grow it 73%, you're going to have to find 13 million acre feet in the next 45 years. If we build every single surface reservoir, we're going to have 1.2. Marvin Nichols Lake is a third of that 1.2. Are we going to condemn 70,000 acres, contiguous acres of land as a state? I doubt it. If I were the governor, I sure wouldn't. So the surface water plan is not a real plan. The plan itself isn't a real plan. And so what we're doing here is what we're trying to understand is take water where it's most plentiful and take it to the places in our state that has to have it. So when you talk about, well, we're going to take it out of East Texas, look, I feel like I'm an East Texan. I'm going to live and die out in East Texas myself, hopefully not too soon. But I love East Texas. I love the Pine Curtain. I love our state. You as state legislators have to think about this vexing problem that we're facing today. And there is a reason the governor added water to be a strategic legislative priority this legislative session in February. Adding $1 billion a year for 20 years is a great start, but just one pipeline going 180 miles is about a $6 billion project, just to be clear. $1 billion a year is a great start. It is nowhere near what we're going to have to spend. I think we're going to have to spend $100 billion over the next 10 years on water, at least. And that is the bottleneck for our state. So we sit here today because I read the state water plan, and it is, I mean, it's farcical. There isn't a plan. And so as we sit here today and we worry about where we're going to move it from and to, we're going to stop exporting and things like that, what's going to happen is we're going to run out of water somewhere, and it's going to happen soon. And when that happens, we're going to have different legislative priorities, in my opinion. And so what we're trying to do is take the law the way it is, follow it to the T, do everything we can do ecologically properly. You develop the MAG, we hire 3 sets of engineers, we try to live by every rule you guys have set for us, and then we sit here and we hear, well, let's just change the law. Well, it's fine. I mean, I guess you guys can do whatever you want to do, but I think it's really important to think about what's going to happen going forward. Today, we own 9 properties in the state of Texas. We have about 45,000 acres. We are building the largest wetland mitigation bank in the history of the state at Chocolate Bay today. We are building an endangered species habitat. We are doing everything we can do to ecologically make everything we own better. And the reason we are tackling water is because we read a plan and we realized there isn't a plan. And so we appreciate you being here today. I appreciate you being here today. And I want to go through 2 more numbers really quickly, because Mr. Ashby continues to say that we're asking for more water than is in the MAG, and that's just not true. So when you look at the Henderson County MAG is 17,800 acre feet, and the permit, if everything works out and the science is proper, is 15,800. In Anderson County, the MAG is 43,600 acre feet, and we're asking for 33,000 if everything works out perfectly. So when you use billions of gallons an acre feet, it confuses everyone. So we're asking for 0.02% of the aquifer in place, and that's assuming 100% of it's recoverable, and those are using the Texas Water Development Board's numbers. If you say only a quarter of it is recoverable, let's multiply that number by 4, and we'd be asking for 0.08%. So 0.0008% of the recoverable amount of the aquifer. We are not asking for huge amounts of water as it relates to what's in the aquifer. We're talking about 33,000 acre feet and 15,000 acre feet. Go back to the numbers that I talked about earlier. 17.7 million acre feet is what the state uses annually. We're talking about 50,000. The state needs to find 10 to 13 million acre feet soon, because these plans take decades to get done. So I'm trying to explain that what we're asking for sounds like a lot from the area that it's in. There's a lot of hyperbole, there's a lot of misinformation out there. It's just not true. But I think the bigger plan and the state is really important to think about. Because if you convert the acre feet in the Anderson County aquifer and the Henderson County aquifer, this Texas Water Development Board says that there are 55 trillion gallons in Anderson County and 21 trillion gallons in Henderson County. So there is a lot of fear-mongering going on here, and we are using the science, we're using the law, and I'm glad that you at least sat here and listened to what I had to say here, because I think going forward, we've got some really big issues to tackle. Whether or not these permits end up going where we think they're going to go, the state has some really important, I think, decisions to make very quickly. So thank you, and I'm happy to answer any questions from here.
Thank you. Representative Gonzalez.
Thank you, Chairman. I live in El Paso, so I'm going to have to leave in a little while, so I appreciate being able to go first. But I've been a legislator for 14 years, and I'm not sure I've been as insulted as I have been in this moment in time tonight. I'm grouchy too. It's not even, we're in session and now we're here, and so I'm sorry that you're grouchy and you felt that we were asking difficult questions, but I think it's our responsibility to ask these questions and to use the information that we have. So Mr. McCarthy, I'm sorry you're so grouchy, but you know, when we have major concerns, we have a responsibility to spend hours trying to figure it out. And so I guess my question is you say you have followed the law, but do you think after dozens of people who have testified and hours of testimony that all of them are being hyperbolic and wrong?
Yes, Representative Gonzalez, I do. And
You think every single person?
First, let me say I apologize to you if I insulted you. That was not my intent, okay? But my answer is yes, because again, the suppositions that you heard people testifying about, we haven't applied to produce any water. We have applied to develop, to drill wells, to do testing, to develop science which will be provided to the state, to the local groundwater district, and be available to everybody else. We're not, the supposition is that the water's going to go away and that it's going to harm them. I haven't seen any studies from them that support that. You know, this has been all preliminary and a whole lot of excitement, and all we asked for was the right to go drill wells, and we did that because the law requires that in order to drill a well, you have to have a permit. And you heard earlier that when somebody thought we didn't apply for a permit we didn't need, we broke the law and ought to be subject to $10,000 a day penalties for that. That's what I was trying to clear up.
I think the problem with your statement is I think the chairman was extremely deliberate in having multiple stakeholders from various industries come talk about the potential harm. And as somebody who's been here for over a decade of my life, I do trust, unlike you who said they were all wrong, the agency heads, TDCJ, the cattle raisers, or any of the other stakeholders who we've heard from. And so to say that none of them and all of them are being hyperbolic, I find a little bit concerning. But I guess my question is you say you have followed the law as the law exists, but you also said that there are gaps. So would you support legislation to address some of these policy gaps, including notice and publication?
Beyond what we already have, I'd be interested in seeing them, but I don't have a problem with notice and publication, Representative Gonzalez.
And
again, transparency is very important.
And you would be open to some of the other policy changes that have been identified through the conversations these past few hours. I was going to say weeks, but it feels like weeks, hours.
Some yes, most no.
I mean, I have to get on a plane, so I literally have 30 seconds because my staff's yelling at me. But I think my concern is that you say you have followed the law. And I'm not a lawyer. I'm not going to argue with that. But you also say it's our responsibility as a legislature to think about the needs of the state of Texas. And we have heard hours of testimony about the harms of the permits or the harms of the permit approval. And for you to say that there will be no harms is a little bit problematic and doesn't take into account our responsibility. I live in the farthest part of West Texas, and I want East Texas to prosper and exist and grow in a way that feels and honors the cultural heritage and the agricultural roots of that community. And so I am extremely disappointed that you, instead of saying, yeah, we hear the people, we hear the concerns, we are trying to mitigate these concerns in these ways, you're just saying these people have no idea what they're talking about and they're hyperbolic. And so I ask you to be better partners to both the legislature and the people who live in East Texas.
Thank you, Representative.
Representative Bell.
Thank you, Mr. Chairman. So, couple of questions. And I'll just stay with your testimony. I won't try to go in any different direction, but you talked about private property rights, and you and I would agree. I think everybody in the room doesn't have an issue with understanding the water under the property belongs to the property owner. I think I hear a tremendous amount of concern, and where I personally, as a property owner in East Texas and other areas too, see a disconnect is that if you listen to everybody's testimony on state law, including your own comments that suggest you don't have to be concerned about the elevation of the aquifer, which I'm not disagreeing with that assessment and how it may work. But for you to pump enough to affect an aquifer on another property means you're taking that same property right that belonged to that other property owner. And what I think we are sitting here understanding right now is that they're just exactly like we see in other types of property rights that exist under the surface. There's going to have to be some type of fencing that says you can't take more than exists under there. I'm not trying to say where we all go or what we all do, but I am saying if we're going to talk just about your comments regarding private property rights, the private property rights of your neighbor are not supposed to be accepted because of your own private property rights. And under the current guidelines and that I hear in your comments, under the rules of capture, there's nothing to prevent you from pumping the water that exists on your neighbor's side of the fence down. You have no, did I hear you right, that you have no obligation to protect the level of the aquifer?
Representative Bell, I think there's some confusion here. It's physically impossible to pump water from the aquifer and not have some effect, okay? How noticeable it is and what it is. But those are things that we go through the hearing process. What I heard all night tonight was, let's shut this down before it even gets started. Don't give them the permits to drill the wells, to prove the science, to show whether or not it will happen. We have this MAG number, and we're going to rely upon it, okay? Or we have these desired future conditions. Mr. Ward from Trinity River Authority spoke about some quick review he had done on a report that Dr. Bill Hutchinson had prepared. That report I'm familiar with, and I have a completely different take on it. It shows a prediction of 139-foot drop on average across the aquifer in Anderson County over the 10-year period between 2013 and 2023. The reality is there was a 6-foot drop on average across the aquifer. You heard people talking about the levels dropping in their static well levels. Well, that's the well they're pumping. You're always going to have the most concentrated impact at the point of production. And so the greatest drawdown is going to be there. And we're not saying that we're not going to have some impact, and we're not saying we're not going to be willing to mitigate the impact or to do something to ameliorate the impact. We're saying let us go and drill the wells, do the pump tests, prepare the science, and then come to the district created by the legislature with as the preferred management tools to decide what's the right permit to issue, and let's make it based upon that evidence. But let's do some real field science, okay? Not just rely upon these models that we heard everybody say weren't reliable. That's what I'm saying, is give us a chance to prove up our project.
And so you've already put in your 2 wells, so I would assume you have your information to prove up your model of concept at least, or you wouldn't still be sitting here in the room. And again, I'm going to, Mr. Bass, you mentioned that sooner or later people would run out of water. I think not too long ago, the city of Groesbeck around Christmas time was hauling water because the surface water wasn't available in the lake. And so I don't think that's something that you got to wait too long for. I think that's already happened in areas around Texas in the past. I'm a staunch believer in private property rights. I think since I've been in this place, I've stood up for those rights. I'm concerned about the analogous to mineral rights because of the challenges that go along with being unable to buy mineral rights in the time that I've been old enough to buy land. because every little old lady in East Texas was told, hold on to the mineral rights, sell the land, don't sell the mineral rights. And so, those same challenges that every private property owner fights every time they get that call from that landman that says, oh, we're just going to come in, you'll love us. Well, no, not necessarily. So I have a good understanding of the private property rights side of it. And where I hear, two things that I hear are problems. One, if you pump more than is necessary to protect your neighbor, then you are infringing on the private property rights of your neighbor. That's the first comment that I would make. And secondarily, if that effort doesn't preserve the local ability to develop, then you've compromised all of your neighbors. And so, anyway, would you agree, I guess my question to you is, would you agree that under current law, your earlier comments that you're not required to protect the aquifer and that it is not an obligation to protect the neighbor's water rights in the utilization of yours, what's under you we've heard it said, maybe it's wrong, that if you can pump it, your only defense is to put a pump beside it. Is that a true statement?
I don't believe I said that, Representative Bell.
I'm sorry, the pump part you didn't say, but it's been said today that the only defense you have against a neighbor who's pumping water that infringes on your water rights is taking water from, fences don't know water. I mean, aquifers, so the water on the one side of the fence doesn't know what you're doing with your pump on the other. But the water does, but the fence line doesn't know that. So the comment was made earlier that if property A over pumps and is dropping the water on property B, different property owners, that is if indeed it is a private property right, then it's a taking. Whatever amount of water is coming from that other property over is a taking. And my question to you was, somebody made the comment that under current law, if this committee chooses to do nothing, this legislative body chooses to do nothing, which I don't think is the case, but the comment was made that the only recourse was to go put your own pump across the fence and see if you could pump enough to recover your property rights. Is that your opinion of the current law, the way it sets today with regards to the rule of capture and your and private property rights?
I don't believe so, Representative Bell. We have a modified rule of capture in any area where we have a groundwater conservation district. Groundwater conservation districts adopt a variety of different rules and protections, including spacing requirements, production rates, all of those things, as well as curtailment ability to protect if there is unreasonable harm to the aquifer or to a neighboring landowner or well owner. They have well spacing as another rule requirement that's already in the law. That's under what we call the modified rule of capture that most of Texas operates under.
And I understand the modified rules. Also know that at the end of the day, what we heard throughout testimony today was nobody's curtailing their pumping. Some of them have suggested that they should pay a higher fee, and that's perhaps occurring in the subsidence district. It's the only place in the state that we've heard that particular testimony. But that aside, it is very challenging to apply what I understand your articulation of the private property rights to a scenario where you can take that many acre feet, and I understand these are fairly large tracts, 7,000 to 8,000 acre tracts, but those types of volumes and the type of modeling that is being articulated, at least from within your permit, it appears that it likely will exceed your fence line and cause impact on your neighbor. And back to your comment about groundwater conservation districts and modified plans, it's very clear that some of these districts, some of these counties aren't covered in a groundwater conservation district, and that is creating some broad latitude to do things like contemplate export with no requirement of permit or other consequences. That's a fair comment too.
I agree with I think with the last part of it, Representative Bell, but one of the things, let me try and clarify this. The rule of capture is not a property right. The rule of capture is a rule of tort law that was decided by the courts that said, if you pump your landowner's water, you have no liability for doing so. That's a tort law. It's a trespass issue. It's not a property right. The property right is in the water itself that is in the ground beneath your property. That's the property right. That's the property right that was declared to exist by the Supreme Court in the Edwards Aquifer versus Day case,
yeah.
and by this legislature in Section 3602.
So, and again, how the rule of capture application is there, that's just based on today's testimony and literally for the benefit of everybody who sat through the last 9 hours or however long we've been sitting here, trying to just hear your understanding. You represent the property owner that in this particular case is seeking the permits, and I'm asking for your understanding of it, and you've articulated that. So thank you.
Thank you,
Thank you, Mr. Chairman.
Bell.
Representative Sweener.
Thank you so much, Chairman. Thank you both for being here. Mr. McCarthy, if you've ever like me to affirm that you have a lot of people mad at you over water, I'm happy to bring the Hays County folks to do the same.
I see them regularly, Representative Zwinger.
I was
Thank you.
aware of your name before I ever stepped foot in this building. I actually really want to echo some of what Representative Gonzalez said before I get started, which is that I really do think some of both of y'all's remarks were insulting to this committee. I'm going to be frank. I think the House Natural Resources Committee is the most hardworking, most informed committee in the Texas House. And every single member on this committee takes their job seriously, is informed, and researches things. Mr. Bass, you may have made a lot of money, but that doesn't mean you know every single thing about our job and how we do it, and we all go out of our way to be very informed. And just because we have put our effort into public service instead of into finance and earning dollars does not mean we are any less talented than you. And I hope you, instead of challenging us and acting like we don't know what we're doing, can show us the respect we deserve and that we've been entrusted with by the people of Texas. I want to have a little bit of a conversation about this rule of capture, or, I'll take your point about tort. Mr. McCarthy, absolute dominion rule, I think is a more appropriate term. Texas is unusual. I studied forestry in Montana. I have a degree in natural resource conservation from the University of Montana, and we all had to take natural resource policy. And I remember the day we started talking about water law, and we talked about how they did in the West, and they talked about how they did it in the East. And as, the lone Texan in the room, I raised my hand to say, well, what about Texas? And my professor looked at me and was like, well, Texas is weird, and it's hard to explain. We are the only state in the country that does water law the way we do water law, and there is nothing inevitable about it. The rule of capture has its origin in wildlife law and in who owns wildlife. The idea is that if you want, that in general, wildlife is owned by the public or the governmental entity, but that if you capture that wildlife on your property, it becomes your property. So the deer's not yours till you shoot it or trap it or whatever. That same logic got applied to natural gas and to oil. And some of the reason for that was because we wanted to encourage rapid development of oil and gas resources. The idea was if your only defense to somebody pumping all the oil out from under your land was to put your own derrick in, that we would more quickly develop that resource. And of course, that ran into trouble, and then we started to get some rules around blatant waste and allowing regulation through Texas Railroad Commission and other entities, because we had some bad actors just blatantly waste that resource. And so then we took this legal regime that was designed to encourage extractive use, and we ported it onto water and groundwater. And the giant problem with this is that groundwater is not a resource that any of us just want to drain. It recharges. You know, we don't have any more dinosaurs under the crust dying and refilling our oil resource. We know that when we're taking it out, we're taking it out. With water, there is this expectation that aquifers recharge and that it is a resource we can use time and time and time again. And so we need to not act like the Wild West is good. You know, Mr. McCarthy, Mr. Bass, I understand that y'all believe you have followed every single law in the books, and you very well may be right. I have not read your permit application. I have not read the rules of these local groundwater districts. So you may have followed every single rule. That doesn't mean this is the way it should be. That does not mean this is working for the state of Texas. And Texas has been very cautious with our groundwater regulation because we are a private property rights state. But we have options. We have other opportunities. And if we are going to, as you say, Mr. Bass, move into the 21st century, be an economic leader, we can't have Wild West laws on the books. We have to have laws on the books that work for now. And so, Mr. Bass, if you want the trust of this community, that you are doing the right thing for them, I hope you will be here and argue for them to have the ability to say no to you if your math doesn't pencil out. Right now, they don't feel like they have the ability to say no to you, and that's why they've come to us. And if they don't feel like they have the ability to say no to you, then they aren't going to trust you, no matter what you say, no matter what numbers you produce. If they don't have a no, they also don't really have a yes. And so I would encourage us to look at what's going on in other states in the West. We are the only state west of the Mississippi that uses this, absolute domain rule. Most other states either use some form of prior appropriation for groundwater, or they use a rule of reasonable use where you can't hurt your neighbor. And what we have seen through our groundwater districts is a slow move over to the rule of reasonable use, and we need to keep bringing that about so that you can't just hurt your neighbor. And so, Mr. Bass, I know I'm supposed to be asking questions, and I didn't ask a lot. Mr. Bass, I'm going to ask you, do you want the people in these counties, in Anderson, Henderson, Houston County, do you want their wells to go dry?
Obviously not.
So what is your plan to avoid that?
Well, I think if you look at what we're doing, we are talking about the modeled available groundwater, in essence, the recharge that you speak of. We're not talking about touching the corpus. We're not talking about touching the depth of the aquifers. We're taking the laws that you and your fellow legislators have put on the books, and you say that you have options. We don't want to hurt the community, obviously. We live there. We're not trying to pump anything dry and leave. What we're hoping to do is take what recharges, take where there's something that's plentiful, and move it to somewhere in the state that is desperate for it. It's that simple.
What will you do if the numbers don't come out the way you think they will? Or the way you hope they will, I should say.
I think that what we've said and what we will do is if we drill when we drill the test wells, we're trying to prove up the science of 3 different engineering firms. And if we prove up that science and we stay within the MAG, within what the Groundwater Conservation District and GMA 11 says is an amount that is not harmful to the aquifer, then we intend to produce that. If the numbers don't pan out, and if our testing doesn't pan out, well, then we will certainly change plans and do less.
And Representative Sweeter, that's why we've only applied for exploratory drilling permits. The test holes we drilled, we did geophysical logging, and we worked, it was part of what I call the tabletop literature review, first step. Taking what's reported by the development board, take what's reported in the district's records, take what the Bureau of Economic Geology, what our hydrogeologists are trained to do, and look at the first step, because there's no sense spending a whole bunch of money drilling a bunch of wells if when they look at what the literature provides and take the geophysical logs from the property, tells us it isn't there. So the next step then is to try and go and drill the wells, okay, do the pump tests, see what the aquifer characteristics are. The district doesn't have this data. They don't have this type of modeling and field analysis within the district. They haven't done the modeling they asked us to do. That's in part why they asked us to do it. And they didn't provide us any modeling and say, look, this is what our modeling shows, and there's a problem. We haven't seen anything from the district. We're trying to do, the project has a lot of different facets, one of which is economics. Like I said, we're not going to make an investment that isn't going to work. We're not going to make an investment that's going to drain the aquifer. So those are our exit ramp points in the process. We're trying to get step 2 done, actually go out in the field and collect data, and we're getting shut down.
Is there any requirement that y'all report test wells drilled outside of a groundwater conservation district?
We report the drilling, the water well drillers rules require, I believe, when the well is drilled, that a driller's report be filed. What we do with the data in a non-GCD, I don't believe there is a legal requirement to report that.
So I'm sorry, who is that report filed with, the driller's report?
It's Texas Department of Licensing and Regulation, which regulates the water well drillers.
Okay.
And it also gets filed, I believe, with Texas Water Development Board for their inventory.
Okay. Has CEM drilled any wells outside of a groundwater district in Houston County, or are there any plans at this time to do so, to do a test well?
My understanding is we haven't drilled any wells. We drilled 2 test holes in which we did geophysical logging. We have not drilled a water well for purposes of doing any testing or analysis.
That's correct.
Okay. Where were the test holes drilled?
One was drilled in Anderson County, Anderson County, and we secured a permit from the district. I believe Mr. Stover confirmed that. And the second one was drilled the test hole was drilled in Houston County. And there's nobody to report that to in Houston County. We have the geophysical logs done for Houston County, but there's no district there. So we didn't have to go file an application or a registration with them.
Okay.
There's nobody to file with.
Are y'all planning to do a test well in Houston County based on the test hole?
We're going to drill test wells in Houston County, yes. We've only filed applications with Nature's Trinity Valley for Anderson and
I
Anderson
understand
County
you're not
because
required to.
that's what we're required to do. There's no requirement. When we drill a well, we will follow all of the requirements for reporting those wells. The driller himself has a statutory duty to do that too. But that information will be incorporated because the more data points we have and the more data and information that we can show what the impacts to the aquifer are, our hydrogeologists will be incorporating that data into the reports we ultimately file with Nature's Trinity. Again, the applications we file with Nature's Trinity as of today are just to be allowed to drill wells in Anderson and Henderson County because that's the district that we have to report to.
No, I understand that you're not required to report to the Natchez groundwater district for things outside of their district. I think the reason I bring up that concern is, my district, as you know, Mr. McCarthy had a big issue with there being a little bit of a blank spot on the map that wasn't covered by a groundwater district and that becoming a target. And I think that fear is very real, that areas without any regulation whatsoever will be targeted. And I think it's very rational. So, Mr. Bass, if your intentions are what they say they are, I would really encourage you to, as a courtesy, keep the chair of this committee informed on those test operations in Houston County if you do want to try and build some trust. So, thank y'all.
I was going to make a quick response to what you're saying. I think it's the low-hanging fruit for Representative Bell sitting on the committee. Houston County has no GCD. I mean, Smith County has no GCD. How does Tyler not have a GCD? I mean, I think, personally, I think that's pretty crazy. I think that the gaping holes in our aquifers are the places where there is no oversight. Now, a less scrupulous operator would just go drill those counties. What we submitted in our plans here was, yes, one of our pieces of property has a large landholding in Houston County. Yes, we drilled a logging hole, but what's important is there's gaping holes in what everybody here cares about, and it's over pumping and no oversight whatsoever. I think the low-hanging fruit there is to figure out how to remove those holes, and then let's talk about how those GCDs should operate going forward. But the fact that I think it's 4% of the state, if my numbers are right, don't have GCDs. 4% of our state is actually a pretty large area for less scrupulous operators to operate in. So I agree with you is what I'm saying.
Representative Hefner.
Thank you, Mr. Chairman, and thank you, Mr. Bass, for sitting here all day and answering questions for us. I want to go take a little different route. So your organization, you're not the only investor in these LLCs, are you? Or do you have other investors involved?
So it's important to note that on Pine Bliss, I'm the 100% investor there. That's my family ranch. On Red Town Ranch it's a partnership with myself as the largest investor, and then other external investors that are, I would say, primarily Texans. Some are from around the country.
I chair the Homeland Security and Public Safety Committee, and this session we passed about a dozen bills through the legislature regarding foreign adversarial influence, ownership, and talk about our property, our investments abroad, gifts to our institutions of higher education. Trying to protect our critical infrastructure, our property, our food supply chain, our electrical supply, and so one of those things that we wanted to protect was water rights as well. So, do you have any foreign investors, anybody that we should be concerned about, and what can you tell us to make us comfortable that we don't have to worry about those foreign adversaries owning access to some of our water, because we don't want to become dependent on a water source and then somebody that wants to do us harm say, you know what, we're mad at you today, we're going to turn that off.
You and I are on the same page there. I had a lot to do with the Lone Star Infrastructure Protection Act. I was the one who brought to light General Soon's interests down in Val Verde County. In fact, I brought all the DOD witnesses to the state or to the Senate chamber to testify, including myself, for that bill to get that passed. That passed 31-0 after that hearing in the Senate. So I care very much about this. My life's passion is national security. So the long answer to your question is absolutely not. There are no investors with me that have anything to do with foreign adversaries.
Okay. Well, that's something that we just, like I said, it's kind of out in left field from what we've been talking about here today. But I know how sometimes these investment things, which are fine, when people are investing together, can get kind of layered up, and you can kind of lose track of who's who in there. So obviously we'd have great interest in making sure that we don't have foreign adversaries involved. So, but thank you for that. Thank you for that answer.
Thank you.
Representative Ashby.
Thank you, Mr. Chairman. Ed, I think let me, client, attorney here, it did strike me as a little bit unusual that you started out, Mr. McCarthy, talking about the project in your opening comments, and you made the statement that you were not sure if there was going to be export involved with this, if there would be a permit approved at a future point. But the last thing you wanted to do was to harm, and you listed 3 or 4 different groups there, but I interpret that as basically you didn't want to harm anyone. My first piece of advice is your client just said a second ago that the objective here is to move a resource that's plentiful in one area to another area that needs it. And I think that really strikes at the heart of why so many people, Mr. Bass, are concerned in East Texas. I won't bore this committee or you. You've heard a lot of the testimony here today. But you're looking at it from a profit perspective, a return on investment. I respect that. But just as you have a job to do as a principal in your company, we are representatives of people, approximately 200,000 people for each House member that send us here. And I think it's pretty clear that you and me are going to be on opposite sides of this issue because you've heard my constituency here today in the terms of Houston County. But beyond that, just like you, with my East Texas roots and having lived there my whole life, I want to, beyond just House District 9, look out for the interest of all of East Texas. And for that matter, rural Texas. And so I just want to be clear that you have a job to do, I have a job to do, we all have a job to do. Another observation, you asked the question, have we read the 50-year water plan? And that is a fair question. I have read a lot of it, but I can't say I've read all of it. But what I would suggest to you is that document is produced as a result of an act by this legislature, as you probably are well aware. And so when you describe it as farcical, it is a little offensive to some members. I personally don't take offense to it, but I do think there probably are members that take offense to that because that is a very important document that we rely a lot on in this committee, as the chairman will attest to, in helping guide us in making policy-making decisions. And so I would just suggest to you that our water planning process and that 50-year water plan is very important to us as a policy-making body. Now, I made a couple of notes here. The first one that, Mr. Bass, I want to just clear up. You cited my comments probably at least 2 or 3 times today to different folks that were testifying. And Mr. McCarthy, this is where you might can help beyond this hearing with me specifically. But I am looking at the MAGs, Mr. Bass, and the data that I'm using. Again, I'm not suggesting, I don't know what you're looking at, but I'm looking at the data that was provided to us. And I'm not going to bore everybody here and everybody watching online, but I have the information here for Anderson, Henderson counties, and for Houston County as it pertains to the available amount of groundwater in those counties, and looking at the Creosote, the Queen, and a little bit the Sparta aquifer. And I'm looking at the existing demands in those counties for those aquifers, and then I'm looking at the project demands that are in your application. The data that I have, and I'm a data-driven person, and I hope we all are, the data that I have suggests, as I said earlier, that in the case of Henderson County, that if your permits were approved, that there would be a deficit. And so what I would suggest to both of you, but certainly use your attorney, now don't let him charge you for this, but I would like to compare our numbers and see if I'm mistaken in the information that I was provided. Because I certainly want to be factual and I want to be clear. But the information that I've used today is the same information that is widely and publicly available that many of the folks that are in these affected counties, Mr. Bass, are using, which is, of course, the information that we have. Now, if you have other information, I'd certainly like to see it, but I want to be clear with you, I don't want to misrepresent the facts. And I am doing my best here to make sure that I'm not. I don't believe I am, but I certainly am open if that's the case, that there is some discrepancy here in the numbers that I'm looking at. So I wanted to offer that to you.
Thank you.
Mr. McCarthy, you referenced the export fees.
Yes, sir.
And there's been testimony here today that, you know, and this is something that we may or may not consider next session, but maybe it's time to look at export fees and whether or not that 20 cents per 1,000 gallons is enough. But you mentioned and highlighted that the Nature's Trinity Groundwater Conservation District, your words here, Mr. McCarthy, could stand to generate with maybe over $1 million or millions of dollars. Okay, you agree? You said that, right?
Assuming that, as Mr. Ashby, Representative Ashby, yes, assuming we got the full, we went forward with the full amount that we said was the objective, and if we can prove it up, we'll get permitted. If it was all permitted and all transported, yes.
Okay.
I believe that's how the math works.
Well,
$65 an acre foot times, 45, 50,000 acre
right.
feet.
Well, I think the point is this. Well, actually, there's two. One is, how does that export fee benefit Houston County? It doesn't, is the answer, because they don't have a groundwater conservation district. So there's no collection of an export fee. So when you talk about mitigating the potential impact of this project, yeah, it's easy to point over to the GCD, those counties. But in the case of Houston County that Commissioner Stokes is here representing, they won't derive an economic benefit in terms of an export fee to help deal with the mitigation cost of whatever comes out of this project. And so I cite that as a little bit of an unfairness in the case of Houston County, but also I would submit, and I'm not preaching here, I'm just sharing my feelings, but we've had dozens of people stand up here today and testify, and I synthesize and boil it down to this. They don't want charity. They don't want help re-drilling their well if it runs dry. And listen to the mayor of Chandler back there talk about his woes in his city and municipality. That's not something that's going to be very enticing to them to know that, well, there is potentially maybe some dollars that might help you if you have to re-drill your well. These folks, they're content. And I just think that in terms of looking at mitigating a project of this scope, that when you're talking to folks that I represent, re-drilling a well or mitigating a drop in that aquifer level and them having to deal with that, potentially losing their well, it's not much, it's not satisfying to hear that, well, there may be some help or maybe not. The other thing that I do think that there's probably agreement on, you cited, Mr. McCarthy, that in this case that you didn't intentionally try to hide the ball from the public. There was an application made, I think you said in June of '24, not disputing that. But when nobody knows about it, except for the GCD, and they put it on their website where maybe no one is paying attention, I'm not sure that we've served public notice, and to the extent that we're letting the residents of these counties and the affected area know about this project. And so, I would think, Mr. Chairman, as we start talking about policy decisions and changes that need to be made, at least in the case of export projects for groundwater conservation districts, that there needs to be more notice, widespread public notice given not only through local media, but maybe through the local commissioner's court, city councils, what have you. But we've got to do a better job of notifying the public when there's a massive export project that's in their backyard. For the sake and brevity of our hearing here, I'll stop there, other than to say that this upcoming SOA hearing is obviously it's going to be important, and I recognize, Mr. McCarthy, what the permit that you're applying here for is not a production permit, but the vast majority of folks, outside of evidently one person in Henderson County, they don't want it. And so, again, I just want there to be some mutual respect here. I get what you're trying to do, and certainly you as his attorney, but I also hope there's an appreciation for the citizens that I represent, many that I represent. Senator Nichols represents all of them over there, and Chairman Harris represents the other part of them. They don't want this project. And so I understand you're going to deal with the letter of the law and you're going to do your best, but I also want to be clear up front that I'm not for this project. I will not be for this project. And in terms of looking towards the future and next session, I look forward to working with my colleagues to make sure that, as Representative Bell talks about, that we're striking the balance between private property rights, but also not completely depleting or causing catastrophic harm to folks that are relying on groundwater for whether it's domestic, residential, agriculture, or whatever. So with that, I apologize for my speech there, but I appreciate you listening.
If I might respond, Representative Ashby? Thank you. I appreciate your comments, and it's always good to hear from you and understand your thought process there. Notice that you raise. I believe Dr. Buckley talked about a large project that was going to be in district, in his district, that was coming or was projected that would use a lot of water. I'm not sure we should be making the distinctions between export permits and in-district permits with respect to notice and similar issues. The aquifer doesn't know what happens to the water when it's produced. And you know, we have large, but the state's encouraging large industry to come in. As you're very familiar, just east of here in Taylor, 15,000 acre feet a year for one plant to be replicated 11 times if the project works the way they want it to. That's all going to be in that county. Now, there aren't any districts in that county, okay? But if you're going to have large projects in district, and we haven't said we're going to go out of district, yes. Moving water from where it is to where it isn't is important. I think there are some areas in East Texas where water is needed also. But notice as a benefit to everybody is something we shouldn't distinguish between export and in-district permits.